ಫುಡ್ ಮಾಸ್ಟರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಆಡಿಬಲ್ ಇದೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ತಾನೆ? ಕೋರ್ಟ್ ಆಫೀಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್? ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
ಕೇಳಿಸ್ತಾ ಇದೆ. ಅವಾಗೆಲ್ಲ ಹೇಳಿದೀನಿ ಆಡಿಬಲ್ ಇದೆ ನಿಮ್ದಂತ. ಸಾಹೇಬ್ರು ಬಂದ್ಮೇಲೆ ಅವ್ನು ಇದು ಮಾಡ್ತೀವಿ.
ಖಂಡಿತ ಖಂಡಿತ.
ವಿಡಿಯೋ ಅಸ್ಟೆಂಟ್ ಕಮಿಷನ್ ಕೊಟ್ಟದ್ದು
ಸರ್
26
ಸರ್ ಥ್ಯಾಂಕ್ ಯು. ಓಕೆ, ಲೇಟ್ ಆಗ್ಬೋದಾ ಸಿಟ್ಟಿಂಗು?
Lordship, one matter for end up list, matter pertaining to education matter, my lord.
ಇವತ್ತು ಇದೆಯಾ?
One matter for end up list, matter pertaining to education matter, my lord. Bachelor of Engineering course. Tomorrow is the exam, lordship.
Oh.
2:30.
Yes.
Fresh matter.
Fresh matter.
Hand over all fresh matters.
Plus tomorrow we drop.
Unless you want it to be taken at 2:30.
With your office time permission.
Submission, my lord.
One matter tomorrow. I have filed an application.
ಕೊಡಿ ನಾಳೆ ನೋಡಿ ನಾಳೆ ಅಂತ ನೋಡಿ.
One submission, my lord.
Madam, please
My
wait.
lord.
We are taking memos. Please wait.
Yes, ma'am.
Possession warrant is issued bank recovery matter, 2:30.
My lord, the 2:30, my lord, the transfer matter, my lord.
You know, what is the urgency?
My lord, I'm taking the chap additional superintendent in the Nirashita Kendra, my lord. There is no any standard rules to in superintendent post, the deputation of this superintendent post, my lord. Now the order is passed on, lord. Yeah,
Come tomorrow. Yes,
please.
yes, Kalpana.
My lord, in one of the matter, my lord, my colleague is there to move the matter. In that matter, my lord, ತಾವು ದೀಪಕ್ ಬಿರಾದರ್ಗೆ ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡಿದ್ರಿ, ಬಟ್ ಅವ್ರು ತಗೊಳಲ್ಲ ಅಂತ ಹೇಳಿದ್ರು. ಹಂಗಾಗಿ ಇಷ್ಟು ನೋಟಿಸ್ ಆಗ್ಬೇಕಾಯ್ತು. ಚಂದ್ರಕಲಾ ಅಂತ 20,000 ಅಂತ ಹೇಳಿ.
Yes, ಯಾರ್ಗ್ ತಗೋಬೇಕಾಯ್ತು ನೋಟಿಸು?
ದೀಪಕ್ ಬಿರಾದರ್.
ದೀಪಕ್
Santosh Biradar.
ಬರಾದ್.
Now he is not in penal advocate. That is
ಯಾರು
the issue.
ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು? ವಿಚ್ KSRTC?
Case
ಹೌದು
is-
ಹೌದು ಸರ್.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? KERTC. ನೀವು ಅಪಿಯರ್ ಆಗ್ತೀರಾ? KRTC, Deepak Barad, who appears? There is some KRTC, any KRTC.
Yes, I appear.
ನೀವು ಇದ್ದೀರಾ?
Yes.
ಮತ್ತೆ ಕಾಪಿ ತಗೊಳ್ಳಲ್ಲ ಅಂದ್ರಂತೆ.
ಇಲ್ಲ.
Santosh Biradar ತಗೊಳಲ್ಲ.
Mr. Deepak Barad is directed to accept notice for the respondent. ಇದರಲ್ಲಿ ಬಂದಿಲ್ಲ ಅಲ್ಲ, ಆಯ್ತು ಲಿಸ್ಟ್ ಮಾಡಿ ಡೇಟ್ ಕೊಡಿ.
Saturday.
Initial.
ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ, ಅವ್ರ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
Saturday.
Saturday, Saturday, my lord.
First you hand over a copy, madam, to Mr.
ಅಲ್ಲ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬೇರೆಯವರು ಇದ್ದಾರೆ.
Madam, I please hand over a copy to the advocate on the panel, Mr. Deepak Barad.
Yes, ma'am.
If it comes up on Saturday, we cannot again adjourn the matter.
Yes, ma'am.
Be ready with the matter. Please
Yes,
hand
ma'am.
over a copy.
Yes, ma'am. Yes. Thank you, ma'am.
Serial number 33, my lord.
33.
Respondent in this matter, my lord, the objection is ready, my lord. I'll file, my lord, within 2 days, my lord. Kindly have this matter any next date, my lord. 33.
Is this the first time it is coming up?
My lord, the second time it is coming.
Then how many times more adjournment should be given?
Initially, my lord, matter was filed before, my lord, Bangalore principal bench. Thereafter, my lord,
That's
matter was
okay, but
transferred.
if it has been listed on the last date, how many more adjournments you want?
My lord, finally, my lord, 2 days accommodation. My lord. Kindly have this matter on Monday, my lord. By that time, I'll file objection.
Turn counsel for the respond number 9 time as a last chance list on.
Your Lordship, in serial 36, my lord, I was asked to file for statement of objections, my lord, since respondent 8, there's a bereavement in the family of respondent 8 to 11, my lord. They could
Huh?
not, there's a bereavement in the family of 8 to 11, my lord. They could not come, my lord, any date next week.
Who are you?
I am for respondent 8 to 11, my lord.
Correct, are you a private party?
Yes, my lord, private party, and I was asked to file statement of objections.
That is right, we can't go on granting adjournments, mister.
They could,
That's a government, ಇದು ಇದಲ್ಲ, state ಇದಾರಲ್ಲ.
due to bereavement
hear
in
them.
the family, I could not,
That is okay, let us hear the concerned panel advocate. You have formed sites in the
Contested-
area reserved for park.
no, my lord. I was allotted in the, my business shops were across
Whatever
for
it is.
road widening and.
Allegation is that plots are formed in the area reserved for
And-
park.
And OS was filed, my lord, RS filed and RS.
Consider, yes, next, correct.
My lord, serial number 38, my lord, I am from petitioner. 2 weeks time, my lord.
Current counsel for the petition seeks time list on. ಯಾಕ್ರಿ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತೀರ? I don't know why all lawyers take adjournment in all this matter. I don't know why. Why you take adjournment if the matter is listed? ಅದೇನೋ ready ಮಾಡಿ argument ಮಾಡಿ take a decision. 2021 petitions, ಏನಪ್ಪ? Yes, correct.
Lordship, in serial number 60, the matters being infectious, my lord, examination.
The learned counsel for the petitioner, Mr. Shivasharan Reddy, submits that the writ petition has become infructuous. Submission is noted and the petition is dismissed as having become infructuous.
Lord,
Bill number 73.
Uh,
The petitioner is kindly 1 week's time out.
Why?
Lordship, ಇದು
Learned
instruction
counsel
ಇಲ್ಲ.
for the petition seeks time list on date.
There is no instruction.
Bill number 72, I have to file objections, my lord, it is.
Number
Sounds good.
72, learned counsel for the respondents 2 to 4 seeks time list on date.
serial number 74,
74.
man.
74. ಯಾಕೆ ಹಿರೇಮಠ್ರೆ?
Sir, I am filing application for impleading as one of the respondent.
Learned counsel-
Before I am appearing.
ಇನ್ನ ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿ
ಇವತ್ ನಿನ್ನೆ ರಾತ್ರಿ
No,
ಬಂದ್ ಕೊಟ್ಟಿದ್ದ ಪೇಪರ್ಸ್.
ಹೌದ್ರಿ, ನೀವು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ. How can you come and make a submission? When the matter is called, you come and make a submission.
One kind submission with regard to serial number 74,
Hmm.
but in fact, it's a bottom in the list, my lord.
Huh?
It's in the last in the list, my lord. It's
So
last
what?
but one number, my lord. But it's matter pertaining to mayor and deputy mayor elections, my lord. It is scheduled on Monday only, my lord.
Huh.
It's partly heard, my lord.
You want it to be taken up
Not
out of?
any time at your lord's convenience, my lord, during the course of day.
I think let us,
Senior counsel is appearing in this case.
yes, let us see. Yes, next.
Not accommodation for filing impleading application.
ಅದೇ ಮಂಡೇ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ನೀವು.
ಅಲ್ಲ, Monday elections.
ಎಲೆಕ್ಷನ್ ಮಂಡೇ ಇದೆ ಅಂತ ಅಂದ್ಮೇಲೆ. Yes.
Anytime at lord convenience.
Hmm.
Raise 1 week time.
1 week time is granted to do the needful. K. Ramachandra.
But in this case, earlier Amit Kumar Deshpande was appearing, my lord. Now I undertake to file power for respond number 4 to 6. I'll take instruction and file power for respond number 4 to 6, my lord.
But ನಾವು ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲ ಅಂತಾನೆ.
But only 6 ಗೆ ಅಷ್ಟೇ ಇತ್ತು. Amit Kumar Deshpande was earlier appearing, my lord, senior counsel. Now
Mr. Swanson is that undertakes to appear for the respondent number
4, 5 and 6.
4, 5 and 6.
1 to 3 are government.
Government.
192 not pressed already, my lord.
Huh?
As per memo filed by petitioner, my lord.
The memo filed by the petitioner on 39/2021 is not pressed. The same is noted. Yes, you are ready?
Yes, I am ready.
You are ready? ನೀವು?
But only mandamus ಇದೆ, but instruction ತಗೊಂಡು
ಅಲ್ಲ, ಏನ್ mandamus ಏನು? If it can be
to
disposed
shift
of
the
it-
nala, to shift the nala from from his land to other place and to pay compensation.
Consider whatever
We'll
that has to be
consider,
done.
we'll consider and pass appropriate orders.
Sir, cool. The petitioner or petitioners? The petitioner has sought for a writ in the nature of mandamus to consider his representation dated
At annexure A to Q, Manoj.
Annexure A
A
to
to
Q.
Q.
6/10/2015, 12/4/2016, to 22/11/2016. You should have asked for one document, Mr. 22/2/2017, 7/3/2017, 23/6/2017, 29/8/2017, 7/3/2017, 23/6/2017,
And 18/7/2021, 18/12/2018,
18/12/2018,
and 19/7/2021.
and 19/7/21. Yeah, Ramchandra, you don't apply your mind, is it?
Since 15 years.
You might have done it,
fif-
mister. You could have restricted your request to the latest representation. A to Q. A to Q includes, please have a look at the letters. ಯಾವ್ದೋ ಒಂದು ಸ್ಪಾಟ್ ಪಂಚನಾಮನು ಸೇರಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ. Why you people don't apply your mind is what I'm asking. ಏನು ಯೋಚನೆ ಮಾಡಲ್ವಾ? See, annexure N is some letter issued by the state government. Annexure L is some panchanama drawn by some samakshama kandaya nirikshakaru. Why you people don't apply your mind? ಕೋಣ ಈದಿದೆ ಅಂದ್ರೆ ಕೊಟ್ಟಿಗೆ ಕಟ್ಟು ಅಂದ್ಬಿಡೋದಾ? Please apply your mind, mister. At least a mistake ಆದ್ರೂ when I point out, please consider rectifying it. Please don't repeat this kind of mistakes. To close down the Nala existing in his land bearing survey number 68/3 of Kundunur village, Chittapur Taluk, and to shift it to some other place. The petitioner has also sought for a writ in the nature of mandamus to the respondents to pay compensation of ₹50 lakhs for the loss of for the damage caused to the land and to the crops since 2014 to 21. Next para. The petitioner contends that he is the owner of 4 acres 24 guntas of land in survey number 68/3 of Kundunur village, Chittapur Taluk. Full stop. The respondent number 6 had formed a nala on the western side of the aforesaid land. So the petitioner had several times submitted representations requesting them to shift the nala. Since the sewage water was directly flowing into his land and had spoiled the crops for more than 10 years. The petitioner submits that as per a spot inspection done by the revenue inspector and village accountant of Chittapur, it was revealed that the sewage water was flowing through the nala in the land of the petitioner and had destroyed the fertility of the land. Full stop. The petitioner is therefore before this court seeking for a direction to the respondents to consider the aforesaid representations and close down the nala in his land and also pay compensation. Next para. The learned counsel for the petitioner contended that respondent number 6 has unauthorizedly and illegally formed a nala in his land to discharge the sewage. Full stop. He contended that this has damaged the land of the petitioner and has rendered it unfit for cultivation. Therefore, he submits that the respondents are liable to be directed to close down the nala and to pay compensation. Per contra, the learned counsel for the respondents 4, 5, and 6, learned counsel for the answering respondents 4, 5, and 6 submits that the representations of the petitioners would be considered in accordance with law and suitable remedial action would be taken if it is found that the nala formed in the land of the petitioners is not in accordance with law. Next, in view of the aforesaid submission of the answering respondents, a direction deserves to be issued to the respondents to consider the representations of the petitioner and take suitable steps in accordance with law if it is found that the nala laid in the land of the petitioner is illegal and unauthorized. Full stop. The respondent number 6 shall also quantify the compensation payable to the petitioner for the unauthorized laying of the nala in in his land.
Period may be mentioned.
Within a period of 3 months
3 months.
from the date of receipt of a copy of this order.
Please,
ರಾಮಚಂದ್ರ ಸ್ವಲ್ಪ ಬದಲಾವಣೆ ಆಗ್ಬೇಕು
Please,
ಪ್ಲೀಸ್.
please.
ಇಟ್ಸ್ ರಿಕ್ವೆಸ್ಟ್, ಪರ್ಸನಲ್
Please,
ರಿಕ್ವೆಸ್ಟ್.
please, please,
ಸ್ವಲ್ಪ ಚೇಂಜ್ ಆಗಿ ಸ್ವಲ್ಪ ನೋಡಿ.
please,
ಇನ್ನು ರಿಟ್ ಪಿಟಿಷನ್ ರೆಡಿ ಮಾಡಿದ್ಮೇಲೆ ಪ್ಲೀಸ್ ರಿವ್ಯೂ ದ ಡ್ರಾಫ್ಟ್ ಒನ್ಸ್
please,
ಫೈಲ್ ಮಾಡಕ್ ಮುಂಚೆ.
please.
ಇಟ್ಸ್ ಎ ಪರ್ಸನಲ್ ರಿಕ್ವೆಸ್ಟ್, ಐ ಬೆಗ್ ಯು ವಿತ್ ಫೋಲ್ಡೆಡ್ ಹ್ಯಾಂಡ್ಸ್.
No, please, no, sorry,
ನೀವು ಫೈಲ್ ಮಾಡಕ್ ಮುಂಚೆ ಇನ್ನೊಂದ್ ಸತಿ ನೋಡಿ.
please, no,
ನೀವು ಡ್ರಾಫ್ಟ್ ಮಾಡಿದ ತಕ್ಷಣ ತಗೊಂಡು ಬಿಸಾಕ್ಬೇಡಿ ಫೈಲ್ ಮಾಡೋದಕ್ಕೆ.
please.
my lord, concerned my lord, file wakalat my lord kindly weeks time.
ಹ್ಮ್
Previous government Gopal Krishna Yadav is now is government advocate, so file undertake to file wakalat my lord on behalf of petitioner my lord.
Writ of mandamus.
Mandamus says there.
I have appeared for respondent number 5 and 6.
ಏನ್ ಮಾಡ್ಬೋದು? You want it to be disposed of or not?
It may be disposed of, directing respondents 2 to 4 to consider their representations at
Manager-
A1.
Has
Yes,
filed a writ in the has sought for a writ in the nature of mandamus to direct the response 2 to 4 to consider the representation dated 2/7/2021 and take appropriate action to remove the illegal construction made on the land bearing survey number 321/1, 320/1, situated at Kolhar village, Kamtana Hobli, Bidar Taluk and district. As per the petitioner contends that he is the owner of land bearing survey number 320/1 of Kolhar.
Kolar Village. There is that respondent number 5 and 6 have made some illegal construction, though it is
The
agriculture.
respondents 5 and 6 purportedly are the owners of some portions of the land in survey number 320/1. The petitioner contends that without converting the land for non-agricultural use, the respondents 5 and 6 are using it for non-agricultural purposes. Therefore, the petitioner submitted a representation dated 2/7/2021 to the respondent number 5, 21, to the respondents 1 to 3.
2 to 4.
2 to 4. 2 to 4.
2 to
2 to 4. Full stop. The respondent number 4 issued an endorsement dated 5/7/21 stating that they had not issued any license for putting up construction in the agricultural land and directed the petitioner to approach the concerned Tahsildar of the Taluk. Full stop. The petitioner is therefore before this court seeking for a suitable direction to the respondents to consider his representation dated 2/7/2021 and take suitable action in accordance with law. The learned counsel for the petitioner reiterated the above contentions and claimed that the respondents who have slept over the representation are bound to be directed to consider the same in accordance with law. The learned counsel for the respondent number
5 and 6.
5 and 6 submits that
I have filed statement of
what
objection.
about 1 to 3?
I'll
The
consider.
learned
We'll
AG, the
consider.
learned AG
Reasonable.
submits that the representation of the petition shall be considered in accordance with law and suitable action would be taken if it is warranted.
Yes.
Full stop. In view of the aforesaid submission of the learned AGA, this writ petition is disposed of directing the respondents 1 to 3,
2 to 4.
2 to 4 to consider the representation of the petitioner in accordance with law and if need be, take suitable action if it is warranted in law. The same shall be done within a period of 3 months from the date of receipt of a copy of this order.
My name is
May the order sheet and office is directed to show the name of
Sandeep Patil.
Sandeep Patil. Sandeep Patil.
Sandeep Vijay.
Sandeep
Vijay Kumar.
Sandeep Vijay Kumar Patil.
Please.
Paper publication.
IA 1 of 24 is not pressed by the learned counsel for the petitioner. What about IA 2 of 24?
paper publication, notice to respondent.
IA 2 of 24 is filed by the petitioner to serve the respondent through substituted service by publication in Samyukta Karnataka Kannada Daily, Bidar edition. Full stop, next para. Since the efforts of the court to serve the respondent has proved futile, comma, it is necessary to serve the respondent through substituted service by publication in a newspaper having wide circulation in the place where the respondent is residing. It is stated that Samyukta Karnataka has wide circulation in the place where the respondent is residing, and therefore a request is made for substituted service. Hence, IA 1 of 20, 2 of 24 is allowed. The respondent is ordered to be served through substituted service by publication in Samyukta Karnataka, Bidar edition, showing the date of appearance of the respondent as appearance on thinglu bit kodri. As 24/2/2025, and the publication shall be caused by or before 3rd of February 2025. Yes. Baramagowda, Patil,
Interim stay may be extended.
seat number 4, interim stay is extended till the next. Non-compliance of office objections raised on PF.
I furnished the.
Do it today.
Corrected.
Do it now. Again, no, again mistake is you.
Only furnishing of correct address to the proposal.
Cover with address of unserved proposed respondent and copy of IA to be furnished. Cost list still ನಿಮ್ಮ ಕೈಯಲ್ಲಿ?
Yes, sir.
Cost list still ಇದೆ. Where's the cost list?
It has been downloaded in my mobile.
Huh?
Cell phone download ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ.
ಆಯ್ತು ನಿಮ್ಗೆ ಅದ್ರಲ್ಲಿ ನೋಡ್ಬೇಕಲ್ಲ ಏನಕ್ಕೆ ಬಂದಿದೆ ಅಂತ.
I'll furnish. Do
So
it.
henceforth, if I don't see the lawyers coming with the cost list, I'm going to impose heavy cost.
I'll furnish. I'll furnish.
Lawyers don't carry the cost list. Why should we issue the cost list then?
Aye.
ಅದೇನು ಕೆಟ್ಟ ಹ್ಯಾಬಿಟ್ಗಳು, you don't want to mend. ಸರಿ ಮಾಡ್ಕೊಳಕ್ ಪ್ರಯತ್ನನೇ ಪಡೋದಿಲ್ಲಪ್ಪ.
Sir, do it. I'll furnish.
You don't want to change. ಮೊನ್ನೆನೇ ಹೇಳಿದ್ದೀನಿ ನಾನು. Why should I spoil my mind? Why should I, early in the morning, why should I spoil my mind, mister? Change ಮಾಡ್ಕೊಳ್ಳಿ ದಯವಿಟ್ಟು.
Forthwith I will. Password.
This is called unprofessional behavior. Unfit to be lawyers. If you don't carry the cause list, you're unfit to be a lawyer.
My lord, it was a week's time, my lord.
1 week time is granted to do the needful.
Please.
Ravindra Reddy. Third time. There's no representation. Complaints ಮಾಡಿ.
Yes.
Complaints pass over.
2 days time.
1 week time is granted to do the needful, failing which the petition shall stand dismissed.
Please.
Without reference to bench. Could you then?
Kindly pass over the matter, man.
What is this acceptance of note below the cost title?
My lord,
The note mentioned below the cost title of the writ petition is perused and the same is accepted. List on date, could.
my lord, kindly pass over the matter. My senior
what?
will come and make a submission.
LB ಇರೋದು ಯಾವತ್ತು? Pass over.
Please, my lord.
Serial number 9. Guru Basava Basanna. List after service, list after receipt of trial court records. ಯಾಕೆ ಬಂದಿಲ್ಲ ಎಲೆಕ್ಷನ್ ಪಿಟಿಷನ್ ಮ್ಯಾಟ್ರ್? ಚೆಕ್ ಮಾಡಿಸ್ರಿ ಯಾಕೆ ಬಂದಿಲ್ಲ? ಯಶಸ್ ದೀಕ್ಷಿತ್. ಪಾಸ್ ಓವರ್. Shmi ji. Pass over.
My lords, serial number 11.
Ah.
My lords, this matter is pertaining to the upgradation of classes number for 9 and 10. My lords, I am a
No, you're
petitioner.
supposed to produce some documents indicating the ownership
My
and
lords,
the sanction.
valid plan sanction is submitted, my lords, and the other side, the state government has taken
No,
an.
you're not produce it before the court.
It's part of the
Pass
record.
over. Produce it. I can't adjourn it. Pass over. List after service of notice to the respondent number 2. Entry ಮಾಡಿದ್ದೆ check ಮಾಡಿ. Huh? ಇಲ್ವಾ? Yes, next. See number 13.
I have to amend the car title, man.
ಮಾಡಿದಿರಾ?
ಈಗ ಮಾಡಿ.
Pass over. Pass over.
Lords, in respect of the office subjections, annexure, production of legible copy of annexure B and D, I will do it, Lords, within 3 days, since they have not furnished the legible copy. Now I am able to.
The IA 2 of 25 for correction of interim order.
How, the numbers were wrongly mentioned, Lords. Though I have stated correctly in the petition amendments, while mentioning it, Lords, I have mentioned the numbers which were allotted as per the 2009 list.
Annexure D is stayed anta ide.
How?
What you want to be stayed?
List of beneficiaries.
Huh?
List of beneficiaries.
Beneficiaries.
House allotment.
Lords, in the interim prayer and the prayer, mandamus annexure B and interim prayer, wrongly I have mentioned the house numbers, Lords, where they are residing. Though I have stated correctly in para 4 of writ petition.
No, you sought for some interim prayer of stay of all further proceedings pursuant to the meeting notice dated 15/11/24. ಯಾವ್ದ್ರಿ?
ಇಲ್ಲ ಬೇರೆ.
Writ petition copy ಕೊಡಿ.
What is the interim order?
Interim order in respect of the numbers only.
1 minute.
Whatever you sought for, it is granted.
ಇಲ್ಲ, I agree, Lords. There is some mistake on my part too.
Number of mistake.
Because 2009 list says these
Can you
numbers.
correct it? File an application for.
I have filed both the application. And I have mentioned.
IA
My lord, I have got some objections, my lord. I have filed, my lord, impleading application on behalf of beneficiaries who are allotted
Do you have
land.
any
under the list.
objection for this IA for 3 of 24 for
Our
amendment?
Yes, my lord, we are
application
already put in possession. May I request my impleading?
You might have the best case on merits.
Yes,
You have any objection for amendment?
amendment, no.
ಯಾವಾಗ ಅರುಣ್ ಕುಮಾರ್?
ಅದು ಆ beneficiaries ನ ಪಾರ್ಟಿ ಮಾಡ್ಲಾರ್ದೆ ಎಂಟ್ರಿ ಮಾಡಿರ್ತೀವಿ.
ಆಯ್ತಪ್ಪ. By this amendment, if some other properties are included, by this amendment,
Please.
if some other properties are sought to be included, whether the owners of all those properties are made parties in the writ petition. Amendment allow ಆದ್ರೆ
Yes,
ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಇನ್ಕ್ಲೂಡ್ ಆಗುತ್ತೆ.
please.
ಆ ಪ್ರಾಪರ್ಟೀಸ್ ನ ಓನರ್ಸ್ ಈ ಕೇಸಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿದಾರಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ಅವ್ರು ನಮ್ಗೆ ಲೀಸ್ಟ್ ಗೊತ್ತಿಲ್ಲ. What is the case is that, my lords, there was a list prepared in the year 2009. Due to the flood, my lords, the entire village was shifted to some other place. There were 154 houses were granted. The list was prepared in the year 2009 itself.
Whether any of these houses were allotted to anybody?
No, my lords, now they are saying we are.
May I request for a moment, my lord, my impleading application, I have produced all akkupatras issued in favor of.
Impleading application illiದೆ. Any objection for impleading application? Let them come on record.
Let them come on record, my lords. Whole
Hold.
my case is that, my lords.
IA 3 of 25 is filed for amendment of the interim prayers sought for in the writ petition. Full stop. The petitioner contends that the particulars of the houses which are the subject matter of particulars of the houses which was houses that were set apart by the respondents for allotment was wrongly mentioned while claiming while seeking the interim order. Therefore, this application is filed to correct the interim prayer. Full stop. Though the learned counsel for the proposed respondents objected, since the amendment is for an innocuous relief, comma, the same is allowed. Counsel for the petitioner is directed to make appropriate corrections in prayer number 20, paragraph number 25 of the writ petition. Full stop. IA 2 of 25 shall be considered after the writ petition is amended. Next, IA 1 of 25 is filed by the proposed respondents to come on record in this writ petition. They all contend that the houses the houses which are the subject matter of this writ petition were allotted by the respondents 3 and 4 to the proposed respondents, and therefore any order that may be passed in this writ petition would directly affect them. Full stop. The learned counsel for the petitioner, though opposed this application, since the proposed respondents claim that houses which are the subject matter of this writ petition are allotted to them, they are necessary parties, and without hearing them, no orders can be passed. Hence, IA 1 of 25 is allowed. The counsel for the petitioner is directed to amend the writ petition. Yes.
That's Monday. Because
Whatever date you want. LB matters ಯಾವತ್ತಿದೆಯೋ ಅದು ತಗೊಳ್ಳಿ.
since there is an IA pending for me also, because the houses they were residing.
Correction ಮಾಡಿ I will consider.
I will do it today.
ಮಾಡಿ.
And one submission in this matter, last time only I made a submission. What has happened was 154 houses were allotted in the year 2009. The list was prepared. Beneficiaries' names were mentioned. That list was never implemented. Then some of these petitioners, particularly these petitioners, were lost their houses, but they don't have any houses for residing at that time. They started automatically, they occupied some houses and started residing therein. Thereafter, in the year 2018, they alleged that there was a survey was conducted, and thereafter fresh houses were allotted. Now the whole problem is, my lords, out of 154, 109 houses were allotted. Now, due to the after 9 to 10 years, some they're not always in the village.
We can't grant any interim order permit.
No, I'm not saying interim order, my lords. What I'm seeking is the deputy commissioner also last time your lordships orally directed to verify that why the other houses, 154 houses were not built even after 10 to 15 years.
Yes, government.
The officials are today, they are came to the office.
Yeah.
They communicated.
Please file your report, whatever, by
Please.
next Thursday.
First.
Thursday, yes.
Please.
List after service of notice to respondents 4 to 6. Is there non-taking of hand summons?
My lord, respondent 4 is Siddheshwar Bank, my lord, is one.
Sangan
brother appearing for respondent number 4, my lord.
Mr. Sangan Gowda Biradar.
Please, my lord.
Mr. Sangan Gowda Biradar is directed to accept notice for respondent number 4. What about 5 and 6?
5 and 6, my lord.
You have summons ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ?
Hand summons are
ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ? ನೀವು ತಾನೇ ಕೇಳಿದ್ದು hand summons.
I will take some hand summons.
The office is directed to reissue hand summons to the respondent number 5 and 6, failing which within 1 week, failing which the petitioner shall take out proper service of notice to the respondent number 5 and 6.
14, there is an interim order. 14.
ಯಾವುದು?
Earlier, 14 minutes. Interim order was there.
First correction amendment ಮಾಡಿ.
ಕೆಲವೊಂದು ಪ್ರಾಪರ್ಟೀಸ್ ಕರೆಕ್ಟ್ ಆಗಿದಾವೆ. ಅದ್ರ ಬಗ್ಗೆ ಇಂಟೀರಿಯರ್ ಆರ್ಡರ್ which was earlier granted.
Interim order granted is extended till the next. Yes.
My lord, in this case, my lord, Honorable Court directed me to secure instruction when notice was served on President, my lord.
R4, yaar R4 yaar. R4.
PDO, my lord.
Panchayat Development Officer, Sindhigi. Yaar, Sindhigi yaar. Ratna Shivayi is directed to accept notice for respondent number 4. Yes. ಏನು ಮಾಡ್ಬೇಕು?
My lord,
Please serve a copy to her. Learned counsel for the petition is directed to serve a complete
Last
set of the writ petition
last
to
occasion,
Srimati
last-
Ratna
My last
Shiva.
has directed to secure the records to the government, madam.
Yaarge?
Yes.
Government.
When was notice served on present matter?
Yearly.
It is served on 17/12, man.
17?
12.
What is the date of notice?
16/12.
16/12.
No, 17/12 notice, same day it has served
What is the meeting notice date?
on 3/1/2025.
3/1/25.
Yes.
Yes, Mr. Annaraya.
Notice served on 23, my lord.
No, man.
Put it.
On the last occasion, they were supposed to give the date of service.
They have given.
It is served on 17/12 according to them.
Yes, madam. They have also sent RPD also subsequent.
Yes. Barcode. Yes, anything? You want to say something? Anything?
Yes, my lord, they themselves, my lord, I have the documents to show, my lord, that they have served on 21st.
What are the documents?
Lord, my colleague will hand over, my lord.
Put it at the end.
They have sent register post also. They are producing register post copy, madam.
Yes, Mr. What is there to show it was served on 21/12?
Lord, I'm showing, Lord.
My lord, I have
Mura one.
memo along with documents.
Memo ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೊಡ್ರಿ ಇಲ್ಲಿ.
But last time they themselves made the submission, Lord. That Lordship may take the additional documents which were filed.
No, but what is there to show it was served on 21st?
Lord, I have produced the, Lord, the copy of the envelope. Lord.
Envelope ಇಲ್ರಿ ಇದೆ.
And postal record also is there, my lord, which shows it's served on 23rd.
933. 933.
VK ಕೊಟ್ಟಿದ್ದು ಕೊಡಿ ಇಲ್ಲಿ. VK ಕೊಟ್ಟಿದ್ದು ಕೊಡ್ರಿ ಇಲ್ಲಿ. AG ಕೊಟ್ರಲ್ಲ ಒಂದು ಲೆಟರ್ ಎಲ್ಲಿ ಇದೆ? Yes, Mr. If it is served by hand, where's the question of service by through
They
RPD?
themselves have made the submission on the last occasion that they have drawn a Panchanama, my lord, on 19th. My lord.
No. See, you have produced some envelope.
Yes.
But the AGA says that it was served by hand.
Yes, by hand, and they have made a Panchanama on the 19th.
Huh?
My lord.
19th.
There are two cases. 931, it is served in time, my lord. 933, it is different. They are submitting on 933, my lord.
We are dealing with WP number 203931 of 2024.
931, very well. That is Sanjan Gowda.
31.
Yes, sir.
This is Santosh.
Santosh Changonda.
Yes.
It is
Lord,
Arna.
your lordship can have this tomorrow, my lord.
Huh?
What they are submitting now, if your lordship has this tomorrow, I will take instruction. Because according to me, the instruction are.
But when is the meeting?
My
The
lord,
meeting
it
is
is
state
over already.
It's already over, man.
No. The, my lord, no confidence meeting is over. It has been passed, my lord. Now,
So it's
the
all right,
election,
then we have to.
the election to this new Adhyaksha and Upadhyaksha has been stayed. So I'm only requesting for 1 day's time so that I can take instruction and submit to your lordship. In each of
on
the
Saturday. List on
But can it be
Saturday.
Friday, my lord? Your lordship can have it Friday.
Friday, we have other matters. We fixed other matters on Friday. Saturday.
Very-
Saturday is a working day.
I know.
Why should lawyers have all the pleasure? ನೀವು ಬನ್ನಿ ಕೋರ್ಟ್ಗೆ ನಾವು ಬರ್ತಿದ್ದೀವಲ್ಲ.
ಬರ್ತೀವಿ.
ಹಾ. ಸಚಿನ್ ಅಂಗಡಿ. ಸಚಿನ್ ಅಂಗಡಿ.
My lord,
ಹಾ.
serial number 17, my lord.
Yes.
My lord, in this case, my lord,
Yes, what you want to do? You're not paid the process.
my lord, in this case, my lord, the respondent has issued the no confidence motion, my lord, as per Annex A, my lord.
Yes, what is your argument?
And my lord, Annex A, my lord, there is no allegation against the
Then what else? No allegation, then? No allegation, and next,
yes, my lord.
what else?
As per Annex A, my lord, may I read, my lord?
Yes. Yes, go on.
And my lord, my lord, on 6/1/2025, no confidence motion held.
Successfully held.
Yes.
Petition become instructional.
Barkol. The petitioner.
My lord, and my lord, my lord, in this matter, my lord, what happened, my lord? The no confidence motion request has given by the respondent number 5 to 20, my lord, before the authority, my lord.
Yes.
On 10/12/2024, my lord.
Yes.
And the assistant commissioner has issued the notice on 20/12/2024, my lord.
Yes.
They are not waited for 10 days, my lord. And they are issued the notice, my lord. This is a gross violation, my lord.
Yes.
And
10 days
without an allegation, my lord, in the no confidence motion, my lord, they are moved the no confidence motion, my lord.
Yes. Ashtena? Is that all? Full bench judgment. Barkol. The petitioner.
Is violates the president's rights, my lord.
Is the petitioner, comma, a
And
president
the
of
president is continuously developed
Gram Panchayat.
developed in the
Juvenile village is before this court challenging a notice dated 20/12/2024
more the
issued by the
no
respondent number
confidence
4,
motion, my lord.
convening a meeting on 6/1/2025, convening a meeting of the members of the Panchayat on 6/1/2025 to consider a motion of no confidence. Next para. The petitioner contends that he was elected as the president of the Panchayat and later Panchayat and had implemented several development works. Full stop. Nonetheless, a few dissatisfied members of the Panchayat submitted a representation dated 10/12/2024 with the respondent number 4 in form number 1 as prescribed under Rule 3(1) of the Karnataka Panchayat Raj motion of no confidence against Adhyaksha and Upadhyaksha (bracket close) rules 1994. Full stop. The respondent number 4, in compliance with Rule 3(2) of the aforesaid rules, issued a notice dated 20/12/2024, convening a meeting of the members of the Panchayat on 6/1/25 to consider the motion of no confidence. Being agreed by the said notice, petitioner is before this court. Full stop. The learned counsel for the petitioner contended that the no confidence motion submitted by the members of the Panchayat was not based on any allegation. And the respondent number 4, without respondent number 4 had issued the notice after 10 days from the date of submission of the representation by the members in form number 1. It therefore contends that this was in violation of Rule 3(1) of the rules 1994. Full stop. Next para. This court had granted an interim order stating that the proceedings of the no confidence motion on 6/1/2025 shall be subject to the result of this writ petition. Next para. The learned AGA submitted that in view of the judgment of the division bench of this court in Lakshmamma, the members of the Panchayat are not prevented by filing form number 1 expressing lack of confidence in the president. And if such a representation is filed, the respondent number 4 is bound to act in accordance with Rule 3(2) of the rules 1994. He submits that it is not necessary that the members have to make allegations against the president to move a notice of no confidence. He also submits that the representation was filed on, representation form number 1 was filed on 10/12/2024. And the notice was issued by the respondent number 4 on 20/12/2024, which is well within 10 days prescribed under Rule 3(1) of the rules 1994. Therefore, he contends that on both the contentions, raised by the petitioner are liable to be rejected. Full stop. In support of this contention, that the 10-day period is 10-day period prescribed in Rule 3(1), in Section 49, the Act of 1993, is mandatory, he relied upon the judgment of the full bench of this court in ILR 2022 Karnataka 3691. Next, I consider submissions of the learned counsel for the petitioner. The learned counsel for the private respondent supported the contention of the learned AGA. Next para. I will consider submission of the learned counsel for the petitioner and the learned counsel and the learned AGA as well as the learned counsel for the private respondents. Next para. A motion of no confidence can be moved by the members of a Panchayat either under Section 49(1) or under Section 49(2) of the Act of 1993. However, rules are not framed by the state government to consider a notice of no confidence under Section 49(2) of the Act 1993. A division bench of this court, while considering the question whether a notice of no confidence based on allegation could be proceeded with, held that in the absence of rules framed by the state government, no proceedings under Section 49(2) could be taken out. However, it held that even if a representation is filed by the members expressing lack of confidence in the president or vice president, based on certain allegations, comma, said representation should be considered as one filed under section 49(1) of the Act 1993. Full stop. Therefore, the contention of the learned counsel for the petitioner that the representation filed by the private respondents in form number 1 did not contain any allegation is liable to be rejected as the representation conformed to section 49(1) of the Act 1993. Full stop. Insofar as the contention that the notice dated 20th of December 2024 was beyond the 10-day prescribed under section 49 of the Act, comma, it is relevant to notice that the members had submitted form number 1 on 10/12/2024 and the notice was issued by the respondent number 4 on 20/12/2024, which was well within the 10-day period prescribed under section 49 of the Act 1993. Therefore, both grounds urged by the learned counsel for the petitioner do not merit consideration. Consequently, the writ petition is dismissed. Sudarshan,
Waiting service for R3.
ಏನು R3 ಯಾರು?
Is the contestant.
My lord, I'm appealing for the respondent number 3 in this case, my lord. I'll undertake to file the wakalat, my lord. Today I have received the instruction, my lord, and I'll file, my lord.
What's your
File
name?
my wakalat. Shilpa Rani, my lord.
Shilpa M.
Shilpa Rani, my lord.
Shilpa Rani, Mrs.
Please,
Shilpa
my lord.
Rani undertakes to appear for respondent number 3. Office is directed to show her name in the cause list. List on
Any date, my lord. Meanwhile, I'll file my objection and vacating stay
List on
application
date
also, my lord.
Interim order.
29th.
Interim
Please, my
order.
lord.
Interim order granted release extended to the next date. Gaurish Kashampur.
Daytime.
Much obliged.
Daytime.
And R2 6 to 8 ಯಾರು?
ಅದು cooperative registrar and ARCS ಇದೆ sir. I want to take a notice, ma'am. And returning officer. Today only, I think, a daytime.
Process katti.
Please.
Learned counsel for the petitioner undertakes to pay the process during the course of the day. If process is paid and is in order, office is directed to issue notice to the respondents 2, 6 to 8.
Grateful.
K. Ramchandra.
My submission with regard to office objection number 22 is that the respondents not issued the acknowledgement of annexure e-mailer. The complaint, the representation submitted by the petitioner mailer.
Annexure E receiving acknowledged. Then annexure E.
Representation mailer to take action against the PDO and president of the Agapur Gram Panchayat who misutilized the
Office objection at seal number 22 is overruled by accepting the submission of the learned counsel for the petitioner that the respondents have not issued any acknowledgement. Acknowledging the receipt of annexure E. Full stop issue. AG is directed to accept notice for respondents 1, 2, 3. Illa Panchayat Kalaburagi. Rupa Sagar Patil for response 4 and 5. Counsel for the petitioner is directed to serve copies of the writ petition to the learned counsel for the respondents.
Please.
What? Arun Kumar,
Yes. Yesterday's matter.
1 week.
Yesterday's matter.
Again, yesterday's.
It is with regard to performing of permission to conduct Urus and Sandal.
Yes. Who was-
Other day lordship has pointed out one under the reference at annexure H, J, my lord,
Annexure?
J.
Hmm.
There, my lord,
My lord, as per
Government.
annexure C, this is a self-formed committee. And the committee says that as per annexure D, notice is issued to the WUB board. That is
Annexure
not.
C is a self-styled committee.
Yes, ma'am.
Annexure C.
Yes. And as per section,
ಒಂದು ನಿಮಿಷ ತಾಳಿ annexure C ಯಾವುದು?
annexure C is a resolution.
This is a self-styled committee.
self-formed committee by the
Ah.
petitioners.
Ah.
And as per section 18 of the WUF Act, the committee has to be constituted by the board, WUF board. It is
No,
not
but
a.
there's some, please come to annexure J.
Yes, my lord. In fact.
Please read the fourth sentence. ಮುಂದುವರೆದು ಸದರಿ
ಮುಂದುವರೆದು ಸದರಿ ವಕ್ಫ್ ಸಂಸ್ಥೆ ಮುತವಲ್ಲಿ ನೇಮಕಾತಿ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖವಾದ ಅನ್ವಯ ಸೂಕ್ತ ಕ್ರಮದ ಆದೇಶ ಕುರಿತು ಸೂಚನೆಯನ್ನು ಮಾನ್ಯ ಮುಖ್ಯ ಕಾರ್ಯನಿರ್ವಾಹಕಾಧಿಕಾರಿ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕ್ಫ್ ಮಂಡಳಿ ಬೆಂಗಳೂರು ನೀಡಲಾಗಿರುತ್ತದೆ.
Where is that?
ಇಲ್ಲ, this has been forwarded to the respond number 1. That is under consideration, my lord.
What is that?
My lord, as per annexure.
ಸೂಚನೆಯನ್ನು. What is that ಸೂಚನೆ? ಸೂಕ್ತ ಕ್ರಮಗಳನ್ನು ಆದೇಶದ ಕುರಿತ ಸೂಚನೆಯನ್ನು
Writ petition was filed, my lord, as per annexure F, wherein the direction is issued in page number 34. Para 5, in view of the aforesaid facts and circumstances, rival submission, response 2 and 3 are hereby directed to address the grievance of the petitioner and consider his representation so and pass appropriate orders, take appropriate steps in accordance with law within a period of 6 months. This application is pending before the respond number 1, that is the work tribunal at Bangalore, my lord. Meanwhile, the respondents, after coming to know about this, they filed annexure F1 in page number 36, objecting for appointing this person as Mutwalli. And they also filed an application that they have formed a committee. In fact, as per section 16, the section 17 of the WAF Act, 18, my lord, 18 of the WAF Act, committee has to be formed by the board.
Yes.
It's not that they themselves form a committee and say that we are the committee members.
My lord, I am not on that. Even otherwise, my lord, may I request for a moment, annexure A?
One more submission.
They
my lord.
suffered an order.
One more submission, as per my instructions, they are in the process of appointing administrator. Otherwise, the work officer is in charge of the this property, my lord, work property, and as per his instruction, ಇದು ಊರ್ಸ್ ಅಂದ್ರೆ ಸುಮ್ನೆ ನಮ್ದು ಹೆಂಗ್ ಜಾತ್ರೆ ಇರುತ್ತೆ ಆ ಟೈಪ್ ಪೀಪಲ್ ವಿಲ್ ಕಮ್ ಅಂಡ್ ದೇ ಆಫರ್ ಅಂಡ್ ದೇ ಗೋ ಇಟ್. Only supervision has to be done. That will be done by the WAF officer. If the court directs, the Tahsildar can also assist them.
Yes. Let nobody do it. Let the WAF officer do it.
My lord, offering of Sandal is different, my lord. Urus Jatra is different. Sandal, my lord, will takes place from the house of petitioner number 2. As my lord, however, my lord, opponent is also taking part in the said process.
Please tell us what is your right.
My right, my lord, my right under annexure A, my lord. May I request?
Annexure A.
Annexure A, page 17. There, my lord, after the Waqf institution was managed by, my lord, initially by the administrator. There is categorical findings and directions issued to, my lord, the board to constitute managing committee within 2 months. Page 17, my lord.
Yes.
Accordingly, we, my lord, we are the devotees who is having interest in the Waqf institution. We issued notices to all devotees and conducted, my lord, meetings under information to district Waqf officer.
No, what is
And
this
we
order? Please wait. What is this order? Annexure A ಆದ್ಮೇಲೆ ಏನಾಗಿದೆ?
Annexure A is challenged before this court. Before
what
this court, annexure B.
What
It is upheld. That order is upheld by this court. And thereafter,
Qadri. Syed Yunus Qadri ಅಂದ್ರೆ ಯಾರು?
ಅದು administrator, my lord.
He is the administrator.
He was administrator.
So what happened to that writ petition?
It was dismissed.
It was dismissed.
Yes.
Then what happened?
Then, my lord, the annexure is C, my lord, meetings were held. In a meeting, my lord, a decision has taken to resolving the petitioner number 1 as a president of managing committee.
Who are you to do this meeting?
Yes, it is, my lord, pursuant to the directions itself.
ಎಲ್ಲಿದೆ?
Annexure A,
ಎಲ್ಲಿದೆ ಓದಿ?
It's of 2019,
page 17.
my lord.
Previous also, my lord, I was ex-president of, my lord, managing
Please
committee.
read annexure A, direction ಏನಿದೆ?
Direction number 3, my lord. May I read?
Yes, please.
Appeal allowed. The Chief Executive Officer, Karnataka State Board of Work, to change the administrator within 7 days from the date of receipt of this order and appoint a neutral person unconnected with the work matter as administrator. Approve the new bylaws within 2 weeks from the date of these orders. To constitute managing committee within 2 months after conducting general body meeting as per approved bylaw.
So therefore, the chief executive officer has to constitute the managing committee.
Yes.
Alva?
Now, what I have done is, my lord,
we conducted meeting and we passed, my lord, a resolution. The same is forwarded to, my lord, respondent number 2. In turn, my lord, he has to place that proposal before respondent number 1. He is failing in his duty.
Yaro chief executive officer.
He has to place, my lord. That is district work officer.
No.
He has to place it.
No. Annexure A prakara.
Yes.
Chief executive officer had to do two things.
Yes.
One is appoint a neutral person.
Yes.
And approve the bylaws.
Yes.
And to constitute a managing committee.
Yes.
Has he constituted a managing committee? Has he?
Previous, my lord, it was constituted.
After annexure A.
Yes, ma'am. Yes.
Whether the chief executive officer constituted a managing committee.
Yes, my lord, it was constituted.
Ellide.
It was constituted.
Page number 36, last paragraph.
You have read it. Yes. Where is it constituted?
Please. It was for a period of 11 months, my lord, earlier. Yes, yes.
Let me understand your case. You are not helping me understand your case.
I lie.
Will the constitute agirudu?
That they are not produced.
What is there to show that committee is constituted?
36, page number 36, last para, their own representation. After passing of the order of Honorable Secretary on 19/10/2020, the board had approved scheme of management on 26/2/21, and thereafter work officer Raichur Karnataka had constituted regular managing committee in the above said work institution. Subsequently, general body members have called.
So, ನೀವೇ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ.
No, it is with the devotees of my lord Dargah.
You might be the devotee. It's a Waqf institution. It is under the control of the chief executive officer. He has to decide who should be the committee.
Yes, my lord, I am not on that, my lord. Even my writ petition to that effect is pending, my lord. Other day, lordship has ordered notice, and he only, my lord, is appearing on behalf of respondent.
Therefore, unless you have been appointed.
All that, my lord, as an interim arrangement, my lord. That was already done previous year, my lord. May I request, my lord?
Previous year.
Annexure H, my lord.
Let the Waqf officer do it.
Yes.
Allah, he can't, my lord. It is a religious activities.
Why he can't?
It is religious activities.
He will decide who shall be involved.
District work officer is not competent authority, my lord.
Who else is the competent?
It is, my lord, chief executive alone again.
The chief executive officer.
Executive
himself.
Tahsildar and
my lord Urusan
led the chief executive officer Tahsildar along with the WAF officer will be directed to.
When, my lord, they have done it previous year.
No, the problem is this.
Yes.
There might be one committee, there might be 100 committees. There might be one person who claims to be the Muttaballi, another person claiming to be the Muttaballi. We do not know.
Yes.
So unless that is resolved, let these officials conduct.
Law officials, my lord, it is a religious activity. Again, my lord, it hurts the feelings of, my lord, many devotees.
And it hurts many things.
Allah.
What can be
Sandal. My lord, directions of this nature would meet sense of justice, that's all.
What?
My lord, in
Even when opponent, my lord, is
No.
participating, what I don't know,
See,
what
if I allow
objections,
you
my
to-
lord.
If I allow you to conduct this Andal, it will be giving a stamp of approval to your constitution.
Even opponent may also take part, my lord. That is what, my lord, that was
the
done.
opponent?
Yes, my lord.
Who is the opponent here?
Who is, my lord, claiming rival rights on the.
ಅದಕ್ಕೆ ನೀವು ಬೇಡ ಅವರು ಬೇಡ ಅವ್ರು ಮಾಡ್ಲಿ ಅಷ್ಟೇ ಬರ್ಕೊಳ್ರಿ. The petitioners claiming to be members of a committee constituted to administer the Waqf have filed this petition challenging an endorsement bearing number so-and-so dated 21/1/2025, bracket annexure J issued by the respondent number 2. They also seek for such other remedy as may be necessary in the facts and circumstances of the case. Next para. The petitioners contend that Dargah Hazrat Sheikh Fariduddin Mansuri, bracket Sunni, bracket, comma, bracket close Manvi, is a notified Waqf. Full stop. They contend that The petitioner number 1, being the president of an erstwhile committee of management, questioned the act of the respondent number 1 appointing an administrator by filing appropriate proceedings before the Secretary to the Government of Karnataka, Department of Minority Welfare, Bengaluru. The Secretary, in terms of the order dated 19/10/2019, directed the Chief Executive Officer of the Waqf Board to appoint an independent person as an administrator, approve the new bylaws and also constitute a managing committee within 2 months after conducting a general body of the members as per the approved bylaws. They contend that this order was challenged by the administrator who was then in office in WP number 205212 of 2019. Full stop. The said writ petition was dismissed in terms of the order dated 19/6/2024, paving PAVING, paving way for the Chief Executive Officer to take steps as directed by the Secretary, Department of Minority Welfare. Full stop. The petitioners contend that a notice convening the general body was issued to all the members and a meeting was held on 2/8/24, 9/8/24, 16/8/24. Whereat it was unanimously resolved to elect the office bearers of the managing committee of the Waqf. Full stop. The petitioner number 1 was elected as the president and a managing committee was duly constituted. Full stop. They contend that the petitioner number 1 invited the respondent number 2 to take part in the meetings of the managing committee, but the respondent number failed to do so. Respondent number 2 failed to do so. Full stop. The petitioners contend that after the members of the managing committee were elected, the same was sent along with a copy of resolution to the respondent number 2 for necessary approval and renewal. The respondent number 2 did not forward it to the respondent number 1. Full stop. Therefore, the petitioners being aggrieved by the inaction on the part of the respondents number 2 in failing to forward their proposal to the respondent number 1, filed WP number 200134 of 2025, where this court has issued notice to the parties. Full stop. The petitioners contend that the dispute regarding the entitlement to continue as the managing committee is pending consideration before the respondent authorities. They contend that in the past, the urus in the dargah would be held between 25/125 and 27/125. Full stop. They contend that in the previous year, that is during January 2024, a similar situation arose and the devotees, including the petitioners, approached the respondent number 2 seeking permission to celebrate the urus and offering sandal. The respondent number 2 granted permission permitting the petitioners herein and one Syed Idris Qadri Saab to perform urus and sandal. Therefore, the petitioners contend that even this year too, the same procedure has to be followed. The petitioners should be granted permission to perform sandal and urus. The petitioners are therefore before this court Full stop. The petitioners contend that the respondent number 2 has issued the impugned endorsement rejecting the request of the petitioners to conduct Urus and Sandal. Next paragraph. Full stop. The petitioners are therefore before this court. Next paragraph. The learned counsel for the petitioners contend that the petitioners are lawfully elected members of the managing committee at a general body of the members of the Waqf. He therefore contends that the petitioners have a better right to perform Urus and Sandal and offer Sandal. He also contends that even in the past, the petitioners were authorized to perform Urus and Sandal, and therefore there can be no difficulty in the petitioners being permitted to continue the said tradition. However, the learned counsel for the respondent number 2 submits that the petitioners are members of a self-styled committee, as the chief executive officer of the Waqf board has not constituted the committee as per section 18 of the Waqf Act 1995 and as per the directions of the Secretary, Department of Minority Welfare. He therefore contends that the petitioners have no locus standi to assert that they are members of a managing committee, and therefore they cannot compel that they should be permitted to perform Urus and Sandal and offer Sandal. Full stop. He contends that in administrator upon Madidiri,
They are in the process, man.
so contends that as per the order of the
Moreover,
Secretary,
this writ petition was filed, which is
as per the order of the Secretary, Department of Minority Welfare, steps are being taken for appointment of an independent person as an administrator. He further submits that there are infighting between the petitioners and other members of the Waqf of the institution, claiming hegemony, 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 in matters of administering the Waqf, and therefore, allowing the petitioners to perform Urus and offer Sandal would result in an awkward situation and a likely law and order problem. Therefore, he contends that the chief executive officer, along with the district Waqf officer and the Tahsildar of Manvi Taluka, of Manvi Taluk, would perform the Urus and offer Sandal,
would supervise.
and also supervise the religious activities. Full stop. Next para. I consider the submissions of the learned counsel for the petitioners and the learned counsel for the respondents 1 and 2. Next para. A perusal of the order passed by the Secretary to the Department of Minority Welfare dated 19/10/2019 shows that an administrator was appointed, was ordered to be removed, and a neutral person was directed to be appointed as an administrator. The chief executive officer of the Waqf board was directed to constitute a committee within 2 months after conducting a meeting of the general body. Full stop. This order was challenged before this court in WP number 205212 of 2019. And the said writ petition came up for consideration only on 19/6/2024. Full stop. This court, in terms of the order dated 19/6/24, dismissed the petition, paving the way for the chief executive officer to take steps as per the order passed by the Secretary, Department of Minority Welfare. Full stop. Since the chief executive officer has not constituted a committee of management of the Waqf, it appears that the petitioners themselves have constituted a committee of management and have staked their claim to perform Urus and offer Sandal. Full stop. In matters of this nature, it is the chief executive officer who alone is entitled to constitute a committee of management in respect of a notified Waqf under section 18 of the Act 1995. Therefore, the petitioners being self-styled office bearers, petitioners being self-styled office bearers of a committee of management, cannot lay claim to perform any religious activities in the institution. Therefore, the respondent number 2 was justified in rejecting the request of the petitioners permission to conduct the Urs and offer Sandal. Full stop. Hence, there is no need to interfere with the order passed by the respondent number 2, which is impugned in this petition. Next para. Since the learned counsel submits that all steps are taken for performance of Urus and Sandal and offering of Sandal, the same shall be done by the Chief Executive Officer along with the District Waqf Officer with the help of the Tahsildar of Manvi Taluk. And they shall ensure the peaceful conduct of the religious activities in the institution.
Observation made, my lord,
Any
cannot come
observation
in the
made-
way of,
Any observation made in this petition shall not come in the way of considering any other case on merits.
claim of petitioners.
Huh?
Claim of petitioners.
Will not come in the way of the claim of petitions.
Claim of petitioners, my lord, that they are duly constituted managing committee.
Sir, ಎಲ್ಲಿದ್ದಾರೆ ನೀವು?
ಇದೆ.
How you have been constituted?
My lord, it has to be approved by the chief executive alone. Yeah.
Correct. Where is it approved is what I am asking. ಎಲ್ಲಿ approve ಆಗಿದೆ?
Allah, it is, proposal is sent, my lord.
ಎಲ್ಲಿ approve ಆಗಿದೆ ಅಂದ್ರೆ? Where is it approved?
Allah, it,
ಕಳಿಸಿದ್ರಿ.
yes, ma'am.
ನಿಮ್ದು ಮೀಟಿಂಗ್ ಆಯ್ತು, ಕಮಿಟಿ
Yes,
ಮಾಡಿದ್ರಿ, ಕಳಿಸಿದ್ರಿ.
Yes, ma'am.
ಕಳಿಸಿದ್ಮೇಲೆ ಅಪ್ರೂವಲ್ ಆಗಿದೆ.
ಆಗಿಲ್ಲ, ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ ಅವ್ರದ್ದು. ನೈದರ್ ಇಟ್ is approved nor rejected.
ಏನಾಯ್ತು? Any observation made in this writ petition shall not come in the way of the petitioners claiming to be the duly elected members of the managing committee if it is approved duly by the respondent number 2. Yes.
Great.
Still 27.
My lord,
Yeah,
the
office
office objection is with
27.
regard to, my lord, annexure B, my lord, page number 17.
Legible.
My lord, I am referring only to, my lord, page 16, the date, my lord, by which we have to.
Annexure
B.
is legible.
The reference is only to the date, my lord. ಅದಕ್ಕಾಗಿ ಅಷ್ಟೇ ಹಾಕಿ. Date by which, my lord, we should complete the election ಅಂತ ಅಷ್ಟೇ
Now,
ತೋರ್ಸಕ್ಕೆ
if you say it is legible, I'll accept it.
My lord,
Learned counsel for the petitioner submits that annexure B is legible. In view of the aforesaid, office objection serial number 27 is overruled. Yes.
my lord, the petitioner is a, my lord, registered society. My lord, running, my lord, a banking institution. My lord, the elected body, my lord, was elected, for the existing management was elected on 14/2/2020 at annexure A, my lord, page number 12A. This is the list of management, my lord. The date on 14/2/2020. 14, my lord, elected members. Then, my lord, the elections to, my lord, the post of president, vice president were held on 25/2/2020. Now, my lord, the tenure of, my lord, the management is 5 years, which will be, my lord, expiring in the month of February. My lord, the annexure B, my lord, page number 16, the reference as 18, my lord, I am sorry, page number 18. The tenure of, my lord, the banks or society which expires from 1/2/2025 to 28/2/2025 has to be completed on or before, my lord, 26/1/2025. There are 5 dates, my lord, given by the authorities.
Yes.
We have to choose one of it, and, my lord, we have to hold an election. For the purpose of holding elections, my lord, the authority has also appointed, my lord, the Tahsildar as, my lord, the returning officer as per annexure C, page number 21. My lord, thereafter, my lord, we have passed a resolution prescribing, my lord, the roster. My lord, there are 14 constituencies under the petitioner society. And we have, my lord, passed a resolution providing, my lord, the roster also. And then, my lord, the date is fixed, my lord, by passing a resolution for conducting election on 25/1/2025 as per, my lord, the proceedings at annexure E, page number 26. My lord. My lord, necessary notification is also issued by way of a paper publication informing all the members.
Yes.
And individual notice are also sent, my lord, to the members. Then, my lord, the list of eligible and non-eligible voters are being submitted to, my lord, the authority for approval on 9/1/2025.
Yes.
My lord, till today, my lord, the authority is neither approving, my lord, the list nor rejecting the list. My lord, on the contrary, my lord, based on some complaint by 3 persons, my lord, at page number 86, the authority, my lord, has issued a notice at annexure J, my lord, page number 85, enclosing the copy of their representation. These members are neither, my lord, in the list of eligible voters nor in the non-eligible voters. They were the past members, my lord, who have lost their rights 15 years before, my lord. They are not even in the list of eligible or non-eligible list. Based on their complaint, my lord, now authority wants to hold, my lord, inquiry. My lord, 13/1/2025 hold date is fixed on 18/1. Now date is fixed tomorrow again. My lord, by the time, my lord, this is the
Yes,
claim
Mr.
of 3
why not you
persons.
consider the list?
Yes,
Now, as per rule 28, if we do not complete the process by, my lord, 14/2, my lord, the administrator will be appointed and entire management will be taken over.
Yes.
My lord, their intention is to, my lord, take over the management of
Where's
the.
the cooperative election officer?
My lord,
You not made him a party.
my lord,
Or two.
the deputy registrar
Yaar
of
advocate
cooperative
yaar,
and district election
cooperative
officer.
election authority yaar.
Government deputy registrar himself.
There's a special council for them.
ಇಲ್ಲ ಯಾರು ಇಲ್ಲ.
ಇಲ್ಲಿ ಯಾರೋ ಇದ್ರಲ್ಲ ವಸತಿ.
ಇಲ್ಲ ಯಾರು ಇಲ್ಲ.
No, there was some advocate.
ಅಂಬರೀಶ್ ಇಲ್ಲ.
Augustine
ಇಲ್ಲ
ಯಾರೋ ಇದ್ರು.
several
ನಾನ್ ಬಂದಾಗ ಶಶಿಕುಮಾರ್ ಅಂತ ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ರು.
ಅಲ್ಲಿದ್ದಾರೆ.
So therefore I asked Shashikumar, he said Augustine is appointed. ಯಾರೋ ಇದ್ರಲ್ಲ.
Alfred Solomon.
ಇನ್ನೊಬ್ರು ಯಾರೋ ಆಲ್ಫ್ರೆಡ್ ಸಾಲಮನ್. ಅವ್ರು ಇದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು.
ಇಲ್ಲಿ.
So find out, Mr. Who is the advocate? Have they appointed any advocate?
Yes.
Barcode AG is directed to accept notice for respondents 1, 3, 4 and 5. 1, 3, 4 and 5. They also directed to secure instructions whether the respondent number 2 has appointed any advocate to represent it before this court, before the bench of this court. Before this bench and before this bench. Yavat Monday. Yes, Monday.
Next Monday.
Monday agutta? Monday.
Petition.
VK Naik.
Lord, in this, I have filed amendment application, also impleading application.
Any objection? Who appears for the Krupa Sagar?
Krupa Sagar.
No objection?
For impleading that notice has to be issued.
Alla, amendment again objection idea. But IA 1/24 is filed to amend the writ petition. The petitioner intends to add additional grounds in support of the writ petition and also seek an additional prayer to quash the list of eligible candidates. Full stop. Since allowing the application would conclusively decide the dispute between the parties, IA 1/24 deserves to be allowed. Consequently, IA 1/24 is allowed. Counsel for the petitioner is directed to amend the writ petition and also file an amended writ petition. Issue notice on IA 2/24. VK Naik amendment ಮಾಡ್ಬಿಡ್ರಿ. Please amend it. ಆಮೇಲೆ ಮರ್ತೋಗ್ತೀರಾ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ, ಮರ್ತೋಗ್ತೀರಾ ಮತ್ತೆ ಇನ್ನೊಂದಿನ ಬರುತ್ತೆ. Yes, Ganesh Kalaburagi.
Kindly pass over, Your Lordship.
What pass over?
Senior is engaged in court.
Please argue the matter, Mr.
Lord, in this matter, my Lord, he has sought for, Lord, revaluation and answer script also, I hope, my Lord. But last occasion, what I made submission, my Lord, he already, my Lord, completed the course duration period. Addition to that, my Lord, given with 2 to 3, my lord, opportunity for my lord passing out whatever the left out subjects of the petitioner. And my lord, after that, my lord, we received a communication from the university, Lord, but giving of his answer sheet, my lord, at this moment not arise, my lord, as because the immediately on announcement of result, 5 days were given for the my lord student to apply for, and he could not done and taken the my lord, make use of the said opportunity. One thing. And the second point is, my lord, at this moment, my lord, there is a notification, my lord. Next, my lord, he will be having 2 more, my lord, examination, additional examination.
When is that next?
And that
exam?
notification I will pass on, my lord. It is,
ಯಾವಾಗಿದೆ?
my lord, but 14/8/2024 notification, my lord.
Next exam ಯಾವಾಗಿದೆ?
Exam date, my lord, probably it has not mentioned in this, my lord. But anyhow, he will be provided with that, my lord, this thing.
He'll
I will
be-
pass on that, my lord, even communication along with notification, my lord. I take a printout. 2:30 it may be taken up.
Pass
That,
over.
please. Much.
Ajay Busare, Harshavardhan Patil.
For petition. The petitioner is challenging my lord annexure A. Wherein my lord the demand notice issued under section 142(1)(5) of my lord the Municipalities Act. Lord, the last paragraph, my lord, in first paragraph, my lord, ಈ ನೋಟಿಸ್ ಮೂಲಕ ತಿಳಿಸುವುದೇನೆಂದರೆ ದಿನಾಂಕ 2005-6 ಅವಧಿಯ ಸ್ವಯಂ ಘೋಷಿತ ಆಸ್ತಿ ತೆರಿಗೆ ಪದ್ಧತಿ ಪ್ರಕಾರ ತೆರಿಗೆಯನ್ನು 31/3/2023 ಅವಧಿಯಲ್ಲಿ ಪಾವತಿಸಬೇಕಾಗಿದ್ದು, ಅಲ್ಲದೆ 1964 ಅಧಿನಿಯಮದ ತಿದ್ದುಪಡಿ ನಿಯಮ 105(1) ಮತ್ತು 2 ಅನ್ವಯ ಸ್ವಯಂ ಘೋಷಿತ ಆಸ್ತಿ ತೆರಿಗೆ ಪದ್ಧತಿಯಲ್ಲಿ ಪಾವತಿ ಮಾಡಲು ತಮಗೆ ಅವಕಾಶವಿದ್ದಾಗಿಯೂ ಸಹ ತಾವು ತೆರಿಗೆ ಪಾವತಿಸಲು ವಿಫಲರಾಗಿದ್ದೀರಿ. ಆದ ಕಾರಣ 1964 ಅಧಿನಿಯಮದ ಕಲಂ ತಿದ್ದುಪಡಿ 105 ಕ್ಲಾಸ್ 4 ರಲ್ಲಿ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರಿಯನ್ನು ಚಲಾಯಿಸಿ ತಮ್ಮ ಆಸ್ತಿಯ ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿ ಈ ನೋಟಿಸ್ಗೆ ಲಗತ್ತಿಸಿರುವ ವಿವರಗಳ ಪಟ್ಟಿಕೆಯಲ್ಲಿ ಮೇಲಿನ ಅವಧಿಯ ತಮ್ಮ ಆಸ್ತಿಯ ತೆರಿಗೆಯನ್ನು ನಿಯಮಗಳ ಅಡಿಯಲ್ಲಿ ಸೊ ಅಂಡ್ ಸೊ ಅಂತೆ ನಿಗದಿಪಡಿಸಲಾಗಿದೆ ಹಾಗೂ ಬಾಕಿ ಮೊತ್ತ ಲೆಕ್ಕಾಚಾರ ಮಾಡಿ ಕೆಳಗಿನಂತೆ ಬೇಡಿಕೆ ಮೊತ್ತ ತಿಳಿಸಲಾಗಿದೆ. ಮೇಲಿನ ಮೊತ್ತ
how many years? 2005-6 ಇಂದನಾ?
Yes, my lord, 5-6 ಇಂದ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅಂಡ್ in first paragraph, my lord, it is stated that my lord ಸ್ಥಳ ತನಿಖೆ ಮಾಡಿದ್ದೀವಿ ಅಂತಾರೆ. The spot has not been inspected, my lord. And last paragraph, ಮೇಲಿನ ಮೊತ್ತ so and so ಬ್ಯಾಂಕಿಗೆ 30, that is my lord the provision which says my lord 30 days, whereas it has been rounded and 7 days time has been given, my lord. ದಿನಗಳ ಒಳಗಾಗಿ ಪಾವತಿ ಮಾಡಿ ವಿವರಣಾ ಪಟ್ಟಿಗೆ ಸಹಿ ಮಾಡಿದ ಪಾವತಿ ಮಾಡಿ ಚಲನ್ ಜೊತೆ ಪುರಸಭೆ ಕಾರ್ಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸಬೇಕು ಅಥವಾ ತೆರಿಗೆ ನಿಗದಿಪಡಿಸಿದ ಬಗ್ಗೆ ಆಕ್ಷೇಪಣೆ ಇದ್ದಲ್ಲಿ ಮೇಲ್ಮನವಿಯನ್ನು ನಿಗದಿತ ಅವಧಿಯಲ್ಲಿ ಆಯುಕ್ತರು ಪುರಸಭೆ ಇವರಿಗೆ ನಿಯಮ ಪ್ರಕಾರ 105(6) ಪ್ರಕಾರ ಸಲ್ಲಿಸಬೇಕು. Then, my lord, I have called in.
Sorry to interrupt, my lord. I have a preliminary objection regarding maintainability. Appeal is 150 ಕೆಳಗಡೆ ಇದೆ.
And my contention is that, my lord, after, my lord, this
If there's an
105,
appeal, why do you want to waste your time here?
my lord, 105 clause 6 prescribes, my lord, after issuance of this demand notice, my lord, 30 days notice, my lord, days has to be given for
That is
submitting
okay,
objection.
but if there's an appeal remedy, why do you want to waste your time here?
Section 150.
Lord, appeal comes, my lord, after compliance of section 105, my lord.
Notice issue agidalla, we'll treat it as a notice and 30 days notice.
Your lordship kindly see section 105 clause 6, my lord.
Not 5 clause.
105 clause 6.
Of
Karnataka Municipalities Act. 6. The owner or occupier may either accept the property. The owner or occupier may either accept the property tax assessed and the penalty, if any, levied, or send objection to the municipal commissioner or the chief officer, as the case may be, or the authorized officer within a period of 30 days from the date of receipt of copy of the order under subsection.
So now
3.
we are still at the stage of notice.
Yes, my lord. Where, my lord, instead of 30 days, 7 days time has been given, my lord. Thereafter, my lord, clause 7, the municipal commissioner or the chief officer, as the case may be, or the authorized officer shall consider the objections and pass order such order either confirming or revising the assessment of such tax and penalty, if any, within a period of 60 days from the date of filing of objections, and a copy of the order shall be sent to the owner or occupier. Therefore, my lord, 30 days.
File ಮಾಡಿದಿರಿ?
Madila 7 days ಕೊಟ್ಟಿದ್ರು.
ಆಯ್ತು, ಇವಾಗ ಮಾಡಿ.
Then what happened, my lord? Even before this notice also, my lord, when they come for, my lord, for payment of tax, by orally threatened that, my lord, they will lock the property. Then, my lord, the petitioner has paid 3 lakh amount, my lord.
So, okay, we'll say that unless the whole process is
Yes.
decided,
Yes,
they should not take any precipitative action.
please,
You file your objections, let them decide it in accordance with law.
please.
ಅಷ್ಟು ಮಾಡ್ಬೋದಲ್ಲ?
Yeah.
Yes, ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged a notice issued by the respondent under section 105 clause.
Alla 142 clause 142
142 na?
Yes.
Under section 142(1) of the Karnataka Municipalities Act 1964. 142 na?
142. 1 Roman 5.
One
142 clause 1 Roman 5, my lord. Property tax including penalty leviable under section 5 of section 105.
subclause 1, subclause Roman 5. Demanding the arrears of property tax along with interest for the term 2005-6 to 2023-24. Next para. The petitioner contends that it is a society registered under the Societies Registration Act. And is involved in philanthropic activities by running a library for the general public, for the use of the general public. Full stop. The respondent issued a notice to the petitioner under section 142(1) Roman 5 of the Karnataka Municipalities Act 1964, demanding arrears of property tax for the period 2005-6 to 2023-24, amounting to a sum of rupees 19,71,821. Petitioner contends that the respondent had threatened to lock down the library if the petitioner did not pay the demand, the tax demanded. Full stop. The petitioner is therefore before this court challenging the notice issued by the respondent. Next para. The learned counsel for the petitioner contends that a notice under 142(1)(5) of the Karnataka Municipalities Act 1964 can be issued only after compliance of the procedure contemplated under section 105 of the Karnataka Municipalities Act 1964. He contends that the respondent was bound to first issue a notice demanding tax and granting 30 days time to the petitioner to respond, and thereafter consider the objections filed by the petitioner and pass appropriate orders within 60 days. Full stop. The respondent, without complying the aforesaid procedure, has straightaway laid a demand for a sum of rupees 19 lakhs so and so so and so. The petitioner is therefore before this court challenging the said notice. Full stop. Per contra, the learned counsel for the respondent submits that the petitioner has the remedy of an appeal under section 150
Yes.
of the Municipalities Act 1964, and therefore he cannot approach this court.
And my lord, they are running shops, my lord, they are commercial
He also
property.
contends that the petitioner is running commercial shops and not a public library as claimed by
No,
the
no, library is
public
also
library
there.
Also there, my lord.
shops along with the public library, and therefore the petitioner is not doing any philanthropic activity. And therefore, the activity of the petitioner is not fully philanthropic. Next para. A perusal of section 142.15 of the Act 1964 shows that the respondent is entitled to make a demand of the property tax along with interest. However, procedure of determining the property tax payable is contained in section 105 of the Municipalities Act 1964, and for ready reference, the same is extracted below. Copy of it. In view of the provisions, in view of section 105, the respondent is bound to first issue a notice to the petitioner,
Spot inspection. 105 clause 4 has to comply.
and
Spot
if need be, after conducting a spot inspection, and grant an opportunity to the petitioner to file its objections. And after considering the objections, an order could be passed determining the property tax payable along with interest, if any. Full stop. The impugned notice does not show that the procedure contemplated under section 105 of the Act 1964 was followed. Therefore, the impugned notice cannot be sustained as it is not in accordance with the provisions contained in section 105 of the Act 1964. In that view of the matter, this writ petition deserves to be disposed of deserves to be allowed in part, and the impugned notice issued by the respondent is liable to be quashed. Hence the following order. The writ petition is allowed in part. The notice dated so-and-so issued by the respondent bearing number so-and-so, bracket annexure A, is quashed. However, liberty is reserved to the respondent to take out proceedings in accordance with section 105 of the Act 1964. Full stop. The relief sought for by the petitioner to exempt it from payment of tax under the Karnataka Municipalities Act 1964 is rejected or is kept open to be considered at an appropriate stage.
And meanwhile, I have paid 3 lakhs rupees, my lord, that has to be.
Any amount paid by the petitioner shall be appropriated by the respondent towards the property tax payable by the petitioner.
Please. That exercise under 105, my lord, is completed. The notice says, my lord, 105, my lord, that exercise.
Ellagide.
For
ಅಲ್ಲ,
spot
ಇದ್ರಲ್ಲಿ
inspection
ಬರ್ದಿದೆ.
ಆಗಿಲ್ಲ. 105 ಅಲ್ಲಿ clause 4 spot inspection ಆಗಿಲ್ಲ.
ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಬಿಡಿ ಅದ್ ಬಿಟ್ಟು ಆಗಿದೆ. ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
Objection ಆಗಿಲ್ಲ.
ಮತ್ತೆ 7 days ಕೊಟ್ಟಿದ್ದೀರಾ?
30
30 days ಬದಲು 7 days ಅಂತ ಮಾಡಿದ್ರು.
ಅಲ್ಲ, my lord, 30 days notice is under 105 for determination.
Correct.
After that determination, this is for payment.
But what is there to show that 105 procedure is
Not the
followed?
notice, my lord, first paragraph says that. Well, we'll redo that, my lord. That's no, there is no
Please
difficulty,
redo
but
it.
it's
Please.
done, my lord.
Please
may not-
read it because he has not filed any objections.
Yes.
Please redo it. Yes, next. Sagar Patil.
Also kindly pass over.
ಇನ್ನೊಂದಿನ ಮಾಡಿ ಯಾವತ್ತು 2024 matter. Learn counsel for the petition seeks time list on date. Number 27, AM Nagaral.
There is entry moderated.
Entry order is extended till the next date. AM Nagaral.
Hearing for the petitioner.
Hmm.
Petitioner is challenged, my lord. Petitioner is before this court, my lord, challenging annexure C1. No
Annexure
confidence.
C.
C. Notice issued by the third respondent, my lord, Assistant Commissioner. Moving
Further
no confidence
proceedings
motion.
are stayed, my
I filed with-
further proceedings are stayed, my lord.
This is annexure.
We'll close it. ಏನೋ ತೀರ್ಮಾನ ಮಾಡ್ಬಿಡಿ. ಯಾಕೆ ಸುಮ್ಮನೆ keep it pending.
I for a vacating stay, my lord.
9/12/24 is the notice.
Yes.
When is it? When is the meeting?
Meeting fixed on
26,
26/12.
ಯಾವಾಗ ಸರ್ವ್ ಆಯ್ತು ನೋಟಿಸು?
It is not on that count, my lord. I have challenged
based on annexure B, where, my lord, the PDO has endorsed the, my lord, representation.
ಎಲ್ಲಿದೆ?
Page 16 is the annexure B. 17, my lord, ನನ್ನ ಕೆಳಗಡೆ Panchayat Development Office.
ಕರೆಕ್ಟ್. ಈ ಮೇಲೆ ಸಹಿ ಮಾಡಿದ ಎಲ್ಲರೂ ಮಧುಬಾವಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಸದಸ್ಯರೆಂದು ದೃಢೀಕರಿಸಿದ್ದೇನೆ.
Rule
ಏನ್ ತಪ್ಪೇನಿದೆ?
3, 1 and 2 is, my lord, this honorable court, my lord.
ಅಲ್ಲ, ಈ ತರ ದೃಢೀಕರಣ ಮಾಡೋ ತಪ್ಪು ಅಂತೇನ ಇದೆಯಾ? ಕೊಡಿ ತೋರ್ಸಿ. ಪ್ಲೀಸ್ ರೀಡ್. ಎಲ್ಲಿ ಹೇಳಿದಾರೆ?
Para 10,
para
10, my lord.
10
ಹೌದು.
ಏನಂತ ಮಾಡಿದ್ರು ಹೇಳಿ, ಓದಿ.
It's a plain reading of Rule 3(1) of said rules of 1994 clearly indicates that the respondent number 5 to 15 were entitled to submit the same only to the Assistant Commissioner and not to the PDO. Further, a conjoint reading of Rule 3(1) and Form number 1 also indicate that the same do not provide for any writing, signature or seal or of anyone else other than the respondent number 5 to 15 who submitted the impugned representation or the Assistant Commissioner who received the same from them. In other words, Rule 3(1) read with Form number 1 of the said Rule 1994 do not contemplate in any manner either the presence, involvement or participation of the PDO for the purpose of submission of representation or at the time of its submission. Neither is there any or other provision under the Karnataka Gram Swaraj and Panchayat Raj Act 1993 or the said Rule 1994 which permit the PDO to affix its writings, signature or
Correct,
seal on the representation in Form number 1.
It is not as if he has received the representation. He says ಇವರೆಲ್ಲ members ಅಂತ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ. And who is this person who has received it on 25/11? Assistant Commissioner has received it. Please put up ಮಾಡಕ್ಕೆ ಹೇಳ್ರಿ, WP number 2031 file put up ಮಾಡಕ್ಕೆ ಹೇಳ್ರಿ.
Based on this judgment, my lord, several judgments
No,
were.
that is right. But I do not know what was mentioned on the representation. ಇವಾಗ ನೀವು representation page 16 ಅಲ್ಲಿ,
ಹೌದು.
if there is a PDO seal, what you say is right.
PDO seal is there.
ಎಲ್ಲಿ?
Page 17.
17 ಅಲ್ಲಿ ಇವ್ರ members ಅಂತ ಇದು ಮಾಡಿದ್ದಾರೆ. Is only said they are members. ಈ representation ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ? Assistant Commissioner ಕೊಟ್ಟಿರೋದು Annex B ನಲ್ಲಿ.
Then representation should be by two of the persons, my lord. ಇದರಲ್ಲಿ
is
ಒಬ್ಬರೇ ಸೈನ್ ಮಾಡಿದ್ರು.
ಹಾ.
ಫಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ SS ಜಾಧವ್ ಮತ್ತು 15 ಜನ
ಮತ್ತು 15 ಜನ ಸದಸ್ಯರು ಅಂತಿದೆ.
ಅದೇ ಸದಸ್ಯರು is comes next page. Both page consist of, my lord, representation. Last page he has, my lord, endorsed.
ಕರೆಕ್ಟ್. ಅವ್ನು ಹೇಳೋದೇನು, ಈ ಮೇಲೆ ಸಹಿ ಮಾಡಿದ ಎಲ್ಲರೂ ಮಧುಬಾವಿ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸದಸ್ಯರೆಂದು ದೃಢೀಕರಿಸಿದ್ದೇನೆ. How does it affect?
These judgments.
ತರಿಸಿ ನೋಡೋಣ. Get the file. File ತರಿಸಿ, pass over. Anyway, the elections ಆಗಿಲ್ವಲ್ಲ? So you have succeeded. Succeed ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಸ್ಟೇ ಇದೆಯಲ್ಲ?
ಹೌದು.
ಮತ್ತಿನ್ನೇನು?
Date is elapsed.
So therefore a fresh meeting has to be held.
ಅದೇ liberty was given in that judgment also.
No. Yes.
Filing including application.
Serial number 16 and this matter, same matters.
ಯಾವುದು?
Serial number 16. Saturday date ಕೊಟ್ಟಿರೋದು my lord.
They are same.
Same matter, my lord. Kindly have it
Pass
along with that matter.
ಯಾವತ್ತಿದೆ?
Saturday ಕೊಟ್ಟಿದ್ದೀರಾ?
Saturday.
This matter, my lord, implementing application I have filed. In this matter,
Your members.
I am Vice President, my lord. Now the
You are
election.
the elected president.
Election notice is stayed, my lord. Now no confidence proceedings are concluded successfully. In persons of that, Vice President, President elections are there. I am Vice President, my lord. By virtue of the interim order, my lord, sir.
Yes, you filed the application. Objection ಹಾಕ್ರಿ, ಯಾಕಂಗಿದ್ರಿ? ಹಾಕ್ತಿರಿ? ಏನು ಐ ಹಾಕಿದಾರಲ್ಲ ಮೇಡಮ್?
ಅಯ್ಯ ಅವ್ರು ಆಗ್ತಾ ಇದ್ದಾರೆ my lord. ಈ ಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇವಾಗ ಅವ್ರು ಆಗ್ತಾ ಇದ್ದಾರೆ.
ಇನ್ನ ಫೈಲ್ ಆಗಿಲ್ಲ?
ಇಲ್ಲೇ ಹಾಕ್ತಾ ಇದ್ದೇನೆ.
ಇಲ್ಲ, ಮತ್ತೆ ಫೈಲ್ ಮಾಡಿ, ರಿಜಿಸ್ಟ್ರಿಲ್ ಫೈಲ್ ಮಾಡಿ. This is petition on
Very
16th.
short point ಮುಗಿಸಬಹುದೇನಂತ.
16th. Let it come on 16th.
along with 16 serial number, my lord.
ಆಯ್ತು. Let it come on Saturday.
Saturday.
Saturday. Day after tomorrow.
And the appearing for the petitioner, my lord.
My lord, in this case, honorable court directed me to secure records. It may be taken tomorrow, my lord. I will say.
Tomorrow, Saturday.
Please.
ಏನ್ ಡೇಟ್ ಆಗೋಗಿದ್ಯಾ?
ಆಗಿದೆ.
ಮೀಟಿಂಗ್ ಡೇಟ್ ಆಗೋಗಿದ್ಯಾ?
Date ಆಗಿದೆ subject to result at matters. There is the 15 days clear notice.
ಲಿಸ್ಟ್ ಆನ್ ಮೀಟಿಂಗ್ ಆಗೋಗಿದೆ.
Meeting ಆಗಿದೆ. No confidence motion is passed with a majority.
ಲಿಸ್ಟ್ ಆನ್ Saturday.
Please.
BC Jaka.
Appear for petition. Lord, the petitioners are, my lord, members of Gram Panchayat. They have moved, my lord, no confidence motion against Adhyaksha. The Assistant Commissioner, my lord, respondent number 2, held meeting on 4/1/2025. And all the members, my lord, who moved no confidence motion were present. On that day, my lord, one of the member, my lord, fell down from the chair. Therefore, my lord, fell down from the chair, my lord, because of chest pain. My lord. So all the member took him to the hospital, my lord. Thereafter, my lord, the second respondent passed, my lord, impugned order, Annexure E. Annexure E, my lord. Stating that, my lord, in page number 44, typed copy, second para, my lord. ಮುಂದುವರಿದು ಸಿರವಾರ ತಾಲೂಕಿನ ಗಿಣದಿನ್ನಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ತಾಂಡ ವಲಯದ ಒಟ್ಟು ಸದಸ್ಯರ ಸಂಖ್ಯೆ 15 ಇದ್ದು, ಇಂದಿನ ಸಭೆಯಲ್ಲಿ ಕೇವಲ 2 ಸದಸ್ಯರು ಹಾಜರಿರುತ್ತಾರೆ. ಕಾರಣ ಸಭೆ ನಡೆಸಲು ಗೊತ್ತುಪಡಿಸಿದ ಸಮಿತಿಯಿಂದ ಒಂದು ಗಂಟೆಯವರೆಗೆ ಸಭೆಯಲ್ಲಿ 2/3 ಕೋರಂ ಇಲ್ಲದ ಕಾರಣ ನಿಯಮ 3(6) ಸಭೆಗೆ ಗೊತ್ತುಪಡಿಸಲಾದ ಕಾಲ ಮುಗಿದ ತರುವಾಯ 1 ಗಂಟೆಯೊಳಗೆ ಕೋರಂ ಇಲ್ಲದ ಕಾರಣ ಇಂದಿನ ಸಭೆಯನ್ನು
ಹೊಸ ಟೈಪ್ ಆಫ್ ಬೀಟಿಂಗ್ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್. ಯಾರೊಬ್ಬ ಮೆಂಬರ್ ಹಿಂಗ್ ಇಟ್ಕೊಂಡ್ಬಿಡೋದು.
My lord, I have produced, my lord, medical records, my lord.
Correct, but ಇಲ್ಲ ಏನ್ ಮಾಡ್ತಾರೆ? What can the Assistant Commissioner do if the members are not there?
Looking to the circumstances, because that was took place in front of the Assistant Commissioner, my lord. He could have fixed another date, my lord.
How can you fix another date? What does the rule say? Is to wait for 1 hour.
1 hour wait
ಮಾಡಿದ್ದಾರೆ. ನೀವು 1 hour ಅಂತ ಹೋಗ್ಲಿಲ್ಲ. What should you do? ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಡಿ ಅಷ್ಟೇ.
Please, my lord, that.
ಬರ್ಕೊಳ್ಳಿ. The petitioners being members of the members of the Gram Panchayat Sirwar.
ಗಣದಿನ್ನಿ
ಗಣದಿನ್ನಿ
ಗ್ರಾಮ ಪಂಚಾಯತ್ ತಾಲೂಕ್ ಸಿರ್ವಾರ.
ಎಂತದು ಗಣದಿನ್ನಿ. ಗಣದಿನ್ನಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ are before this court challenging the proceedings of the respondent number 2. Respondent number 2. Dated 4/1/2025. Terminating the proceedings of terminating a meeting of no confidence. As there was no sufficient quorum to consider it. Next para. Based on a representation filed by the petitioners in form number 1 under Rule 3(1) of the Rules 1994, the respondent number 2 issued a notice dated 10/12/2024 convening a meeting of the members of the Panchayat on 4/1/2025 to consider the motion of no confidence. Full stop. On the said day, one of the members of the Panchayat,
petition number 8 here.
Petition number
8 here.
18.
8, my lord.
Petition, one of the members of the Panchayat, namely the petition number 8 herein, suffered pain in the chest and therefore had to be immediately evacuated and shifted. They immediately shifted to a hospital. So therefore, the respondent number 2 waited for the members of the Panchayat to reassemble. Full stop. Since none of the members reassembled, he held that there was no sufficient quorum to consider the motion of no confidence and hence closed the meeting. Being agreed with the said closure, the petitioners are before this court. Next, the learned counsel for the petitioners contend that the petition number 8 was also one of the members who submitted a representation
Yes.
expressing lack of confidence in the Adhyaksha
Yes.
and that he became unwell on the date of the election, date of the meeting, which all happened in the presence of the Assistant Commissioner. Therefore, he contends that the Assistant Commissioner, therefore, respondent to number 2 must have postponed the meeting rather than closing the meeting. Full stop. Thus, he prays that suitable directions be issued to the respondent number 2 to hold a fresh meeting. Full stop. Based on the representation filed with the petitioners. Next part. The learned AGA submitted that Rules 1994 prescribe the procedure that has to be adopted by the respondent number 2 in the absence of quorum. He contends that under rules
Section 53.
and under section 53 of the Act 1993, the respondent number 2 is bound to wait for 1 hour for the members to reassemble, which in the present case, the respondent number 2 followed. However, since none of the members turned up, he had no other option than to close the meeting. Full stop. Rules ಅಲ್ಲಿ ಇರಬೇಕಲ್ಲ.
Rules basics.
There is no confidence. No. The section, Rule 3, Sub-Rule 6 of the Rules 1994, subsection 5 of section Rule 3, the Sub-Rule 5 of Rule 3 of the Rules 1994 mandate as follows. Similarly, Sub-Rule 6 of Rule 3 mandates as follows. Next para. Admittedly, petitioner number 8 fell sick on the date of the meeting, and therefore all the members who had signed the representation in form number 1 shifted him to the hospital. Full stop. It may be that the incident occurred in the presence of the respondent number 2. Full stop. If the petitioners were interested to pursue the motion of no confidence, they must have reassembled within 1 hour. Since full stop. Since that was not done, the respondent number 2 had no other option than to hold that there was no quorum, had no other option than to wait for 1 hour and 1 hour for the members to reassemble. And if the members did not reassemble and if there is no quorum, the respondent number 2 was bound to dissolve the meeting. Full stop. Since the dissolution resulted in lapsing of the notice issued by the petitioners under Rule 3(1) of the Rules 1994. The petitioners cannot assail the procedure adopted by the respondent number 4, respondent number 2. In that view of the matter, no indulgence can be shown to the petitioners in this writ petition, and a fresh date and the respondent number 2 cannot be directed to convene a meeting based on the representation submitted by the petitioner. Hence, the writ petition is dismissed. However, it is open for the petitioners to file a fresh representation in forum number 1. Full stop. If such a representation is filed, the respondent number 2 shall proceed in accordance with law.
I will take notice for R1
AG
and
is
R2.
permitted to file a memo of appearance within 10 days.
Yes.
Mr. S.V. Deshmukh.
Lord, I'm seeking respond. Petitioner is the petty businessman in APMC yard, my lord, Chitapur. And
Here notice ಏನಿದು annexure D.
annex D, yes. APMC is representing APMC, my lord. Moga is there. I'm seeking mandamus, my lord, directing my considering my application dated.
ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಲ್ವಾ?
Pardon?
Is there an order passed?
Yes, my lord. Previously it was order passed, but they were not considering my application.
ಅಲ್ಲ sir. A notice in Form A.
Yes.
Eviction of unauthorized occupants Act ಕೊಡಿ. Karnataka eviction of unauthorized.
No, previous occasion, they were given the direction to consider my application, my lord. In the previous petition, my lord.
They have taken position, my lord.
ತಗೊಂಡಿದ್ದಾರೆ.
Yes.
I not got any instructions.
ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ? ಹೇಳ್ತೀರಾ?
Tomorrow.
Saturday. Saturday.
Please.
List on Saturday. Deepak Bharat. Application for mutation.
Annexure H is in question, Lord. Annexure H, my lord.
Annexure H.
Yes. Annexure H, page 52, my lord. Lord, I have purchased a plot measuring 30 into 40 in land survey number 17/1 of Azadpur. Lord, my vendor had got converted the land from.
Yes, who appears for this? Kalaburagi Mahanagapalike.
Ambekar, DP Ambekar appears. Lord, my vendor's entry is there in the corporation.
Please, highlight. ಒಂದು ಈ ಖಾತಾಗ ಎಷ್ಟು ತೊಂದರೆ ಕೊಡ್ತಾರೆ ನೋಡಿ ಜನಗಳಿಗೆ. Whoever is responsible, I'll direct him to pay cost for compelling the petitioner to come to the court.
This is a little different matter, my lord. ಈ ಖಾತಾದ್ದು ಇದಿಲ್ಲ.
ಆಯ್ತು, ಈ ಖಾತೆ
ಇದರಲ್ಲಿ that does not come within corporation limit ಅಂತ ಅದೇನು ನಮ್ಗೆ.
My vendor's entry is there.
But it is not your endorsement. You did not say that it does not come within the corporation limits. You say ಯಾರ ಮೇಲೆ ವಿಚಾರಣೆ ಇದೆ ಅದಕ್ಕೆ ಕಾರಣ ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ. ತಪ್ಪಲ್ಲ.
I'll verify.
Notice to R1 is dispensed since no relief is claimed against the respondent number 1. The DP Ambekar is directed to accept notice for respondents 2 and 3. Mr. DP Ambekar shall secure instructions as to why the e-khata cannot be issued to the petitioner. The list on yavat.
Next week.
Please. May I request for preliminary hearing?
Miss, next.
May I request for preliminary hearing?
Bharat, don't worry.
Since my lord, the loan has to be obtained. Loan has to be obtained by petitioner.
ಆಯ್ತು, ಶನಿವಾರಕ್ಕೆ ಹಾಕ್ರಿ. 1ನೇ ತಾರೀಕು ಹಾಕಿ. Saturday.
I'm only request for preliminary hearing.
Yes, yes.
Friday.
Friday. Friday, Thursday, no?
Thursday.
Thursday. Okay, for preliminary hearing.
God bless.
Mr. G.D. Nayak. DP Ambekar. Chaitanya Kumar.
Seeking writ of mandamus. The respondent number 4, 5, and 6, my lord, they issued a notice calling for interested bidders in an auction for open plot. My lord. The petitioner, my lord, he was the second highest bidder. As per clause 7 of the auction notice, in case the highest bidder, if it does not deposit the balance amount within 7 days, then it would be cancelled and it would go to the next highest bidder. The highest bidder, my lord, he did not come up to pay the balance amount. Accordingly, this thing was cancelled. I have been requesting them since that day to kindly allot the plot to me since I am the highest bidder. Till today, they are not been done in full. Hence,
ಅಲ್ಲ 2007 allotment, my lord. Now we are in 2025.
But when was what were you doing for so many years?
pardon, my lord.
What were you
Till
doing?
2012, my lord, they have not taken.
Hello, it-
One of
it
the
is on their
condition
part.
is that, my lord, the prior sanction, my lord, direction from the deputy commissioner is necessary as per annexure A, my lord.
Annexure A.
A, clause 7, my lord.
ಏನಂತಿದೆ?
ಹರಾಜಿನಲ್ಲಿ ಹೆಚ್ಚಿನ ಬೆಲೆ ಮಾಡಿದ್ದರಿಂದ ಹಂಚಿಕೆಯಾದಾಗ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಗುಲ್ಬರ್ಗ ಅವರಿಂದ ಲೀಲಾವು ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಒಪ್ಪಿಗೆ ಪಡೆದ ನಂತರ ತಮಗೆ ನೋಟಿಸು ಮುಟ್ಟಿದ 7 ದಿನದೊಳಗಾಗಿ ಉಳಿದ ಹಣ ತುಂಬತಕ್ಕದ್ದು. ಒಂದು ವೇಳೆ ಮೊದಲಿನ ಬೋಲಿದಾರರು ತುಂಬದಿದ್ದಲ್ಲಿ ಅವರ ಠೇವಣಿ ಹಣವನ್ನು ಹಿಂದಿರುಗಿಸುವುದಿಲ್ಲ. ಸದರಿ ನಿವೇಶನ ಎರಡನೇ ಬೋಲಿ ಮಾಡಿದವರಿಗೆ ನಿವೇಶನ ಕೊಡಲು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಗುಲ್ಬರ್ಗ ಇವರಿಂದ ಅನುಮತಿಗಾಗಿ ಸಲ್ಲಿಸಲಾಗುವುದು ಮತ್ತು ಅನುಮತಿ ನೀಡಿದರೆ ಅಂತವರಿಗೆ ನಿವೇಶನ ಕೊಡಲಾಗುವುದು.
ಏನ್ ಸಲ್ಲಿಸಿದಿರಾ? ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಸಲ್ಲಿಸಿದಿರಾ?
ಕಳಿಸಿದಾರೆ ಸ್ವಾಮಿ. And
ಯಾವಾಗ
he has not,
ಕಳ್ಸಿದ್ರು?
because my lord, the allotment is
ಯಾವಾಗ
concerned.
ಕಳ್ಸಿದ್ರ ಹೇಳ್ರಿ. ಫಸ್ಟ್ ಬಿಡ್ಡರ್ಗೋ ಸೆಕೆಂಡ್ ಬಿಡ್ಡರ್ಗೋ ಯಾವಾಗ ಕಳ್ಸಿದ್ರಿ? When have you sent it?
To my knowledge, that was never sent.
Let him say. If they are not sent it, then they will be in trouble.
My lord, I'll furnish, my lord. It is informed, my lord. After that, my lord, for approval, it has sent to my lord deputy commissioner. And my lord, what has happened, my lord, 3 persons were, my lord, attended in the, my lord, auction. My lord, the first bidder is, my lord, bidded 16 lakh rupees. 15 lakh rupees. And the second bidder is, my lord, petitioner has, my lord, bidded, my lord, only 6,50,000.
15 lakhs ಅಂತಾರೆ.
But he did not come forward. It was highly exorbitant.
And this person is, my lord, bidded only 6,50,000.
And you not deposited the money.
Yes.
You deposit ಮಾಡಿದಿರಿ. 6 ಲಕ್ಷ.
6 lakh. 50,000 was the amount, security amount.
EMD amount is deposited.
Deposited.
Yes, find out when you have sent it to the deputy commissioner.
I'll furnish, my lord. It is informed there immediately thereafter, my lord, letter has
On
said.
Saturday.
Monday, my lord.
ಗುರುವಾರ ಮಾತ್ರ. ಇಲ್ಲಿ LB ಮ್ಯಾಟರ್ಸ್ ಗುರುವಾರ. ನೀವೆಲ್ಲ ಡಿಸೈಡ್ ಮಾಡೋದಕ್ಕೆ ನಾನು ಮಾಡಿರೋದು.
Saturday.
25th.
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 Yes.
There is 34 ಅಲ್ಲಿ learned counsel for the respondent number 5 seeks time to ascertain whether as per the tender notification any communication is sent by the respondents to the deputy commissioner. This on 25th. Deepak Bharat.
Lord's Annexure J.
My lord, I have received a statement of objections. Notarize ಮಾಡಿ ಫೈಲ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಈಸ್ಕೊಳ್ರಿ.
ಅಲ್ಲ ನೋಟರೈಸ್ ಮಾಡಿ ಫೈಲ್ ಮಾಡಬೇಕಾಗಿದೆ.
ಸ್ಟೇಟ್ಮೆಂಟ್ ನೋಟರೈಸ್ ಯಾಕೆ ಮಾಡ್ತೀರಾ?
ಅಫಿಡವಿಟ್ ಮಾಡಿದ್ದಕ್ಕಿಟ್ರೆ
ಆಯ್ತು ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ?
ಅಲ್ಲ ಔರಾದಿಂದ ಬಂದವರು ಅಫಿಡವಿಟ್ ಮಾಡಬೇಕು. ಏನಿಡಿ
List on Saturday. Learn
Please.
counsel for the respondent number 6 seeks
Please.
time to file statement of objections. List on Saturday.
Great.
Mahantesh Patil, Gaurish Kashampur.
Last date of hearing in this case, my lord, this honorable court directed the petitioner to placing certain documents before the court, man.
Not petitioner, the respondent stated
Huh?
that.
Respondent number 8 to 11 ಗೆ. Sorry.
Time to file objections ಅಂತಿದೆ.
ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀನಿ ಅಂದ್ರು ಅವ್ರು ಹಾಕಿಲ್ಲ ಅವ್ರು
Respondent number 8 to 11 ಗೆ document place ಮಾಡಿದಾಗ direction ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ.
The 8 to 11 objections file ಮಾಡ್ತೀನಿ ಅಂತ ಅಂದ್ರು.
ಅದೇ.
Bhushan Reddy. ಹಾ. ಏನ್ ಮಾಡ್ತಾರೆ? ರೆಡಿನಾ?
ನಾನ್ ರೆಡಿ ಇದ್ದೀನಿ.
You are ready?
Disputed between petitioner and respondent number 8 to 11, my lord.
Dispute ನಿಮ್ಮ ಮೇಲೆ ತಾನೇ ಇರೋದು.
ಯಾಕೆಂದ್ರೆ
You have formed some sites in some area reserved for.
Municipal commissioner was also directed to give answer, I think, so they are the municipal commissioner.
and the one as per the submission.
ಏನಾಗಿದೆ ಪಾರ್ಕ್ ಏರಿಯಾ ಇದೆ. It is town planning approves a layout and leaves a park area. That park area is converted into plots by the municipal commissioner of the corporation and sells it.
The mail civil suit pending ಇದೆ ಅಂತ ಹೇಳಿ last time. Please, I'll get the instructions, ma'am.
How can you form sites in a park area?
It is not permissible, my lord.
That is.
Yeah. 2021 cases ಎಲ್ಲ ಹಿಂಗೆ ಅಡ್ಜರ್ನ್ ಆಗ್ತಾ ಇದೆ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಸಾರಿ ಅದರಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ ರೆಡಿ ಮಾಡ್ಕೊಂಡ್ ಬಟ್ ಇದರಲ್ಲಿ ನನಗೆ seek short time, my lord.
Young counsel for the response.
Finally ಕೊಡಿ.
Seeks time
Please.
list on.
30th, ma'am.
Next week.
Ganesh Kalaburagi.
One submission, my lord.
Hmm.
My lord, they have taken, my lord, no objection on the last day before yesterday, my lord. Kindly have this matter, my lord, the next week, my lord, because, my lord, it is informed they will engage advocate, but so far they have not engaged advocate.
Term ಆಗಿದೆಯಾ ಹೆಂಗೆ ಇದು?
Serve ಆಗಿದೆ, I had filed.
Term.
Some.
Whether the
Like,
term
it's
of
still
this
there, it is
man is expired
up
or
to
what?
August, it is still up to August.
August 2025.
I think it was August or I'm not sure, but it is still in vogue.
Yeah, what is the allegation?
They have violated the whip is the allegation, and therefore a complaint seems to have been lodged, not by the person who is authorized. One of the members was a lady member who had a reason to be absent because she was pregnant, and so these allegations, in fact, there is a reference that it is argued before the authority that the complaint is not maintainable.
Party has not filed the proceedings. Party madilla.
The party anta torusta, it is not party. It is only, my lords, a particular person who makes this complaint. That's the the complaint is at page number 27, typed copy at annexure A. Mukhyadhikarigalu anta is forwarded by the Mukhyadhikarigalu.
Was he authorized?
That is the contention which I have raised. This respondent number 3 is only a councillor from one ward.
ಇದೆಯಾ authorization ಇದೆಯಾ?
ಇಲ್ಲ.
Huh?
ಇಲ್ಲ, ನನ್ನ ಪ್ರಕಾರ my argument itself is that there is no authorization, nor he is the proper person to.
Whether you raised a contention before the deputy commissioner?
Yes, that is
ಎಲ್ಲಿ
there.
ಹೇಳಿದ್ದೀರಾ?
Annexure M is the order.
ಅಲ್ಲ, annexure
M.
E is some objection.
In the order, it is noted, my lords, that the complaint is not maintainable. I have submitted some citations with regard to this aspect of the matter.
ಅಲ್ಲ, objections ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
ಹೌದು.
Annexure D ನಲ್ಲಿ
ಹೌದು.
where have we mentioned that someone else, some
ಹೌದು.
person who is not authorized has filed the
Yes,
complaint?
I will show that. That is in fact one of the main contentions. Page 71, annexure E.
71,
71.
ಇದೇನಿದು?
71 is the affidavit of one of the parties.
ಅಲ್ಲ ಇಲ್ಲೇನೋ ಇದೆಯಲ್ಲ ಪೇಜ್ ನಂಬರ್ 57
Yes,
annexure D.
57, annexure D is the statement.
ಹಾ ಆಶಣ್ಣ.
Ashanna is the one of the respondents there. Khaja Moinuddin is the complainant.
ಹಾ ಎಲ್ಲಿ ಹೇಳಿದ್ರ?
Non-compliance of SOP, my lords,
Where have you said?
para number 7 is with regard to the notice of whip not being properly served. Para number 9 is about maintainability of the complaint.
You're not taken a specific contention.
That my lords will find in the order where a particular judgment is referred, cited by the advocate.
So we can take it that you have not raised any contention, the objections.
Well, I have, my lords, raised that as per annexure, at annexure D, para number 9 is an omnibus statement, general statement, but it is about maintainability. And then in page number 93,
Yes.
This para number H of the findings and conclusions of Deputy Commissioner. Further, advocate for respondent have submitted citation to cite the judgment of Honorable Justice so and so in P. Govindraj versus State of Karnataka on 10th November 2017, WP number so and so in High Court of Karnataka, Dharwad bench on 29 June 2017, Srimati Hemalit Lata versus DC Bagalkot district. As per this citation, maintains that complaint is not maintainable because complaint is not made by president. Rather, the complaint is made by the member who is contesting for the post of TMC president. Gurmitkal also, as per the citation, whip has to be given directly in hand to the person, but whip cannot be pasted on the TMC member's door. Also submits that evidence shows clear case of admission to hospital for delivery and delivered on 2/11/2020. Same date that election of Gurmitkal TMC was conducted, that is on 2/11/2020. Evidence R3 shows positive COVID-19 report of Ashok Kumar Mahadev on 19/10/2020 and to undertake home isolation for 17 days. And also Ashanna Bichanna shows positive COVID-19 report on 19/10/2020 and advised home isolation for 17 days. Karnataka Local Authorities Prohibition of Defection Act 1987 under 3B provides for condonation of violation of whip can be granted within 15 days from the violation of the whip. It's a matter of record that no such condonation has been granted. Therefore, complaint is valid. Complaint has been heard by Deputy Commissioner Yadgir. I have perused and examined documents, and whip has been legally correctly issued by the District President Congress. In fact, Manoj, I have a contention to say the District President of a party also is not, unless he is specifically authorized in writing to issue a whip, merely because he is the president of a district party, he cannot issue the whip at all. So the issuance of the whip also has to be properly considered. There is nothing on record to.
Where are the bylaws of this INC, Indian National Congress?
That is not true.
ಅದ್ರಲ್ಲಿ ಏನಂತಿದೆ ವಿಪ್ ಬಗ್ಗೆ?
ಏನು ಬರೆದಿಲ್ಲ.
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಲ್ಲ. What is mentioned in the, how a whip has to be served, who has to issue it?
Before your lordships, I have to produce it, but then my lords, it was necessary on the part of the complainant before the deputy commissioner to have shown that he is authorized to, the president was authorized to issue the whip. Secondly, my lords, even pasting the whip on the door is not a procedure which can be accepted in this kind of a circumstance where one of the party member is already tested positive for COVID and
Yes.
another lady member is has actually delivered on the very same day.
ಏನ್ರಿ ಡೆಲಿವರಿ ಆದ್ರೆ ಹೆಂಗ್ರಿ ವಿಪ್ ಫಾಲೋ ಮಾಡೋದು?
Notice.
When the lady is delivered.
Allah, so far a lady is concerned, my lord, it is submitted, she has delivered the child. To other two persons are, my lord, they are.
They say that they contracted COVID-19. What is the date of the notice of the whip?
My lord, and ink page, my lord, 30, my lord. Last paragraph.
Ink page number?
30.
30.
Please, my lord. 31 is, my lord, particularly it is mentioned, my lord, the notice where, my lord, affects to the, my lord, house of the, my lord, petitioners.
ಓದಿ ಎಲ್ಲಿ ಇರ್ತೀರಿ?
31 ಸ್ವಾಮಿ, ಅಭ್ಯರ್ಥಿ ಆಯ್ಕೆ ಸಭೆಯ ನೋಟಿಸು ವಿಪ್ ಅನ್ನು ಕಾಂಗ್ರೆಸ್ ಪಕ್ಷದಿಂದ ಪುರಸಭೆ ಆಯ್ಕೆಯಾದ ಸದಸ್ಯರ ಮೇಲೆ ಜಾರಿಗೊಳಿಸುವ ಸಂಬಂಧ
ಇಲ್ಲದ page 30
ವೈಯಕ್ತಿಕವಾಗಿ ಮನೆಗೆ
31.
ಸ್ವಾಮಿ, 31 ಸ್ವಾಮಿ, 31
31.
ಫಸ್ಟ್ ಪ್ಯಾರಾಗ್ರಾಫ್.
ಹಾ.
ಅಭ್ಯರ್ಥಿ ಆಯ್ಕೆ ಸಭೆಗೆ ನೋಟಿಸು ವಿಪ್ ಅನ್ನು ಕಾಂಗ್ರೆಸ್ ಪಕ್ಷದಿಂದ ಪುರಸಭೆಗೆ ಆಯ್ಕೆಯಾದ ಸದಸ್ಯರ ಮೇಲೆ ಜಾರಿಗೊಳಿಸುವ ಸಂಬಂಧ ವೈಯಕ್ತಿಕವಾಗಿ ಮನೆಯ ಬಾಗಿಲು ಗೋಡೆಗಳ ಪಂಚರ ಸಮಕ್ಷಮ ಅಂಟಿಸುವುದು ಮೂಲಕ ಪ್ರಕಟಣೆ ಹಾಗೂ ಮೊಬೈಲ್ ಫೋನ್ ಮೂಲಕ ಮೆಸೇಜ್ ವಾಟ್ಸಪ್ಗಳ ಮೂಲಕ ರವಾನಿಸಲಾಗಿದೆ. ಫೋಟೋ ಮತ್ತು ವಿಡಿಯೋ ರೆಕಾರ್ಡಿಂಗ್ ಸಹ ಮಾಡಲಾಗಿದೆ. ಅದಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ದಾಖಲೆಗಳನ್ನು ಈ ದೂರಿನೊಂದಿಗೆ ಸಲ್ಲಿಸಲಾಗಿದೆ. Along with, my lord, photographs, video, same is produced before the, my lord, Deputy Commissioner.
ಎವಿಡೆನ್ಸ್ ಆಗಿಲ್ವಾ? ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ವಾ?
The annexure E is the affidavit filed before the authority.
Annexure?
E, annexure F.
ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ?
Agide, that statement is there.
You have produced those COVID certificates.
Yes, yes, that is at page number 30. COVID certificate is also produced, page number
Page number 62.
33 to 42 are the statement and the discharge summary reports.
Number 30?
33 to 42 is the statement along with the discharge summary certificate. Page number 38 is the certificate of the lady member. And
Page 62 is some COVID certificate.
yes, yes. Page number 48 is the RT-PCR test report. Page 48. Of petitioner number 2, one Ashok Kumar. And the test report, RT-PCR test of petitioner number 3, Ashana, is at page 62.
Test report ಎಲ್ಲಿದೆ ಇದು?
ಇದು
Ashok Kumar
positive.
Mahadevappa test
ಹೌದು.
report.
ಇಲ್ಲಿ positive ಅಂತಿದೆ in that very page 48. In the second tabular column, SARS-CoV-2 is tested as positive on 19/10/2020. And that was a period where 15-20 days of isolation was prescribed generally. So this is the second wave of COVID in October 2020.
In 1910 was the date of
Testing as positive.
what is the date of
2/11/2020.
what is the date of the meeting?
2/11.
2/11,
2/11/2020.
Yes, Mr. ಇದೆಲ್ಲ if you don't dispute these documents, then what can be done?
ಅಲ್ಲ, it is not, they have taken file. Therefore, kindly have this not day after tomorrow, I'll collect file from my lord government office and I'll.
Learn counsel for the respondent number
Saturday,
3 time list on
Saturday.
Saturday,
25th.
25th ಆಗುತ್ತಾ? It's 20. Yes. Mahantesh
If
Patil.
there is an interim order, it may be extended. I'm not
Or
sure whether it
extend
is
to the
only
next.
till the next date.
DP Ambekar.
Only one grievance, my lord. Petitioner is a cooperative society.
Hmm.
There is an allegation that it has encroached a portion of public park. A survey was conducted by a committee without any notice to the members of the persons who are who are claimed to be allegedly encroached. Thereafter, my lord, a report was filed.
Hmm.
The report, my lord, it was not accepted by the Assistant Commissioner because of several lacunas. However, my lord, again, the Assistant Commissioner has ordered for resurvey. And in the resurvey order also, there is no direction to issue notice to all concerned. So our apprehension is, they may conduct a survey, they may obtain a report behind or back and proceed directly to demolish without any prior notice.
Yes, who appears for the respondent? Gopal Krishna Yadav.
I'll intimate man, now he becoming government advocate.
He is now government
Whether he
advocate.
has given the no objection to the other. Alternate
The
accommodation.
advocate for the respondent number 4 is disabled to appear in this petition.
Well, I think he is continuing.
Huh?
Continue ಆಗಿದ್ದಾರೆ. Because ಅದನ್ನು government body ಇದೆ, TMC ಇದೆ.
ಅಲ್ಲ TMC
Panel
ಆಗಿದಾರಲ್ಲ.
Panel continue ಆಗಿದೆ.
Yes, what do you want? ಅವ್ರನ್ನ ಕರೆದು ಕೇಳಿ ಅವ್ರ ಸಮ್ಮುಖದಲ್ಲಿ ಮೆಷರ್ಮೆಂಟ್ ಮಾಡ್ರಿ, ಸರ್ವೆ ಮಾಡ್ರಿ.
With that direction, it may be discussed.
ಬರ್ಕೊಳ್ಳಿ. The petitioner has challenged an order dated 18/9/2021, order bearing number so and so dated 18/9/21, passed by the respondent number 2. By which
Next year.
he directed the
Special team, ವಿಶೇಷ ತಂಡ.
by which he directed the special
team, page
Team.
11 ಅಲ್ಲಿ. ಪ್ರಯುಕ್ತ ಹಿನ್ನೆಲೆ.
directed the special team to conduct a survey, identify the sites formed therein and the area encroached,
Alleged.
area of the park,
They claimed alleged.
area of the park allegedly encroached. Full stop. Para. The petitioner contends that it is a cooperative society, cooperative housing society duly registered. Full stop. It claims that it had converted survey number, it claims that it had got the land in survey number 468 of Manvi, Raichur district, converted for non-agricultural use and got a layout approved and formed a layout and distributed the sites to its members in the year 1967. It contends that some third parties had lodged a complaint alleging that some of the allottees had encroached into a public park. Full stop. Following the complaint, the deputy commissioner had constituted a committee comprised of the respondents 2 to 6,
Yes.
2 to 6, with the respondent number 2 being the head of the committee. The respondent number 2 directed the respondent number 4 to look into the issue and submit a report. The respondent number 4 allegedly without issuing notice to the petitioner submitted a report on 4/9/2021. Full stop. However, the said report was rejected by the respondent number 2 in terms of the order dated 18/9/21, and he directed a joint survey by all the members of the team and identify the sites formed in the survey number as well as the alleged encroachment into the park. The petitioner, being aggrieved by the said direction, has approached this court in this writ petition. Next part. The learned counsel for the petitioner contends that in the first instance, the team had submitted a unilateral report without hearing the petitioner as well as its members and the said report was rejected by the respondent number 2. He apprehends that now the respondent number 2 has directed the team to conduct a fresh survey. There is a likelihood of the respondents again submitting a unilateral report, one-sided report. Full stop. The petition is therefore before this court challenging the direction issued by the respondent number 2 to the other respondents. Next para. The learned counsel for the respondent number 4, four submits that in view of the direction issued by the respondent number 2, the petitioner and its members shall be notified and heard before conducting any survey and before determining the boundaries of the sites formed in survey number 468 and before identifying the alleged encroachment into the public park. Full stop. He therefore submits that the apprehension of the petitioner is unfounded and hence the impugned order cannot be disturbed. Next para. The respondent number 2, after rejecting the report of the respondent number 4 and other members of the special team, had directed a proper survey of the land bearing survey number 468 of Manvi and also identify the limits of the sites allotted in the said survey number and to identify the area allegedly encroached by the allottees. This obviously cannot happen without the petitioner and the members of the petitioner being notified and being heard in the matter. Therefore, it is appropriate not to disturb the impugned order, but to direct the respondents to hear the petitioner and the members of the petitioner who allotted sites in survey number 468 of Manvi and then proceed in accordance with law. Hence, the writ petition is disposed of on the above terms and the respondents are directed to hear the petitioner and its members who are allotted sites in survey number 468 of Manvi before taking any precipitative action to identify the park area allegedly encroached into by the members of the petitioner.
Please.
D. Sudha.
My lords, I am appearing online, my lords.
Hmm.
Yes, sir. The petitioner hearing challenging the order at Annexure A, my lords. The petitioner husband has a
Wait,
license in
madam,
form.
let me come to Annexure A. What
Well,
is
sir.
Annexure
Annexure K, my lords.
K?
Please, my lords. Annexure K, my lords, page number 35.
Yes, please.
My lords, sir, page number 41 is the impugned order here, my lords.
Hmm.
My lords, after the proceedings before the Excise Commission has been done, my lords, after following the judgment made by this honorable court, my lords, a direction has been issued to consider the representation.
Is government ready?
Please.
Here.
My lords, the petitioner husband is having CL2 license in the year 1992, my lords. Originally, it has been given, my lords. In 2010, my lords, the petitioner husband died, my lords. Immediately, my lords, the petitioner made a representation saying that the license has to be transferred in favor of the legal heirs of the deceased licensee, my lords. My lords, after, my lords, in 2014, my lords, the amendment has been carried out for 17A, my lords, which says, my lords, my lords, that is amended. Instead of during the currency of the license or lease, it has been corrected as during the currency of the licensee or lease, my lords. To say that that has to be in the after the death of the petitioner, I mean licensee, the license has to be continued, my lords. In this case, my lords, till 2010
So what is the amendment to the rule? What is the amendment to the rules?
My lords, amendment, my lords, that is page number 38 is quoted in the judgment order, my lords, proceedings.
You produced it as Annexure D, page 18.
Please, my lords, that has been also produced, my lords.
What does the rule say?
My lords, 17A may kindly be seen, my lords. In the Karnataka Excise Licenses General Conditions Rules, 1967.
General condition rules,
17A, my lords.
Yes. Yes, please.
Please, my lords. 17A, the words during the currency of the license or lease shall be omitted. That has been omitted, my lords. Saying the same thing, my lords, the commissioner, excise commissioner has been rejected the claim of the petitioner, saying that during the currency of the license, that license has to be continued, since that has been lapsed and it is not renewed when the person has died, the license cannot be renewed in favor of the legal heirs, my lords. That is the contention taken by the authorities, my lord. Now the petitioner is seeking, my lords, the lapsed licenses can be renewed after the payment of the 50% of the license fee for the lapsed period, my lords. Hence, the petition, the second round of litigation, my lords, the earlier order, my lords, may kindly be taken at page number, my lords, 32, my lords, Annexure J, my lords. My lords have considered the writ petition and page number 34, my lords, paragraph number 3. In that view of the matter, this writ petition is allowed. The respondent number 1 shall consider the case of the petitioner as provided under Rule 5A3 of the Rules 1968 and pass appropriate orders within 1 month from the date of the receipt of a certified copy of this order. After this direction, my lords, the impugned order Annexure K has been
So what is this
given.
renewal? You are asking for renewal.
Please, my lords, renewal, my lords, since the licensee is dead, my lord, that has to be transferred as per 17A, my lords. That is the legal heirs of the deceased licensee, my lords. If that is that is permitted, my lords, the petitioner will pay the lapsed license fee as per the rules, my lords, and they will continue the business, my lords. That is permissible under law, my lords.
No, but your husband died in 2010.
Please, my lord, that is the reason they are saying the license it has not been renewed.
No, 2010 only your husband died.
Please, my lords.
And during his lifetime it had lapsed.
Please, my lord, that is the reason they are giving, my lords. Earlier, my lords, before that, my lords.
See, in every case you say that an excise license is always a fresh license.
It is a renewal, my lords. Every year it is renewal. But 543 says, my lords, for the lapsed licenses, we have to pay the 50% for continuity. We have to pay the 50% of the license fee, and we can continue the license fee.
Yes. Where is it? Where is it provided?
Please, my lords,
regarding lapsed
renewal of the license. Please, my lords.
Regarding lapsed licenses, what is the procedure to be adopted for restoration?
Please, my lords, they have to pay the license fee.
What is the procedure?
My lords, the rule says, my lords, for the lapsed license, 554A may kindly be seen, my lords.
Rule?
5, my lords, for continuity of the license, my lords.
Sale of IMFL rules will read them.
Indian sale of foreign liquor rules, my lord.
Sale of Indian and foreign liquor rules.
Please, my lord.
Pudril.
5A, my lord, renewal of license.
Sure, just
business.
$37. ಇದೇ ಬಿಡಿ. Rule 5A.
3 Malus, Rule 5A, renewal of license. 5.3 Malus. The licenses granted prior to the 1st of July 1999 may be renewed at the discretion of the Excise Commissioner or the Deputy Commissioner, as the case may be, on payment of 50% of the license fee prescribed under Rule 8 in respect of the entire period for which license was not granted, for the purpose of maintaining continuity of the license system.
Please read 5A2.
Plus 5A2, my lord. Every such application shall be made at least 1 month before the expiry of the license already granted.
Then read further.
Yes, ma'am. Provided that Excise Commissioner or the Deputy Commissioner, as the case may be, may accept and consider any such application made after the aforesaid period of 1 month, if he is satisfied that the applicant had sufficient cause or not making the application within that period.
Yes.
3 Malus. The licenses granted prior to the 1st July 1999 may be renewed at the discretion of the Excise Commissioner or the Deputy Commissioner, as the case may be, on payment of 50% of the fee prescribed under Rule 8 in respect of the entire period for which license was not granted, for the purpose of maintaining continuity of the licenses. After 99 Malus, the fresh licenses were not given Malus. Prior to that, if the continuity is there, they have to pay the 50%.
Then read further, provided that while renewing the license under this sub
Under this rule, the Deputy Commissioner or the Excise Commissioner, as the case may be, shall ensure that the total number of licenses granted or renewed do not exceed the quota fixed in Rule 12 for grant of each kind of license for an area.
Yes.
Well, they did not say that quota is not there, ma'am. Only they say that the amendment rule says the legal heads during the currency of the licensee, that is, the licensee is to be in the continuation.
Let us see what the commissioner says.
Please, Malars. Annexure K, Malars. Well, it's page number 36, the second paragraph, Malars. The said request was thoroughly examined by the departmental officials, and in turn, they submitted an objective report stating that the applicant, Srimati Ramabai, wife of late Nagendrappa, had not furnished relevant documents such as original license copy, which was previously in the name of the deceased person, blueprint of the license premises, other related necessary documents for consideration. Moreover, it was found that the said CL2 license was renewed last in the year 1991, further discontinued since 91-92. From the year 1991-92 till Sri Nagendrappa, that is in bracket Malas, he died on 18/12/2010, was alive. The license was not renewed and it was in discontinued status, Malas. After that, fellows, the relevant portion, Malas, the writ petition has been said, Malas, the direction has been issued. And then after that inquiry, Malas, now, Malas, the page number 38, Malas. It is pertinent to note that relevant provision of the Karnataka Excise Act and Rules and government notification, that is amendment to rules applicable to the matter on
Is there
hand.
no appeal against this order passed by the commissioner?
Malas, this is the proceedings before the Excise Commissioner, Malas. He is the main authority. Excise Commissioner is the main authority.
Correct, madam. Is this not appealable before the KAT?
Malas, since Malas, this is the renew has been taken after the Excise Commission order, we have to go before KAT, Malas.
Yes, sir. Excise commissioner has passed the order.
It is the proceedings, Malas. Appeal after the appeal, Malas, commissioner's order, Malas, we have to go before the KAT, Malas.
No, but annexure case, the order passed with the excise commissioner.
It says, Malas, office proceedings, Malas, that is the reason why we
Hello,
cannot
last
go.
order is there, page 41.
Please, they say, Malas, it is only order that is.
But if it's an order, then you have to go before the KAT, Alva.
Malas, KAT, it is any order passed by the Excise Commissioner, Malas, in appeal, that has to be go before the appellate tribunal, Malas. It is very proceedings,
Yes. Proceedings ಹೆಂಗಮ್ಮಾಗುತ್ತೆ?
It is an order, my lord, rejected.
Well, as office proceedings of the Excise Commissioner in Karnataka, Bengaluru, that is the headline.
Please read the, yeah, the rules.
61-2, my lords.
61 to what the Excise Act.
Please, my lords.
Hmm.
Plus appeals, my lords. Karnataka Excise Act. Any
Hmm.
person aggrieved by an order passed by any officer other than the Excise Commissioner or the Deputy Commissioner under this Act may within 60 days from the date of communication of such order appeal to the Deputy Commissioner. That is Revenue Minister. Any person aggrieved by an order passed by the Deputy Commissioner under this Act may within 90 days from the date of communication of such order appeal to the Excise Commissioner. 61-3, my lords. Any person aggrieved by an order date passed by the Excise Commissioner under subsection 2 may within 90 days from the date of communication of such order appeal to the Karnataka Revenue Appellate Tribunal.
Hmm. So then you have to go before the appellate tribunal, alva?
My lords, this order cannot be exercised in the appeal, my lords.
Why?
Since it says proceedings, my lords.
Now, how do you say it is proceedings, madam?
My lords, in Annex K, the headline says, my lords,
Hmm.
office proceedings of the Excise Commissioner in Karnataka, my lords. My lords, based on the proceedings of the Excise Commissioner.
Madam, please don't argue this way. Office proceedings of the Excise Commissioner ಅಂದ್ರೆ ಏನು? Proceedings does not result in an order, is it?
My lords, it says, my lords, any appeal order, my lords. ಅಂದ್ರೆ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಆಫ್ ಎಕ್ಸೈಸ್ ಮಾಡಿರೋ ಆರ್ಡರ್ ನಾವು ಎಕ್ಸೈಸ್ ಕಮಿಷನರ್ ಮುಂದೆ ಅಪೀಲ್ ಅಲ್ಲಿ ಹೋಗ್ತೀವಿ. ಸೊ ದಟ್ ದಿಸ್ ಇಸ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಂತ ಹೇಳ್ತಾರೆ.
Yes, not, accordingly, it is appropriate to pass the following order. Word is used following order. Operative portion ಮೇಲ್ಗಡೆ.
Yes, madam. Please go to page number 37.
Please, my lord.
What was challenged in the writ petition?
My lords, writ petition, my lords.
Where is the writ petition order?
It is in Annex D, my lords. Annex J, my lords, page number 32.
Page number?
32, my lords. This writ petition is filed under Article 226, 227 of the Constitution of India, praying to allow the petition and direct the respondent number 1 to consider the representation dated 13/1/2020 by Annexure E in accordance with the Rule 5A, Sub-Rule 3 of 1968, in accordance with law, in the interest of justice and equity. That is to consider the representation. We have approached this honorable court members.
It's very unfortunate, madam. Joint Commissioner had issued an endorsement dated 17/7/2017.
Please, my lords.
You did not challenge that before the Excise Commissioner under section 61(2).
Because earlier we have already approached
Correct,
this honorable court.
but how
Please, my
many?
lords.
You can't take advantage of your own mistake.
Please, my lords.
Instead
Then
of
we
going
have
before
to
the appellate
approach.
authority,
Please, my lords.
instead of going before the Excise Commissioner, you came to this court, sought for a mandamus. Now, the Excise Commissioner has passed an order.
Please, my lords.
We'll direct you to go before the tribunal only.
Please, my lords.
Barcode. The petitioner has challenged an order passed by the respondent number 1, rejecting the request of the petition, rejecting her request for transfer of a license in CL2 CL2, full stop. Next. The petitioner contends that her husband was granted with a license in CL2, was granted with a license in Form CL2 during the year 1990, during the year
92 months.
During the year 1990-91, which was however discontinued from the excise year to 1991-92. Full stop. Later, the husband of the petitioner died on 18/12/2010 without getting the license renewed. Thereafter, the petitioner filed an application for renewal of the lapsed/discontinued license and to transfer it to the name of Messrs. Babbaladkar Wines, a partnership firm purportedly constituted amongst her children. Full stop. The Deputy Commissioner of Excise did not renew the license following which and a letter dated 17/7/2017 was communicated to the petitioner. Despite that, the Deputy Commissioner of Excise again, in terms of a letter dated 23/1/2020, sought directions from the office of the respondent number 1 regarding consideration of the applicant's request dated 13/1/2020. Full stop. The petitioner then filed WP number 201542 of 2021, seeking for a direction to consider the request of the petitioner. This court disposed of the said writ petition in terms of the order dated 25/8/2021 and directed the respondent number 1 to consider the case of the petitioner as provided under Rule 5A(3) of the Rules 1968 and pass appropriate orders. For said direction, the respondent number 1 has held proceedings and has passed the impugned order refusing to transfer the license, refusing to entertain the request of the petitioner. Full stop. Being agreed with the same, the petitioner is before this court. The learned counsel for the petitioner contends that under Rule 5A(3) of the Karnataka Excise Sale of Indian and Foreign Liquor Rules 1968, a lapsed license can also be renewed subject to the condition that the petitioner pays up 50% of the license fee for the previous years. She further contends that Rule 17A of the Karnataka Excise Licenses General Conditions Amendment Rules 2014 is amended and the words during the currency of the license or lease is omitted, thereby meaning that even a lapsed license would be renewed. Full stop. Thus she contends that the respondent number 1 misdirected himself in holding not be renewed. Full stop. Per contra, the learned EGA submitted that the petitioner has not disclosed true and correct facts before this court when WP number 201542 of 2021 was filed. He contends that by the time the writ petition was filed, the Deputy Commissioner of Excise had already rejected the request of the petitioner by an order dated 17/7/2017. Therefore, the petitioner was bound to challenge the said order before the appropriate authority as provided under Section 61(2) of the Excise Act 1966, full stop, 65, full stop. He therefore contends that the petitioner, who has now challenged the order passed by the respondent number 1, has to be relegated back to the remedy of an appeal prescribed and provided under orders section 61(3) of the Excise Act 1965 by considering the proceeding before the respondent number 1 as a proceeding under section 61(2) of the Act 1965. Full stop. Besides this, he contends that the license had expired in the year 1991 and the licensee did not make any attempts during his lifetime to get the same renewed or restored. He contends that the husband of the petitioner died on 18/12/2010 and therefore the license stood lapsed. Full stop. He contends that under Rule 5A, the petitioner is not entitled for renewal of the license as the provision is made for renewal of the license within 30 days from the date of its lapse and not for several years, not after several years of its lapsing. Next para, consider submissions made by the learned counsel for the petitioner and the learned AGA. Next para. The initial request of the petitioner for transfer of the license and renewal was rejected by the Deputy Commissioner of Excise, Kalaburagi District, in terms of the order dated 17/7/2017. The same is found from the impugned order passed by the respondent number 1. Full stop. Ideally, the petitioner must have challenged the said order before the respondent number 1 in an appeal under section 61(2) of the Excise Act 1965. However, the petitioner seemed to have colluded with the Deputy Commissioner of Excise by submitting another letter dated 23/1/2020 for renewal of the license, following which the Deputy Commissioner had addressed a communication dated 13/1/2020 to the respondent number 1. Full stop. The petitioner thereafter followed it up by filing a writ petition before this court and obtaining a direction to the respondent number 1 to consider the request for transfer and renewal of license. Full stop. This court directed the respondent number 1 to consider the same in accordance with law and as provided under Rule 5A3 of the Rules 1968. Full stop. As rightly contended by the learned AGA, the petitioner is guilty of suppression of material fact in not disclosing the order dated 17/7/2017 passed by the Deputy Commissioner of Excise, Kalaburagi. Full stop. Therefore, the order passed by the respondent number 1 in this rejecting the request of the petitioner shall be construed as an order passed under section 61(2) of the Excise Act 1965. Accordingly, the petitioner is bound to challenge the order passed by the respondent number one before the Karnataka Appellate Tribunal. Hence, this writ petition hence this writ petition cannot be entertained. And the petitioner cannot be allowed to short circuit the remedy of an appeal prescribed under the Act. Hence, the writ petition is dismissed. However, liberty is reserved to the petitioner to file an appeal before the tribunal as provided under section 61(2) of the Excise
Three.
Act 1965.
3, my lords, 61-3.
Not 2 minutes.
61(3), yes.
Please, my lords. Obligation.
ನೋಡಿ 4 ವರ್ಷ ವೇಸ್ಟ್ ಮಾಡ್ಕೊಂಡ್ರಿ ಇಲ್ಲಿ. Yes, next. We'll take it up at 2:30.
My lord, one submission. One more for tomorrow election matter, my lord.
Yes.
File ಮಾಡಿ
ಫೈಲ್ ಮಾಡಿ ನಂಬರ್ ಎಲ್ಲ ಹಂಗ್ ನಂಬರ್ ಇಲ್ದ್ರೆ ಮುಂಜಾನೆ ಮೆಮೊ ಮೂವ್ ಮಾಡ್ತಿದ್ದೆ. ಕೊಡ್ರಿ ನಾನೇ ಕೊಡ್ತೀನಿ ಕೊಡ್ರಿ.
Court officer. Court officer. Court officer, ಯಾವ ಲಿಸ್ಟ್ ತಗೊಂಬೋದು ಫಸ್ಟ್ ಪಾಸ್ವರ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ತಗೊಂತಾರ?
Lordship, I am withdrawing.
Number 5.
Five.
You withdrawing the petition?
Yes, my lord.
Learned
Become
counsel
infect-
for the petitioners filed a memo to withdraw the writ petition. In view of the memo, the petition is dismissed as withdrawn.
Relax.
Huh? ಬೆಳಿಗ್ಗೆ ಏನೋ ಆಯ್ತಲ್ಲ ಏನು?
I have made an inquiry to client for correct address. He has told that inquiry has been completed. We have challenged the appointment of inquiry officer, my lord.
ಅಲ್ಲ ಬೆಳಿಗ್ಗೆ ಏನೋ ಇದಾಯ್ತಲ್ಲ ಏನಾಯ್ತು? ಬೆಳಿಗ್ಗೆ ಏನೋ ಬೆಳಿಗ್ಗೆ I asked you something. ಬೆಳಿಗ್ಗೆ ಏನೋ ಸ್ವಲ್ಪ ಏನೋ ಇದಾಯ್ತಲ್ಲ ಮಾತಿನ ಜಕ್ಕಮಕ್ಕಿ ಆಯ್ತಲ್ಲ.
For cause list.
Huh?
To get the cause list.
Office note, my lord, is regarding death, my lord, of one of the appellant who has died, my lord, unmarried and issueless.
ಇದಾಯ್ತು. Accepted the,
Please, my lord.
your colleague wanted a passover.
What he probably, my lord,
Your colleague wanted a passover. ಬೇಡವಾ?
notice has to go, my lord.
Yeah, what is the writ petition about?
Writ petition, my lord, the construction permission was obtained, the construction, my lord, is being put in accordance with law. What has happened, my lord, there are two survey numbers, my lord, which have particularly, my lord, merged at one point. Now, my plot, there is no dispute with respect to the fact, my lord, that my plot is measuring 16 to 40 and my construction is well within that 16 to 40. Now, the difficulty is so happened, my lord, my neighboring plot owner, whose plot is, my lord, beyond the road, situated, my lord, adjacent to my plot. He feels, my lord, that the road, size of the road has shrunk.
Issue emergent notice. ಯಾರು commissioner ಯಾರು?
Commissioner, Municipal Corporation, panel advocates, my lord, Mr. Krupa Sagar Patil is there.
Krupa Sagar Patil is there. So respondent.
Please.
ಕೊಟ್ಟಿದ್ದಾರಾ? ಯಶಸ್ ದೀಕ್ಷಿತ್ ಪ್ರೋಸೆಸ್ ಕೊಟ್ಟಿಲ್ಲ? ಬಂದು ಹೇಳ್ಬೇಕಲ್ಲ. 1 week time is granted to do the needful. Yes. Lakshmi ji.
My lords, for the petition, my lord. My lords, it sought for an upgradation for class number 9 and 10.
Pardon?
My lords, I had sought for an upgradation for classes 9 and 10. Currently, there are around 150 to 200 students in our institution, my lords. It's a fully functioning institution up to 1 to 8.
But you are directed to produce some documents.
My lords, I'll come to that, my lords. My lords, the issue in this writ petition is, they have basically rejected our application based on the ground that we have not produced the land conversion order and the registered sale deed. My lords, with respect to the land conversion order, I have one, the rules of Karnataka Education Institution Prescription of Curricula 2022, which came to be amended, which exempted the institution falling within the limits of Gram Panchayati from obtaining a land conversion, my lords. And further, there is no such mandate under any of the statute requiring an institution to compulsorily take any registration, registered document. My lords, I'm fully functioning institution from 1 to 8. My lords, now they have, I'm not able to, my lords, under
Mr. Correct, what you say is right.
Yes, my lords.
But there should be some document to show that you are having some right or some property where you are running the school.
Yes, my lords, with respect to that, I
It
have
could be a
attached
lease deed,
valid.
it could be a sale deed, it could be anything there, but there should be some document to show
Yes, my lord. Valid building plan sanction, I have annexed it, my lords, at page number 48.
Where is is there any lease in your favor?
Yes, my lords. I have attached it at annexure. Annexure A, my lords. Starting from page number 15. For a period of 30 years. They have no problem.
ಇಲ್ಲಪ್ಪ ಇದೆ annexure A ಎಲ್ಲಿದೆ? This is a trust, this is a trust deed.
No, my lords. So starting from the next page.
Annexure A is the trust deed.
Yes, my lords.
Where is the lease deed?
But lease deed was also produced along with the memo circulated in the office.
Put it R sheet.
Please, my lords, at page number 46, my lords.
Please go to the order dated 28/8/24.
Yes, my lords.
Comply with the order dated 28/8/24.
Yes, my lords. My lords, it requires us to produce the originals. My lords,
Do whatever you want, mister. Whatever you have documents, you produce. Learned counsel for the petitioner is directed to comply the order dated 28/8/2024 within 1 week.
date may be given, my lords.
Failing which, the interim order granted on so and so date shall be taken up for reconsideration. List on date kodi yavat. First,
February, any date convenience to your lordships.
1st February.
Grateful, my lords.
Literally, IA 1 of 25 is not pressed.
Not pressed, my lords.
Hence the same is rejected. Yes, next.
Grateful, my lords.
ಮಾಡಿದಾರಾ?
I appear for my lord on behalf of Ganesh.
I have amended the cost title.
Learned counsel for the petitioner has amended the cost title. Office director check and verify. Ready?
In view of, my lord, yes. In view of interim order, no confidence proceedings are stayed. Challenge here in this writ petition is validity of section 49 amendment.
Yes,
I will not press that prayer, man.
ಆಯ್ತು, next ಹೇಳಿ.
Next, impugned order, impugned notice is under challenge. This honorable court already granted interim order.
ಆಯ್ತು, next ಹೇಳಿ. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಕೊಟ್ರೆ ಅಲೋ ಆಗ್ಬೇಕು ಅಂತ ಏನಿಲ್ವಲ್ಲ?
ಇಲ್ಲ, ಏನ್
ಹೇಳಿ, ಕೇಸ್ ಏನು ಅಂತ ಹೇಳಿ.
Your article may kindly dispose of this writ petition with a direction to the impeding applicants to make fresh no confidence.
No. We'll direct the assistant commissioner to take out fresh, fix a date based on the same representation.
Yes.
ಮತ್ತೆ ಸುಮ್ಮನೆ ಯಾಕೆ ಸ್ಟೇ ಏನ ಕೊಟ್ಟಿದ್ರು? On what ground the proceedings have stayed?
Constitutional validity of section part.
ಸುಮ್ಮನೆ ಕೇಳಿದಕ್ಕೆಲ್ಲ ಸ್ಟೇ ಕೊಟ್ರೆ ಹಿಂಗೆ The petitioner being the president of Gram Panchayat Hebbal, Nidugundi Taluk, Vijaypur district, has filed this petition challenging the notice dated 15/11/2024 issued by the respondent number 3, convening a meeting of the members of the Panchayat on 2/12/2024 to consider a motion of no confidence.
Already period of 5 years has been completed.
Full stop. 5 years, sir?
Period has been completed. First term is completed, second term also completed.
You completed both the terms.
Both the terms are completed.
ಮತ್ತಿನ you'll ಮುಗಿತಲ್ಲ ನಿಮ್ದು. Then writ petition has become infructuous.
Infructuous. Yes,
Yes.
Infructuous ಆಗಿದೆಯೇನ್ರಿ? Correct ಆಗಿ ಹೇಳ್ರಿ.
yes, infructuous. Already 5 years period is completed.
2020, 24, no confidence. No.
The election to the post of Adhyaksha and
Yes.
Upadhyaksha was held on 2/2/2025 for a period of 5 years. Term of the election
20
will be-
election.
ಇನ್ನ 25 ಇದೆಯಲ್ಲ?
ಹೌದು.
Up to 25 ವರೆಗೂ
They
ಇದೆ.
are elected, my lord, on 30/12/2020. Election certificates are at page 14. They are elected on 30/12/2020.
President and
Petitioner-
as a president, he
Petitioner
has
was-
been,
The petitioner was elected as a president of the Panchayat on 2/8/2023. Full stop. For the remainder term of 30 months. Full stop.
that
The Panchayat comprised of its numbers, how many
Lord,
members?
11,
11 members.
11 members,
13, my lord, sorry.
13 members, of whom 11 members who expressed lack of confidence in the petitioner submitted submitted a representation in form number 1 on 5/11/2024 requesting him to convene a meeting to consider a motion of no confidence. Following this, the respondent number 3 issued a notice on 15/11/2024 convening a meeting on
2/12/2020.
2/12/2024. The petitioner is therefore before this court challenging the said notice. Next para. The learned counsel for the petitioner contends that contends that section 49 of the Act of 1993 is prospective in nature. And the amendment to the said section is not applicable to an election that is already conducted on 6/2/2021.
20. 20.
Learned counsel for the petitioner contends that that once an election to the post of president is declared for a period of 5 years, the subsequent amendment to section 49 of the Act cannot affect those who are already elected. ಏನೇನೋ ಗ್ರೌಂಡ್ಸ್ ಹಾಕಿದ್ರೆ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗಲ್ಲ ಗ್ರೌಂಡ್ಸ್. ವಾಟ್ ಆಲ್ ಗ್ರೌಂಡ್ಸ್ ಯು ಟೇಕನ್? It is all, he also contended that as per section 49(2), no representation can be moved expressing lack of confidence in the president unless specific allegations are made in the representation. Full stop. Next paragraph. The learned counsel for the private respondents, on the other hand, contended that the representation filed by the private respondents was pursuant to section 49(1), and therefore there was no need to to make any allegation against the functioning of the petitioner. He submits that the procedure adopted, submits that the procedure for a no confidence motion against the petitioner is in accordance with the procedure for the no confidence motion is in accordance with the procedure prescribed under section 49(1) and under the rules 1994. He also contends that the petitioner was elected as the president at the elections that was held on 2/8/2023. And therefore, the petitioners are entitled, therefore, the private respondents were entitled to move a no confidence motion against the petitioner on 15/11/2024. Next, I consider submissions for the learned counsel for the petitioner and the learned counsel for the respondents. Next paragraph. Though the petitioner, though the the minimum term within which a no confidence motion could be moved, the learned counsel submitted that, since the learned counsel submitted that he would not press that point, this court has not considered it. Full stop. However, insofar as the contention that the representation in form number 1 submitted by the private respondents must have contained some allegations, it is relevant to note that the members are entitled to move a representation expressing lack of confidence without really mentioning any allegation under section 49(1). Therefore, in the instant case, the private respondents have moved such a resolution, and the respondent number 3 has taken further steps to convene a meeting of the members to consider the no confidence motion. Full stop. Therefore, there is no error in the procedure adopted by the respondent number 3 warranting interference in this petition. Next paragraph. Hence, the petition is dismissed. Full stop. However, since the meeting dated 17/12/2024, 24 could not be held in view of an interim order granted by this court, the respondent number 3 shall convene a fresh meeting on the same representation within a period of
One week,
rules could
minimum 10 days. 30 days.
adjournment in idea within a period of 30 days from today. 30 days from the date of receipt of a copy of this order.
Right.
For the petitioner, Your Lordship.
Oh.
Petitioner is a student, Your Lordship, pursuing a Bachelor of Engineering course. He was permitted to attempt, Your Lordship's 7th semester out of 8 semesters exams, Your Lordships, and he has cleared all the subjects, but he was not permitted to appear for 8th semester examination. It is for that reason, Your Lordships, the present petition was filed. Now, in fact, Your Lordships, another 2 opportunity has been granted by the university by themselves.
Then this petition has become.
Your Lordships, I am seeking a revaluation, Your Lordships, revaluation of the exam which I have appeared. That's
No, where is the question of revaluation now?
if he clears your lordships that subject in the revaluation,
Mr. You, this also you will lose. The opportunity.
your lordships, in fact, he has applied for it, your lordships.
If he has applied for it, then he cannot seek for revaluation. ಇಲ್ಲ ಇತ್ತವಳಿ ಇಲ್ಲ ಹತ್ತವಳಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಡೇಟ್ ಮುಗ್ದೋಗುತ್ತೆ ಅಂತ ನಾನೇ ಅಪ್ಲೈ ಮಾಡ್ಸಕ್ ಹೇಳಿದ್ದೆ.
Therefore, you take advantage of this notification.
Revaluation ಒಂದು ಕೊಟ್ಟಿದ್ರೆ, your lordships, if he clears that subject, your lordships, he is not required to, your lordships, appear in that subject.
Yes. Revaluation, again, we have to constitute some authority, ಯಾರನ್ನ ಕರೆದು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಯೂನಿವರ್ಸಿಟಿನೇ.
Why revaluation? What is the ground?
Your lordships, there is only difference of, your lordships, 6 marks.
6 or 5. You should make out a ground for revaluation.
ಇಲ್ಲ, revaluation by default ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. ಇದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು, ನಾವು by way of an order, interim order, we have appeared in the examination.
Only the revaluation by default.
Your lordships, it was required to be submitted.
Whether the rules provide for revaluation.
Yes, your
Only the
lordships.
source.
I have not bought the rules, your lordships. It is,
Please bring the rules.
it could be passed over, your lordships. I will bring the rules itself.
So Shanwara, list on Saturday.
Yes.
AM Nagara.
Yes, very.
Ready na? You are ready?
Your lordship has directed the office to secure the disposal matter
Ah.
where PDO signs.
Kudri ಅದೇನು?
ನೋಡಿದೆ ಅಲ್ಲಿ ಸೇಮ್ ಇದೆ ಸರ್.
Yes, madam. Yeah. Yes, Mr. Same.
Please, please. With liberty, my lord.
The petitioner has challenged a notice
CC1.
bearing number so and so dated so and so issued by the respondent number 1. Respondent number 3. Convening a meeting of the members of the Panchayat on 26/12/2024. Notice of no to consider no confidence motion. Next para, the petitioner being the president of a Panchayat.
Two petitioners, president and vice president.
Ibrahim. The petitioners being the president and vice president of Gram Panchayat Madhawavi have filed this petition challenging a notice issued by the respondent number 3, convening a meeting of the members on 26/12/2024 to consider no confidence motion. The only contention urged by the petitioner in this writ petition is that the representation filed by the private respondents in form number 1 was placed before the Panchayat Development Officer, who endorsed on the representation that the private respondents were the members of the Panchayat. It is contended that the Panchayat Development Officer has no role to play in the no confidence process. Has no role to play in the process leading up to the no confidence motion. Therefore, it is contended that the entire process is vitiated. In support of this contention, reliance is placed on a judgment of a coordinate bench of this court in WP number so and so, where in similar circumstances, this court held judgment ಕೊಡ್ರಿ ಇದು ಆ ಕೇಸ್ ತರ್ಸಿದ್ರಲ್ಲ ಜಜ್ಮೆಂಟ್ ಕೊಡಿ this ಕೊಡಿ ತಗೊಳ್ಳಿ. This court held paragraph number 10 full stop. The coordinate bench therefore set aside the notice. Therefore quashed the notice, but reserved liberty to the private respondents therein, as well as the assistant commissioner to proceed in accordance with law. Full stop. Next para. The learned counsel for Full stop. The learned counsel for the petitioners therefore prays that a similar order be passed in this writ petition also. And the impugn notices dated 9/12/2024 be set at naught. Full stop. The learned counsel for the private respondents submitted that the issue is squarely covered. Learned counsel for the private respondents did not dispute the fact that the issue raised in this petition is squarely covered by the judgment of this court in WP number 203171 of 2024. Full stop. The learned AGA also did not dispute the said fact. In that view of the matter, this petition is allowed and the impugn notices issued by the respondent number 3 dated so and so, convening a meeting of the members of the Panchayat on so and so is quashed. However, liberty is reserved to the private respondents as well as the respondent number 3 herein to submit a fresh representation. Private respondents, liberty is reserved to the private respondents herein to submit a fresh representation strictly in accordance with form number 1. And the respondent number 3 shall proceed strictly in accordance with Rule 3(2) of the Rules 1994. Yes.
Please.
Problem.
Hema Kulkarni. Bajaj Housing. Oh,
I appear for petitioner, my lord.
yes, please.
Petitioner is the respondent before trial court, my lord. Petitioner has taken loan amount of 20 lakh from the respondent, my lord, on 2018.
What have you challenged?
Improved order at Annexure B, warrant issued by trial court, property attachment, possession of the property, my lord.
ನಿಮ್ಮ section 14 order ಅಲ್ವಾ ಇದು?
Yes, my lord.
ಮತ್ತೆ
Possession of the property, my lord.
ಯಾವಾಗ ಕಟ್ತೀರಾ? When will you pay the money?
25% within 4 weeks. my lord.
25% I will not entertain. If you are willing to pay 50%, I can only give you some time. 50%.
25% within.
ನಿಮ್ ಸೀನಿಯರ್ ಕರ್ಕೊಂಬಂದು 50% within 4 weeks
Please, my lord.
and another 50% within the next 4 weeks.
Please, my lord.
Barkoli issue notice
Respond number 2, it may be dispensed.
since the,
Respondent number 2 is maybe dispensed. my lord.
who is respondent number 2?
Guarantor, my lord.
Issue notice to respondent number 1, memo kodi.
Please, my lord.
Notice to the respondent number 2 is dispensed in view of a memo filed by the learned counsel for the petitioner. Next para. Since the petitioner, though this writ petition is not maintainable, in view of an efficacious remedy by approaching, in view of an efficacious remedy available to the petitioner before the debt recovery tribunal, since the petitioner submits that she is willing to pay the outstanding amount to the respondent number 1, if suitable time is granted, if reasonable time is granted, the impugned order is stayed, subject to the petitioner depositing 50% of the outstanding amount with the respondent number 1 within a period of 4 weeks from today, and also undertake to deposit the balance within the next 4 weeks.
Some regulation is necessary.
Huh?
One regulation ಬೇಕಾಗಿದೆ kindly pass on.
So, Mahadev Patil.
Please, my lords. Petitioners are the owner of the layout which is framed in survey number, my lord, 304.
Petitioners are the owners of the layout.
Layout, my lord. Their father has converted the land into non-agriculture, subsequently obtained, my lord, permission from the competent authority, my lord,
Hmm,
for the residential purpose, my lord.
yes.
My lord, subsequently, my lord, in that layout, my lord, some portion has been enmarked for the garden and some portion has been given to the civic community sites, my lord. Now, Lord, the respondent Gram Panchayati, they have constructed the, my lord, Gram Panchayati in the area which is reserved for the, my lord, park area, my lord. And moreover, the further constructing, my lord, toilets in the public road, which is
ನೀವು ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ.
ರಿಲಿಂಕ್ವಿಶ್ ಮಾಡಿದೀರಾ? ಎಲ್ಲಿದೆ ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಡೀಡ್?
ರಿಲಿಂಗಿಶ್ ಡೀಡ್ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಪಂಚಾಯತಿ ಬಿಟ್ಕೊಡ್ಬೇಕಲ್ಲ?
ಕೊಟ್ಟಿದ್ದೀರಿ ಎಲ್ಲ ಇದು.
ಎಲ್ಲಿದೆ? ವಾಟ್ ಇಸ್ ದೇರ್ ಟು ಶೋ ದಟ್ ಯು ರಿಲಿಂಕ್ವಿಶ್ಡ್ ಇಟ್ ಇನ್ ಫೇವರ್ ದ ಪಂಚಾಯತ್?
ಅದು
ಪಂಚಾಯತಿಗೆ ಬಿಟ್ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ ಏನಿದೆ?
it is obtained under the, my lord, ನಗರ ಸಭಾ ಇದು ಟೌನ್ ಅಂಡ್ ಪೆಂಟ್ರಿ ಕಾಲೋನಿ ಆಕ್ಟ್ ಪ್ರಕಾರ.
ಹೌದಪ್ಪ, ರಿಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಬಿಟ್ಕೊಡ್ಬೇಕಲ್ಲ ಪಂಚಾಯತಿಗೆ. ಬಿಟ್ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇವೆಲ್ಲ ಬಿಟ್ಟು ಕೊಟ್ಟ ಮೇಲೆ ಇದು ಅಪ್ರೂವ್ ಇಲ್ಲ, ನಾಟ್ ಅವೇರ್ ಆಫ್ ದಟ್.
Don't jump to conclusions.
I was not aware of that.
Please check that.
ಹಾ.
ಇದೇನ್ ಸಾರ್ವಜನಿಕ ರಸ್ತೆಯಲ್ಲಿ ಟಾಯ್ಲೆಟ್ ಕಟ್ತಾ ಇದಾರ?
ಹೌದು, ಫರ್ದರ್ my lord, they are constructing toilet in the, my lord.
The Panchayat constructing toilet, my lord, in the area of Panchayat land, my lord.
No, but are you constructing in an area reserved for park and civic community?
My lord, the Panchayat building constructed in the property number 791, my lord, which is measuring 18 to 21 meters land, my lord. In the which is reserved for, my lord, park, my lord.
So therefore, how can you construct a toilet in a park?
Toilet in not park, my lord, which is in Panchayat land constructing, my lord.
If you are constructing in Panchayat property, why will you come to the High Court?
Panchayat building work, our contestation was Panchayat building work
Instruction
constructed.
ತಗೊಳ್ರಿ. Please take proper instructions, ಸಂಗನ್ ಬಸವ.
Please, my lord.
ಈ ಪಂಚಾಯತಿ ಪ್ರಾಪರ್ಟಿಲಿ ಕಟ್ತಾ ಇದ್ರೆ ಅವ್ರ ಯಾಕೆ ಹೈಕೋರ್ಟ್ ಯಾಕೆ ಬರ್ತಾರ ಅವರು?
ಅವ್ರು ಟಾಯ್ಲೆಟ್ ಕಟ್ತಾ ಇದ್ದು ಪಬ್ಲಿಕ್ ರೋಡ್ ಅಲ್ಲಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಟಾಯ್ಲೆಟ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇರೋದು ಪಬ್ಲಿಕ್ ರೋಡ್ ಅಲ್ಲಿ ಹೇಳ್ತಿದ್ದಾರೆ. ಬಟ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಪಬ್ಲಿಕ್ ಪ್ರಾಪರ್ಟಿ, my lord.
ಏನ್ ಮಾಡ್ತೀರಿ? Get proper instructions.
Yes, my lord.
Not only, my lord, they have constructed the Panchayat office in the area which is reserved for the park, and further, my lord, obstructing in the road
So
area.
if you are constructed in the park area, we'll get it demolished.
I take instruction, my lord, and file objections.
ಯಾವಾಗ ತಗೋತೀರಿ? ಶನಿವಾರ?
ಇಲ್ಲ ಶನಿವಾರ, but next week also.
ನೆಕ್ಸ್ಟ್ ಶನಿವಾರ?
31st, my lord.
31st is Saturday.
Friday, my lord, 31st.
ಒಂದನೇ ತಾರೀಕು ಶನಿವಾರ. ಶನಿವಾರನೂ ವರ್ಕಿಂಗ್ ಇದೆ?
Yes. First sitting.
First.
Yes, yes.
Learned counsel for the respondent number 6 seeks time to secure instructions from the respondent number 6. List on first. Yes, Hema Kulkarni.
Writ of mandamus, my lord, sir.
You already received the compensation? ಮತ್ತೆ?
Now,
ಬರ್ಕೊಳ್ಳಿ.
till 15 years. my lord, sir,
Petitioner has filed this writ petition seeking for a writ in the nature of mandamus.
it considered in accordance with law.
No, Mr. ಕಾನೂನಲ್ಲಿ ಏನೋ ಇದ್ರೆ ಹೇಳಿ ನಿಮಗೆ. If you have a right, I can direct. We cannot create a right for you. The petitioner sought for a writ in the nature of mandamus to direct the respondents to return the lands in question, to return the land bearing survey number 90 and 91.
One sub-
90, 90,
One similar matter, my lord, sir, same
90, 91, 93, 109 of Badepur, Kalaburagi Taluk and District, which was acquired but not utilized. Next para. The petitioner contends that he was the owner of the aforesaid lands. Petitioner contends that his father was the inamdar. Petitioner contends that, the above lands were endowed to the village office of Inam, a village office. And his father was the inamdar, who died on 28/10/2008. He contends that the aforesaid lands were acquired by the respondent number 1 for the purpose of establishing a college campus. And compensation was granted to his father. His father thereafter filed an application seeking reference, and the proceedings were referred to the civil court in LAC 51/1966. And the compensation was enhanced in terms of the order dated 13/10/1976. The petitioner contends that though the land was acquired for the purpose of establishing a college campus, but the same is not utilized. Therefore, the petitioner caused a notice calling upon the respondents to return the land. The petitioner contends that though the notice was served, the respondent has not taken any action to return the land and there is therefore before this court seeking for a writ in the nature of mandamus to direct the respondents to consider his request. Next para. The learned counsel for the petitioner reiterated the above contentions and contended that if the land that was used for a particular purpose was not used for the said purpose, the petitioner is entitled to claim back the said land. Full stop. He submits that the petitioner is also willing to refund the compensation already received against reconveyance of the land acquired. Thus, he contends that the respondents are bound to consider the request of the petitioner. Per contra, the learned AGA submitted that the land in question was acquired way back in the year 1964.
Yes, ma'am.
64.
58, my lords.
In the year 1958. 1958 and compensation, enhanced compensation is already paid to the father of the petition, to the petitioner, to the father of the petitioner.
Yes.
In LAC 51/1966, he submits that the land is now vested in the state government and the state government is entitled to use the property for any public purpose and the petitioner cannot compel the respondents to reconvey the land. Next para. The relief of a writ in the nature of mandamus can be issued only when we issued directing a public authority to do or forbear to do or forbear from doing any act which is prescribed, any act which is recognized as a statutory duty under any statute. Full stop. In the case on hand, the land in question was admittedly acquired in the year 1958. And the compensation, enhanced compensation was given to paid to the father of the petitioner in the year 1976. Therefore, the petitioner cannot now claim that the land in question was not used for the purpose for which it was acquired and that he is entitled to get back the land. The petitioner was unable to point out to any provision of any law which invests such a right in the petitioner. Consequently, no mandamus can be issued to the respondents to consider reconveyance of the land in question to the petitioner. Hence, the petition is dismissed. Learned AG is permitted to file a memo of appearance within 10 days.
Please, please.
I must directing the respondent authority to issue e-khata.
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 Yes, Mr. A.
I have to submit that to my head office.
Well,
Because in this present case, my lord, what happened? They are claiming that they are the owner of the site which was allotted in the general body meeting of a municipality, my lord. As per the annexure A, they are seeking that this property was allotted. Kindly see page number 10, my lord.
Page number 9.
Typed copy 10. Decision of the council. Every decision of the council has to approved by the state, my lord. In this case, what happened? This is the only council has approved the issue, my lord. Thereafter, it was sent to the state, my lord. The state was not occurred any permission, my lord. And in the meantime, we came to know that, my lord, this property is not a CA site, my lord. It is a park. Park, no authority has having a jurisdiction to allot the park area to the any institution, my lord. Hence, they are not entitled to get any mutation, my lord.
ನೀವು mutation ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ಮುಂಚೆ ಹೆಂಗಿದ್ರೆ?
ಮ್ಯೂಟೇಶನ್ ಮಾಡಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪರ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ 1985.
ಅಲ್ಲ ಅದು ಅವಾಗ ಅದನ್ನೇ 88 ಅಲ್ಲಿ ಮಾಡಿ ನಾವು ಆಫ್ಟರ್ ಲುಕಿಂಗ್ ಇಂಟು ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್, ಮೈ ಲಾರ್ಡ್, ವಿ ಕೇಮ್ ಟು ನೋ ದಟ್ ದಿಸ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ನೌ ಇಟ್ ಈಸ್ ಬಿಲಾಂಗಿಂಗ್ ಟು ದಿ ಪಾರ್ಕ್ ಏರಿಯಾ, ಮೈ ಲಾರ್ಡ್. Our council or without having any jurisdiction, my lord.
No, now that in the records of the municipal council,
Please.
the name of the petitioner is entered.
In manual, they are saying that it is entered, but
Whatever, please tell us, the TMC number 15/741/348, ಯಾರ ಹೆಸರಲ್ಲಿದೆ?
as on today, it is in the name of ಇದನ್ನಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ, but as per records, my lord.
If it is in the name of the petitioner, please issue the e-khata.
I'll file detailed objection, you original.
Whatever you want.
Please.
But I will not allow you people to, what you call, extort from the petitioner.
It is in park area, my lord.
If it's a park area, what were you doing all these years? How did you give a construction permission? How did you register the khata? How did you receive the tax?
They are not paid any single tax, my lord. Till today, the single rupees of tax, they are not paid, my lord.
ಆಯ್ತು, ಈ ಖಾತೆ ಮಾಡ್ಕೊಡಿ, ಟ್ಯಾಕ್ಸ್ ಕಟ್ಕೊಳ್ಳಿ.
I'll file detailed objection, my lord.
I will not allow this thing to happen.
Please.
Shivkumar Kallur.
I'm for the petitioner in this case, my lord.
Hmm.
I'm the owner of the land bearing survey numbers 669, measuring to the extent of 4 acre, my
Is
lord.
government?
Yes.
He says that some land is acquired, no compensation is paid.
Yes, my lord. And land acquisition proceedings have been initiated and 401 notification has issued in the year 1998 itself, my lord. And
ಏನ್
61,
ಮಾಡ್ತೀರಾ? Huh? Who is the answering respondent? Who is the answering respondent?
Please.
Huh?
Yes.
Minor irrigation.
minor.
MI,
ಹಾ, ನೀವೇ ಹೇಳ್ಬೇಕು.
please.
Huh? Yes, find out what steps you have taken.
Please,
ತಿರ್ಗಾ ಇವ್ರ ಹತ್ರ, I will not send them back to these people. ಇವ್ರು ಹೋಗಿ ತಿರ್ಗಾ ಅವ್ರ ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫೀಸರ್ ಹತ್ರ ಕೈ ಕಟ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ಳಕ್ ಆಗಲ್ಲ.
Yes.
Award has been also passed, my lord. They have not
When
issued.
will you pay the compensation? Learned AG is directed to secure instructions as to when the respondents will make arrangements for paying the compensation as per the award.
Yes, ma'am.
Please.
List on.
After 2 weeks.
Hmm?
After 2 weeks, I will get.
Yes, Manvendra Reddy.
Petitioner is challenging annexure D, my lords. The order on IA number 3, my lords. The petitioner is the institution, my lords. The respond number 1 was earlier working as a park. in the institution, my lords.
Yes, 50% subsistence allowance.
Here is here is a case, my lords, wherein, my lords, the father of the respondent number one had sold 10 guntas of land to the institution, my lords, with an understanding that his son should work in the institution, my lords. He worked in the institution on a temporary basis on in 2012 to 2014, my lords. There he was terminated from the service, my lords. Subsequently, my lords, the father, as per annexure E, my lords, I have enclosed a copy of the judgment, my lords. Father and his brother, my lords, brother of the respondent number one had filed a suit for cancellation of the sale deeds on the pretext that the brother did not continue in the service, my lords. They did not choose to challenge the termination order, my lords. Subsequently, after dismissal of this original suit in the year 2019, my lords, this EAT application was filed before the district court, my lords. After lapse of more than 7 years, my lords, this application came to be filed before the district court, and thereby subsequently this application was allowed.
But you did not terminate, you only suspended them.
No, my lords, his was only on a temporary basis. It is, I have specifically mentioned in my statement of objection before the appellate, and the appellate authority, my lords.
Yeah, who appears for the private respondent?
His notice has been served, my lords, he has not appeared, my lords.
Which is the order which is challenged?
Annexure D, my lords, page number 27, my lords.
What the annual?
May I start with the reasons, my lords, page number
Yes.
31. It is contended by the petitioner appellant in his memo as well as in IA number 3 that he was appointed as a supervisor having mobile number so and so in the respondent number 1 and 2 institution, and his name is shown in serial number 15 of the staff member list of Sri Satya Sai Vidya Niketan. So also his salary package was also shown under the WEF at 10,180 from June 2013, and out of if after deducting the certain amount which provident fund contribution to the provident fund, food and shelter, and a net amount of rupees 4,720 was paid to him as salary in support of the same. The petitioner appellant has produced a Xerox copy of the staff member list along with the statement of salary package with effect from June 2013. During the course of the argument, the counsel appearing for the petitioner appellant submit that the petitioner and the petitioner bar appellant was appointed as a supervisor in the institution of the respondent number 1 and 2, and he was receiving the salary from the respondent institution through Canara Bank having account bearing number so and so. But the respondent institutions have terminated the service of the petitioner appellant without initiating any legal proceedings. As such, the petitioner appellant is entitled for the subsistence allowance from the date of the termination till disposal of the main petition. On perusal of the appeal memo along with the contention on IA number 3 as well as the Xerox copy of the list of staff members and the salary package statement, salaries credit list, and the statement of account bearing number so and so of the Canara Bank pertaining to the petitioner appellant, the prima facie it goes to show that the appellant petitioner appellant is appointed as a supervisor in the respondent number 1 and 2 institution. Therefore, the document produced in at this stage by the petitioner appellant is quite appreciable and reliable as per section 60 and 60 to 65 of the Evidence Act. Hence, relying upon the documents, it is just and proper to consider IA number 3 filed under section 92 clause 3 clause D of Karnataka Education Act 1983. Further, the reference was made to the section, my lords. Lastly, my lords, at para number 16 at page number 37.
But where have you said he was appointed on temporary basis?
In my statement of objection, my lord, here one aspect was remained unsilent, reason behind, my lords. The counsel who was appearing there, my lords, he had expired during the pandemic COVID, my lords. Then the objection on IA number 3 was not filed, but statement of objection to the main petition was filed, my lords. Let the matter be remitted back, my lords. I'll file objection to the said application, my lords, and fresh hearing could be conducted, my lords. An opportunity to the petition.
You can't just like that, we can't remand the matter. Point out to the objections that you have filed.
Yes, my lords. I have submitted annexure B is the objection, my lords. Annexure
C.
Please, my lords. Page number 18, my lords. page number 18, para number 4, 5, 6, my lords.
ಓದಿ ಎಲ್ಲಿ ಹೇಳಿ.
It is submitted that the appellant was allowed to serve the institution purely on the temporary basis, but the late trust found that he was not discharging the allotted duties properly. He always misconduct himself and was using filthy language in presence of the children in a irresponsible manner. Despite of the several warning, there was total absence of discipline on him, and he was habitual drunkard. He always used to attend his work in the campus under the influence of the alcoholic drinks in inebriated condition, which he used to drink very often. He used to pick serious fights with the management worker quite often. There was total absence of decorum in him. On several occasions, this fact was brought to the notice of the father, and his father would confess that he could not manage his son. He was unwilling to behave in a disciplined way, despite warning given for several times by the management. He had acted against the interest of the school students who were staying in the hostel, and very safety of the students were threatened.
Sir, if it is a temporary basis,
Yes, my lords.
even if you make so many allegations, he had to be heard. An inquiry had to be conducted. Even if he was a temporary employee,
Yes,
when
my
you are throwing him out, throw him without any blemish. But if you say he did that, he was a drunkard, he was
That
misbehaving.
termination order, my lords, he did not challenge it immediately, my lords. After the dismissal of the original suit, my lords,
has
this
to be
petition was
construed
kept to
as
be filed.
only a case of suspension. ನೀವು ಎಷ್ಟೊಂದೆಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡ್ತೀರ ಅವನ ಮೇಲೆ. There is a procedure.
No, my lords, the kindly peruse the prayer also he has sought in the appellate to revert back the amount which has been given in the sale.
ಎಲ್ಲಿದೆ ಅದು?
Para number 14, page 14, my lords. Prayer number 2, my lords.
ಫಸ್ಟ್ ಪ್ರೇಯರ್ ಓದಿನ ಕೇಳಿ. ವಾದಿಯನ್ನು ನೌಕರಿಯಿಂದ ತೆಗೆದು ಹಾಕಲಾದ ವಜಾ ಮಾಡುವುದನ್ನು ತಿರಸ್ಕರಿಸುವಂತೆ.
Yes, second prayer, my lords.
ಸೆಕೆಂಡ್ ಪ್ರೇಯರ್ ಬಿಡಿ, ಅದೆಲ್ಲ ಕೊಡಕ್ಕಾಗುತ್ತೆ ಟ್ರಿಬ್ಯುನಲ್.
That is why, my lords, I am seeking only for remand, my lords. I'll file objection to the said application, my lords.
Government, you please give an offer. ಇಷ್ಟು ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ, we can record it and send it back. You have taken their land. You are sure that you will give an employment.
We have purchased outright sale, my lords. It was purchased, my lords. It was
Correct.
purchased from the more than the usual amount only, my lords.
Whatever it is, you have taken their land. You are sure that you will give an employment to his son. ಈ ಕೆಲಸ ಕೊಟ್ಬಿಟ್ಟು ಕೆಲಸದಿಂದ ಕಿತ್ತಾಕ್ಬಿಟ್ರೆ ಆಯ್ತು, ಅವರು ಏನೋ ಮಾಡಿದ್ರೆ ನೀವು ಏನೋ ಮಾಡಿದಿರಿ. He has also filed a suit to take back that land. No, so you also thrown the son out of employment.
Prior to that only, my lords, he was dismissed from the service, terminated from the service, my lords.
You can't dismiss him just like that. Come up with some package.
I'll get the instructions, my lords. My lords, one submission, my lords, on last date of hearing, interim order was not extended, my lords.
Yes.
It may
The
be.
learned counsel for the petitioner, after hearing the learned counsel for the petitioner, this court expressed its opinion that the petitioner should come out with some offer of settlement. Full stop. The learned counsel for the petitioner sought time to secure instructions, hence list on date. Temporary employee ಅಂದ್ರೆ ಒಂದು ತುಂಬಾ ಅಲಿಗೇಷನ್ ಮಾಡಂಗಿದ್ರೆ ಎನ್ಕ್ವೈರಿ ಮಾಡ್ಬೇಕು. ಯು ಕಾಂಟ್ ಥ್ರೋ ಹಿಮ್ ಔಟ್ ಜಸ್ಟ್ ಲೈಕ್ ದಟ್. ನಾಳೆಯಿಂದ ಬರ್ಬೇಡಪ್ಪ ಅಂತ ಒಂದು ಲೆಟರ್ ಕೊಟ್ರೆ ಓಕೆ.
My lords, interim order may be extended.
Interim order granted on so and so is extended.
Obligement.
But may pass on word. In very respect of the same road, some other petitions were disposed of in terms of this may also be disposed.
Yes, Mr.
Sir, the copy.
Yes, ma'am.
Can be disposed of.
As per that order.
The petitioners have sought for a writ in the nature of mandamus to consider mandamus to direct the respondents to consider the representation dated 22/7/2022 and 3/8/2022. And direct the respondents not to widen the road from Tahsil office to Dargah Aland without initiating acquisition proceedings and without payment of compensation. They also sought for it in the nature of mandamus directing the respondents not to demolish any portion of the building belonging to the petitioners. Full stop. Next para. The petitioners contend that they are the owners of several properties lying on the road between Tahsil office to Aland, Dargah Aland. Illido? Dargah Aland in which taluk, which district?
Aland in the city, my lord, in the town, lord.
In Aland taluk.
Town, illa town,
In
Aland,
Aland-
Aland town.
In Aland town,
It's
Bijapur district,
illa Gulbarga,
Gulbarga district.
Kalburga.
Gulbarga district. They contend that the respondents, without initiating any acquisition proceedings, are trying to take over their portions of their properties to widen the road. Therefore, they are before this court seeking for the aforesaid directions. The learned counsel for the petitioner reiterated the above contentions and prayed that suitable directions be issued to the respondents to initiate acquisition proceedings before dispossessing the petitioners from their respective properties. Full stop. The learned counsel for the respondents, on the other hand, contended that the issue involved in this petition is squarely covered by an order of this court, by an order passed by a coordinate bench of this court in WP number 202052 of 2022,
It is in respect of the very same road.
which is also in respect of the very same road. So, which is also in respect of the properties lying on the same road. The learned counsel for the petitioner does not dispute the above fact. In that view of the matter, this writ petition is also disposed of. Directing the respondents to take necessary action in accordance with law by initiating acquisition process if it needs the land of the petitioners for the purpose of widening the road. Full stop. In the event of the petitioners encroaching into any portion of the road, the respondents have to take necessary action after issuing appropriate notices under the Karnataka Municipalities Act 76 and proceed in accordance with law. V.K. Naik.
Appear for the petitioner. Note that the property in dispute is 2-3-65. Belongs to the mother of petitioner number 2, and she has purchased it in the year 1945.
In the year
45 Fazli. That is annexure A. On 28/11/1998, she expired. Immediately after she expired, this property 2-3-65 has been mutated in the name of petitioner number 1, who is the daughter-in-law of late Beam Bible. And mutation was effected on 3/8/2000, and that mutation was continued till 2019. When the matter stood thus, the respond number 3 on 31/3/2000, respond number 3 is Amrutabai. Amrutabai is the distinct relative of late Bhimbai. She became widow at the young age. Bhimbai has allowed her to stay in 2 rooms adjacent to the main house.
She approached the municipality on 31/3/2000 with a request to change, enter her name in respect of 2 rooms. Relying upon, your lordship, kindly have a look at the document. Page number 127. After 12 years death of the Bhimbai. The typed copy is at 129. ಹಕ್ಕು ಬಿಟ್ಟು ಕೊಡುವ ಪತ್ರ.
Yes.
And by your lordship, kindly see page number 133. Based on this document, according to them, respond number 3, it is a relinquishment deed executed by the Bhimbai in the year 1992 itself. And now she is producing in the year 2010.
ಏನ್ settlement ಆಗತ್ತಾ?
Swami, that
Settlement.
the petition number 2 is the son. He has promised his mother that till her death, that Amrutabai, as long as Amrutabai is there, they will not evict her. That's why, my lord, from the date of death of Bhimbai till today, you have not taken any steps to remove her. Now,
ಏನಾದ್ರು ಸ್ವಲ್ಪ ದುಡ್ಡು ಕಾಸ ಕೊಟ್ಕೊ ಬಿಡಿಸ್ಕೊಳ್ಳಿ ಇವತ್ತು. Take the property back.
I'll seek instructions.
You also don't have any title to the property. You have to establish your right. You have to go through the civil court.
now the endorsement is issued to me to establish my title against them.
There is a registered gift deed, your lordship.
Based on this,
ಯಾವುದು? Bhimbai execute registered?
Not Bhimbai, your lordships. In fact, your lordships, originally when the property was purchased in the name of Bhimbai, your lordships, it was purchased by 2 sisters, your lordships. However, your lordships, name of Bhimbai was reflected.
Can you claim that before the municipal authorities?
That is not a case, your lordships. 2010, the name of Amrutabai has been reflected in the municipal records. Since, your lordships, 10 years, they have not disputed it. 2019, she executes gift deed to her daughter, transferring those 2 small, your lordships, portion of that area, which was given to her by Bhimbai.
Settlement ಏನೋ ಮಾಡ್ಕೊಳ್ಳಿ. Learned counsel for the petitioner seeks time. Learned counsel for the petitioner and the learned counsel for the respondents 3 and 4 seeks time to explore a settlement. List on
Mediation,
mediation.
If it could be referred to mediation here itself, your lordships.
learned counsel for the petitioner and the learned counsel for the respondents 3 and 4 says that having regard to the nature of the dispute, the parties may be referred to mediation. Hence, parties are directed to appear before the mediation center
30th,
Kalaburagi
your lordships.
on
30th.
30th January 2025 at 11 AM
At your lordships, 1:30, 1:32, your lordships.
at 2 o'clock, 2 PM. Prashant Vajantri.
My lord, it's the matter of recognition withdrawal matter.
Matter of
Recognition withdrawal ಮಾಡಿದಾರೆ my lord.
recognition is
Yes,
withdrawn.
my lord. My lord, respondent authority R1 has issued the
Sudhir
Showcase-
Singh Bijapur. Sudhir Singh Bijapur. On what ground it is withdrawn?
My lord, there are the page. My lord. My lord, page number 63, my lord. Yes, my lord. Page number 63, my lord.
63.
Yes, my lord.
Hmm.
My lord, Bashweshwar College, after the showcase notice, my lord, I complied the necessary documents, my lord. On the document has, whatever I document submitted, they are found the deficiency, my lord. So in this, my lord, there are the 7 deficiencies, my lord, in the point out, my lord. So in this regard, my lord, already 1 to 6, my lord, already I complied, my lord. Regarding the serial number 7, my lord, there can I read, my lord, the 7? The institute submitted with a copy letter dated 27/2019 issued by the registrar Gulbarga University, hereby only the 14 faculty is approved, which is not sufficient to running the B.Ed course. My lord, and they submitted that I am running the only one B.Ed course, my lord.
Yeah.
One B.Ed course, sir, not two. The 14 faculty is sufficient to. My lord. On this regard, my lord,
Please read again. Institute submitted a copy
yes, my lord.
of letter dated 27/2019
Yes, my lord.
issued with the registrar Gulbarga,
Yes, my lord.
whereby only 14 faculty is approved,
Yes, my lord.
which is not sufficient for running B.Ed course
Yes, my lord.
with 2 units as per NCTE regulations.
Yes, my lord.
In 2 units.
Now one unit, I am running 1 unit, my lord. Only 1 unit, my lord.
Then application 1
Yes, my
unit.
lord. Adar ಬಗ್ಗೆ, my lord. Further, I submit further.
Only 1 unit ಅಂತ ತೋರ್ಸಕ್ಕೆ ಎಲ್ಲಿದೆ?
No, my lord. My lord, page number 72, my lord.
72.
Yes, my lord. I given the one more, my lord, submit for all the serial number 6, my lord.
Yes.
6, the institute did not submit the promotions, the facility approval by the university. The submit approval staff listed running the 1 unit, my lord. When the 1 running as per the observation of the premise facility, approval by the university submitted, my lord.
Yes, Mr. Sudhir Singh. Sudhir Singh Vijapur. There is no representation for the respondent number 1. As a last chance list on.
Other than Saturday, my lord. Other than Friday, my lord.
Huh?
Friday, but Thursday, okay.
Yes, next.
Intermatter may be.
Tomorrow is extended till the next.
This matter may kindly be heard along with WP number 200294/23.
List this petition along with WP number so on.
200294.
List on date. Put. Please. Srinivas Shamsundar.
My lord, the name may be deleted. The Srinivas Shamsundar Rao is no more.
Filed wakalat.
Yes.
I have filed wakalat, but
Ah.
registry time and again showing that wakalat not filed anta. I filed wakalat on
You are ready?
11th September itself.
Are you ready or?
My lord, I have to file the statement of objection.
Learned counsel for the respondent number 2 seeks time to file statement of objections.
Please, madam.
Office is directed to delete the name of Mr. Srinivas Shamsundar Rao, SV Patil and HM Gilki, and continue the name of Srimati Ratna N. Shivayogi Mat, who was entered, was filed wakalat
Yes, 11th September 20,
on 11 September 2024.
please.
List on date. Put.
My lord, long. First week,
Yeah.
7th,
Baker,
6th, 7th.
Advi Nadagowda. Hema
For
Kulkarni.
respondents, Mellors, kindly weak accommodation, Mellors, I'll file statement of objections. Mellors.
Learn counsel for the respondent number 1 and 2 seeks time. List on.
My lord, I prayed the honorable court to fix
Please.
the date.
Yes,
Please.
next.
Please. Next week.
Lord, I need weeks accommodation. Next week, any date may be fixed.
Learn
Because
counsel-
they have referred one document,
Learn counsel for the petitioner seeks time.
Short date may be getting.
short date,
Avat Baker, Tavoli Puggi.
ಮೂವತ್ತು ಅಂತ. Please.
Avinash Shuklankar,
interior matter may kindly be.
he was extended to the next. Yes. Yaar other side yaru, Sudarshan.
Yes, please.
Covered.
Yes, I have taken a lot of details as adverse payment. Sir, I have taken a lot, secured the details
my lord, of the Afzalpur, my lord, vicinity. I don't remember the facts. What are the facts? My lord,
The facts are that this college is having a capacity of admitting 60 students is the permissible limit. So they made a request to the university that more number of students are interested to study in our college. So that was a request that was made. The students apply in the UCMS. They will be choosing the colleges. Students chose my college. So 40 students were admitted in excess. So I admitted 40 students in excess. So I said that this is the situation of my college, for which the university was gracious enough to approve for 12 students only, excess 12 students. So 28 students remained in limbo whether to how to approach the examinations which are ensuing. So we approached this honorable court and we sought an interim order, and we have already written the examination. This is one part. On the last date of hearing, queries were raised by the honorable court. My respectful submission would be 40 excess ತಗೊಂಡಿದ್ರಲ್ಲಿ 12 ಅವರೇ ಅಪ್ರೂವ್ ಮಾಡಿದ್ರು, 28ಕ್ಕೆ ನಾವು ಕೋರ್ಟ್ ಆರ್ಡರ್ ಪ್ರಕಾರ ತಗೊಂಡ್ವಿ. These students who have written the examinations, now they are in the last semester. So they have to write the examinations and they will be clearing this thing. My representation is considered for this year and my intake capacity has been increased from 60 to 100. 60ರಿಂದ ಈಗ 100 ಮಾಡಿದ್ದಾರೆ. Now I have got the capacity to accommodate 100 students.
If
So
that
there
is
will
the
be
case, my lord, whatever my lords please to pass orders. No, but 100 capacity increase ಆಗಿದೆಯಾ?
ಆಗಿದೆ. None.
ಅಲ್ಲ, initially it was not there. That's what.
Now, now they got the capacity.
Please.
Barcode. The petitioners have sought for a written the nature of mandamus to issue hall tickets to them and permit them to continue their course. The respondent,
My lord, respondent, university.
number 3. Full stop, next para. The petitioners contend that the respondent number 3 petitioners contend that they are the students of the respondent number 3 and are pursuing a Bachelor in Arts course. Bachelor of Arts course. Full stop. They contend that for the year, during the year 2022-23, the respondent number 3 had admitted 100 students as against the intake capacity of 60 students. Full stop. The respondent number 3 requested for granting permission by enhancing the intake to 100. However, the respondent number 1 university granted permission enhancing the enhancing the intake capacity to 72 students. The petitioners are the remaining 28 students who are not whose admission was not regularized. Full stop. The petitioners therefore have approached this court seeking for directions to the respondent university to issue hall tickets and regulate their admission. Full stop. This court had, the learned counsel for the petitioner submitted that now the intake capacity of the respondent number 3 is increased from 60 to 100. And therefore, the respondent number 3 has all the ability and the infrastructure to impart education to 100 students. Full stop. He submits that the respondent, that the petitioners are now in the verge of taking up the examination for the last semester. And therefore, comma, the petitioners be, therefore, comma, the admission of the petitioners be regularized by issuing suitable directions to the respondent number one to consider the petitioners as eligible candidates and issue the hall tickets to enable the petitioners to face the examination and pass and complete the course. Full stop. He submits that in similar circumstances, a coordinate bench of this court in WP number 203514 of 2023 had allowed the petition and directed the university to verify the records of the students, and if they are eligible to issue hall tickets and admit cards. Full stop. He therefore submits that this writ petition may also be disposed of on the same terms. Next, for learned counsel for the respondent number 1 and 2. Learned counsel for the respondent number 1 did admit the fact that the intake capacity of the respondent number 3 is now increased from 60 to 100. Full stop. He also
Lord advocates, I may not admit, yes, because
It may be taken from my
without
side
saying,
only.
I
please.
learned
From my
counsel
side.
for the respondent,
Yes.
number 1, submits that
Subject to verification.
the intake capacity of the petitioner was only 60, and therefore it could not, the intake capacity of the respondent number 3 was only 60, and therefore it could not have admitted more students. Full stop. It contends that increase in the intake capacity depends upon various considerations, and the respondent number 3, without meeting any of those considerations, had blindly admitted students. Therefore, he contends that the petitioners cannot be granted any leeway, LEEWAY, by regularizing their admission. Full stop. I have considered submissions of the learned counsel for the petitioners and the learned counsel for the respondent number 1. Next paragraph. It is not in dispute that the respondent number 3 had a sanctioned intake capacity of 60 students. And it is also not in dispute that as against intake capacity, the petitioner had admitted 40 more students and thereafter sought enhancement of the intake capacity. Full stop. The respondent number 1 enhanced the intake capacity from 60 to 72, leaving the remaining 28 students in the limbo. Full stop. This court, in terms of an order dated so and so, permitted the petitioners to face the examination, and it is now stated at the bar that all the petitioners have cleared
Final year. Final semester.
their
Previous semester.
previous semesters. Full stop. Now that the intake capacity of the respondent number 3 is increased to 100, it goes without saying that the respondent number 3 had all the infrastructure to impart education to 100 students. Full stop. Therefore, the admission of the petitioners deserves to be regularized as a one-time measure. Consequently, this writ petition is disposed of, directing the respondent number 1 to regularize the admission of the petitioners as a one-time measure, subject to they fulfilling all eligibility criteria.
Please.
Full stop. If the petitioners fulfill the eligibility criteria, the respondent number 1 shall take all steps to regulate and regularize their admission and also issue all admission tickets / hall tickets and receive all examination fees from them, so that the petitioners face the final semester examination. The respondent number 3 is warned to henceforth not take any students in excess of the permitted intake capacity. Full stop. It is also, the respondent number 3 is also warned that in the event of any lapse, the respondent number 1 shall be authorized to take suitable criminal action against the respondent number 3. Yes.
My lord, may I seek one word adding to them, lord? Eligibility criteria subject to, my lord, making available of, my lord, original records, please.
It is needless to mention that all the petitioners shall furnish all their original credentials to the respondent number 3, who shall in turn forward it to the respondent number 1.
Please, much, please.
Yes.
Lord, in that case, my lord, I have sought for, my lord, details. Lord, kindly be taken on Monday, my lord.
Learned counsel for the respondent number 1 seeks time list on Monday.
One submission, Your Worship. We have got the instruction that petitioners have been regularized.
Huh?
Petitioners' admission have been regularized.
But why do you want to invite an order?
Details are there. That's if you are having, please.
Just we have got the instructions. We have got the instruction from the petitioners there.
ಆಯ್ತು ಹಂಗಾರೆ ವಿಡ್ರಾ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ? Why do you invite an order from the court?
ಆಗಿದೆ. They are, my lord, promoted to higher classes also.
ಆಯ್ತು ಮಂಡೇ.
Monday, ಆಯ್ತು.
ಯಾವತ್ತು? ಎಜುಕೇಶನ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವತ್ತು? ಮಂಡೇ. Sorry, Thursday.
Thursday.
Mr. K.M. Gate. Gaurish Kashampur. Okay.
My lord, A endorsement issued by the second respondent, Buda Commissioner is under challenge before this honorable court.
Annexure A.
Annexure A. my lord. The petitioner here is the owner and possessor of the approved layout, my lord. In that approved layout, an open space was left out, and that was not handed over to the development authorities, and there was no direction as such to hand over that open space, my lord.
ಓದಿ ಏನ್ ಹೇಳ್ತಾರೆ ಓದಿ.
Please, ma'am. I made an application to the second respondent based upon the civil court's decree by which my ownership was confirmed, and mutation was also sanctioned to that open space, my lord. In view of the no objection given by the second respondent to mutate my name, my lord, as per Annexure F, my lord. 8/1/2014.
So let us read Annexure A.
Please, ma'am. Annexure A. ಈ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಬೀದರ್ ನಗರದ ಗುಲ್ಲರ್ ಹವೇಲಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 61ರ ವಿಸ್ತೀರ್ಣ 6 ಎಕರೆ 26 ಗುಂಟೆ ಅನುಮೋದಿತ ವಿನ್ಯಾಸದಲ್ಲಿ ಕಾಯ್ದಿರಿಸಲಾದ ಬಯಲು ಜಾಗವನ್ನು ಉಪವಿಭಜಿಸುವಂತೆ ಉಲ್ಲೇಖ 1ರಂತೆ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿರುತ್ತೀರಿ ಮತ್ತು ಉಲ್ಲೇಖ 2ರ ಗೌರವಾನ್ವಿತ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಕಲಬುರಗಿ ಪೀಠ ಕಲಬುರಗಿಯಲ್ಲಿ ಪ್ರಕರಣ WP ನಂಬರ್ 200466/2021 ದಾವೆ ಹೂಡಿರುತ್ತೀರಿ. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಆದೇಶ ನಂಬರ್ ದಿನಾಂಕ 19/11/2021ರಂತೆ ತಾವು ದಿನಾಂಕ 13/4/2018 ಮನವಿಯಂತೆ ಸದರಿ ವಿನ್ಯಾಸದಲ್ಲಿ ಕಾಯ್ದಿರಿಸಿದ ಬಯಲು ಜಾಗೆಯನ್ನು ಭೂ ಬದಲಾವಣೆ ಮಾಡಲು ಪರಿಗಣಿಸುವಂತೆ ಆದೇಶಿಸುವ ರೀತ್ಯ ಕ್ರಮ ವಹಿಸುವಂತೆ ಉಲ್ಲೇಖ 3ರ ಅರ್ಜಿಯ ಮುಖಾಂತರ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಕೋರಿರುತ್ತೀರಿ. ಅದರಂತೆ ಪ್ರಾಧಿಕಾರದ ನಗರ ಯೋಜನಾ ಸದಸ್ಯರ ವರದಿಯಂತೆ ಸದರಿ ವಿನ್ಯಾಸವು ಉಲ್ಲೇಖ 4ರಂತೆ ಯೋಜನಾ ನಿರ್ದೇಶಕರು ನಗರ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯಾಗಿರುತ್ತದೆ. ಸದರಿ ವಿನ್ಯಾಸದಲ್ಲಿ ವಿವಿಧ ಆಳದ 81 ನಿವೇಶನಗಳು ಮತ್ತು 7 ಅಂಗಡಿಗಳನ್ನು ಅಳವಡಿಸಲಾಗಿರುತ್ತದೆ ಮತ್ತು ವಸತಿಗಾಗಿ 58.25%, ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಾಗಿ 1.25%, ಉದ್ಯಾನ ಬಯಲು ಜಾಗೆಗಾಗಿ 10.30% ಮತ್ತು ರಸ್ತೆಗಾಗಿ 30.20%. ಷರತ್ತು ಬದ್ಧವಾಗಿ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ ವಿನ್ಯಾಸ ಅನುಮೋದನೆಯ ಆಧಾರದಲ್ಲಿ ಷರತ್ತು 2ರಂತೆ ರೂಪರೇಖೆಯಲ್ಲಿ ಬರುವ ರಸ್ತೆ ಮತ್ತು ಉದ್ಯಾನವನ ಕ್ಷೇತ್ರವನ್ನು ಸಂಬಂಧಪಟ್ಟ ನಗರಸಭೆ ಮಂಡಲ್ ಪಂಚಾಯತಿಗೆ ಪಡಿಸುವುದಕ್ಕೋಸ್ಕರ ಪುಕ್ಕಟೆಯಾಗಿ ಲಿಖಿತ ರೂಪದಲ್ಲಿ ಒಪ್ಪಿಸತಕ್ಕದ್ದು ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ. ಒಂದು ವೇಳೆ ಭೂಮಾಲೀಕರು ಬಯಲು ಜಾಗೆ ಸಂಬಂಧಪಟ್ಟ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗೆ ಪುಕ್ಕಟೆಯಾಗಿ ಹಸ್ತಾಂತರಿಸದಿದ್ದರೂ ಹಸ್ತಾಂತರಿಸಿದಂತೆಯೇ ಭಾವಿಸತಕ್ಕದ್ದು ಮತ್ತು ವಿನ್ಯಾಸದಲ್ಲಿ ಅಳವಡಿಸಲಾದ ನಿವೇಶನಗಳಿಗೆ ಮಾತ್ರ ತಾವು ಮಾಲೀಕರಾಗಿರುತ್ತಾರೆ. ಉಳಿದ ಸ್ಥಳಗಳಿಗೆ ಸಾರ್ವಜನಿಕರು ಸರ್ಕಾರಿ ಆಸ್ತಿಯಾಗಿರುತ್ತದೆ. ಉಲ್ಲೇಖ 1 ಮತ್ತು 3ರ ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಸದರಿ ಬಯಲು ಜಾಗೆಯನ್ನು ಉಪವಿಭಜಿಸುವಂತೆ ಕೋರಿರುತ್ತಾರೆ. ಸದರಿ ಅರ್ಜಿಯಲ್ಲಿ ತಾವು ನಮೂದಿಸಿರುವ ಉಲ್ಲೇಖಗಳ ಪ್ರತಿಯನ್ನು ಅರ್ಜಿಯೊಂದಿಗೆ ಲಗತ್ತಿಸಿರುವುದಿಲ್ಲ. ಹಾಗೂ ಉಲ್ಲೇಖ 2ರಂತೆ ತಾವು ಘನ ನ್ಯಾಯಾಲಯದ ಸದರಿ ಬಯಲು ಜಾಗೆಗೆ ಭೂ ಬದಲಾವಣೆ ಮಾಡಲು ಕೋರಿರುವುದಾಗಿ ತಪ್ಪು ಮಾಹಿತಿ ನೀಡಿರುವುದು ತಮ್ಮ ಅರ್ಜಿ ಹಾಗೂ ಗೌರವಾನ್ವಿತ ನ್ಯಾಯಾಲಯದ ಆದೇಶಕ್ಕೆ ತಾಳೆ ನೋಡಿದಲ್ಲಿ ತಾವು ತಪ್ಪಾದ ಮಾಹಿತಿಯನ್ನು ನೀಡಿರುವುದು ಮೇಲ್ಮಟ್ಟಕ್ಕೆ ತಿಳಿದು ಬಂದಿರುತ್ತದೆ. ಹೀಗಾಗಿ ಉಲ್ಲೇಖ 4ರ ವಿನ್ಯಾಸದ ಆಶಯದಂತೆ ವಿನ್ಯಾಸದಲ್ಲಿನ ಕಾಯ್ದಿರಿಸಲಾದ ಬಯಲು ಜಾಗೆಯನ್ನು ಉಪಯೋಗಿಸಲು ಮತ್ತು ಭೂ ಬದಲಾವಣೆ ಮಾಡಲು ಕರ್ನಾಟಕ ನಗರಾಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಕಾಯ್ದೆ 1987ರ ಮತ್ತು ಕರ್ನಾಟಕ ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಕಾಯ್ದೆ 1961ರ ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿರುವುದಿಲ್ಲ. ಒಂದು ವೇಳೆ ಸದರಿ ಬಯಲು ಜಾಗೆಯಲ್ಲಿ ಉಪವಿಧಿಸಿದಲ್ಲಿ ಅಥವಾ ಕಟ್ಟಡ ಕಟ್ಟಿದಲ್ಲಿ ನಿಯಮಾನುಸಾರ ತಮ್ಮ ವಿರುದ್ಧ ಕ್ರಮ ಕೈಗೊಳ್ಳಲಾಗುವುದು ಎಂಬ ವಿಷಯವನ್ನು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಿದೆ. My lord, when the earlier writ petition I have filed, annexure.
ಏನು ಕಾಯ್ದಿರಿಸಿದ ಬಯಲು ಜಾಗವನ್ನು ಭೂ ಬದಲಾವಣೆ ಮಾಡಲು ಪರಿಗಣಿಸುವಂತೆ ಆದೇಶಿಸಿರುವ ರೀತಿಯ ಕ್ರಮ ವಹಿಸುವಂತೆ ಇಲ್ಲಿದೆ. ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಡರ್ ಎಲ್ಲಿದೆ? 200466.
Yes, madam.
ಯೂಸ್ ಮಾಡಿಲ್ಲ.
Yes, madam. Page 59, madam. 202766 of 2014.
ಇದು ಇದೇ ಬೇರೆ ರಿಟ್ ಪಿಟಿಷನ್ ಸ್ವಾಮಿ, ಅದೇ ಬೇರೆ.
20200466 ಎಲ್ಲಿದೆ?
No, that was the earlier writ petition which was
ಎಲ್ಲಿದೆ?
filed. Yes, madam. I have not produced, madam. I have not produced. Okay.
ಸರ್ ನಿಮ್ಗೆ ಅರ್ಥ ಆಗುತ್ತೆ, ನಮ್ಗೆ ಅರ್ಥ ಆಗಲ್ಲ. ಅದ್ ನೋಡಿದ್ರೆ ಅರ್ಥ ಆಗುತ್ತೆ.
Please, madam. I will produce it. I will produce it.
ಎಸ್
ಮೈ ಲಾರ್ಡ್,
ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಇದೆಯಾ?
ಇಲ್ಲ.
ನೋಡ್ತಾ ಇದ್ದೇನೆ, ಬೇರೆ ಮ್ಯಾಟರ್ನಾಗ ಅದೇ ನೋಡಿದೆ ನಾನು. I will get a printout and submit.
Counsel for the petitioner seeks time list on
There is an interim order.
interim order granted is extended.
30ಕ್ಕೆ ಬೇಡ ಸ್ವಾಮಿ, 30, 31.
ಯಾವತ್ತು ಬೇಕು?
ಹಾ.
6/2.
I appear for the respondent, my lords. In the last date of hearing, my lords, your lordship directed to produce the file in respect of renewal and encroachment, my lords. Kindly have it on Wednesday, my lords.
So width of the
Counsel for the
road.
respondent number 4
please.
seeks time list on
Next week, my lords. Wednesday. Next week.
Mantesh Patil.
Interim order may kindly be extended.
Interim order is extended. Fifty-seven Mantesh Patil, Ravi Patil.
Here. Petitioners, my lord, are the allottees of sites. In APMC
Petitioners are?
allottees of sites, my lord, in APMC Market Yard, Sindhunur.
Yes.
My lord, there were lease cum sale agreements issued, and thereafter, my lord, now, my lord, there are absolute sale deeds in favor of petitioner 1, 2, 4, 6, 7, and 8. Except 3 and 5. Rest all, my lord, are been issued with the sale deeds, absolute sale deeds. My lord, during, in view of, my lord, the change in the layout map, my lord, may I take lordship to annexure B. My lord, the copy of the approved layout, my lord, at page number 112.
Page?
112, my lord.
Yes.
My lord, towards right side, my lord, at the top edge, my lord,
Hmm.
there is a CA site. Triangle shape.
ಇಲ್ಲಿ CS site ಎಲ್ಲಿದೆ?
ಮೇಲ್ಗಡೆ. At the top, my lord, this side. my lord.
ಇದು ವಿಸ್ತೃತ ಮಾರುಕಟ್ಟೆ ಪ್ರಾಂಗಣ ಅಂತಿದೆ.
ಇಲ್ಲ, ಈ ಮೂಲೆಗೆ.
ಬಟ್ ಅದೇನು ಟಾಪ್ ಇಲ್ಲಿ ತಿಂದೋಗ್ಬಿಟ್ಟಿದೆ ಇಲ್ಲಿ. ಎಲ್ಲಿದೆ? There's some ಯಾವ್ದು ಈ ಪೋರ್ಷನ್ ಯಾವ್ದು ಇದು ಈಗ
CA site. Triangle shape.
ಆ ರೆಡ್ ಡಾಟ್ ಇಟ್ಟಿದ್ದಾನೆ ಅದ ಆ CA.
ಹೌದು.
ಹಾ.
And abutting to that CA site, my lord, there is a road, which is the road for approaching our godowns.
ಹ್ಮ್.
My lord, the respondent number 5 is been allotted with plot number 136 by modifying that layout.
ಹ್ಮ್.
Utilizing the portion of CA site and the portion of the road.
ಹ್ಮ್.
The modified layout at page number 113. A CA site to ಮತ್ತೆ portion of road, they have made it as plot number 136-1 ಅಂತ. ಈ ರೈಟ್ ಸೈಡ್ ಒಂದು ಮ್ಯಾಪ್ ನಲ್ಲಿ ಕಾಣಿಸ್ತಾರೆ, ಟ್ರಯಾಂಗಲ್ ನಲ್ಲಿ ಈ ಕಡೆ ಇಲ್ಲಿ ತೋರಿಸ್ತಾರೆ ವಾಟ್ ಇಸ್ ಬಿನ್ ದ ನ್ಯೂ ಪ್ಲಾಟ್ ವಿಚ್ ಇಸ್ ಫಾರ್ಮ್ ಅಂತ.
Can't even make out what is the number of that site.
136/1 ಅಂತ ಇದೆ ಸುಮ್ಮನೆ, ಅದು ತುಂಬಾ ಚಿಕ್ಕದ ಪ್ಲಾಟ್. Now, by and large, my lord, that portion of CA site and the portion of road is been utilized for, my lord, in the modified layout, which is objected by these petitioners.
ಕರೆಕ್ಟ್, ಬಟ್ ಇದರಲ್ಲಿ ಪೇಜ್ 113 ಅಲ್ಲಿ
ಹೌದು.
ರೋಡ್ ಏನು ಇದಾಗಿಲ್ವಲ್ಲ?
ಇದ್ರಲ್ಲಿ ಆ ತರ ತೋರಿಸ್ತಾ ಇದ್ರೆ, ಬಟ್ ಈ ಕಡೆ ರೈಟ್ ಸೈಡ್ ಬರ್ತದೆ.
ರೈಟ್ ಸೈಡ್ ರೋಡ್ ಹಂಗೆ ಇದೆಯಲ್ಲ.
ಆ CA site ನು ಯುಟಿಲೈಸ್ ಮಾಡಿದ್ದಾರೆ. ದೆನ್ ಈ ರೋಡ್ ಪೋರ್ಷನ್ ಅನ್ನ ಸ್ಕ್ರೋಲ್ ಮಾಡಿದ್ದಾರೆ.
CA ಸೈಟ್ ಅನ್ನು ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಇಲ್ಲ ಅಂತಲ್ಲ.
ಅದ್ರ ಪಕ್ಕದಲ್ಲಿ ಸ್ಕ್ರೋಲ್ ಮಾಡಿದ್ದಾರೆ ಇಲ್ಲಿ ಮೇಲೆ.
ಅಲ್ಲ, ಹ್ಯಾಚ್ ಮಾಡಿರೋ ಪೋರ್ಷನ್ ಏನು? ದಟ್ ಈಸ್ ಅ ರೋಡ್.
ಆಕ್ಚುಯಲ್ ರೋಡ್ ಅದ್ರ ಪಕ್ಕದಲ್ಲಿ ಸ್ಕ್ರೋಲ್ ಮಾಡಿ.
ಪ್ರಪೋಸ್ಡ್ ಏನದು? ಪ್ರಪೋಸ್ಡ್ ಕೊಡ್ರಿ, ಬೂದ್ಗಾಜ್ ಇದ್ರೆ ಕೊಡ್ರಿ.
ಗ್ರೀನ್ ಕಲರ್
ಪ್ರಪೋಸ್ಡ್ ಇಂಥದ್ದು ರೋಡ್ ಅಂತ ಇದೆಯಪ್ಪ.
ಆ ರೋಡ್ ಅನ್ನ ಸ್ಕ್ರೋಲ್ ಔಟ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದನ್ನ ಈ ಕಡೆ ರೈಟ್ ಸೈಡ್ ನೋಡಿ.
ಅದನ್ನೇ ನಾನು ನೋಡ್ತೀವಿ. ಪ್ರಪೋಸ್ಡ್ ವಾಟ್ ಈಸ್ ದಿಸ್ ರೋಡ್? ಅದು ಹ್ಯಾಶ್ ಮಾಡಿಲ್ಲ. ಪ್ರಪೋಸ್ ರೋಡ್ ಅಂತ ಏನೋ ಇದೆ. ಮುನ್ಸಿಪಲ್ ರೋಡಾ?
ಪ್ರಪೋಸ್ ಕಾಂಪೌಂಡ್, ಪ್ರಪೋಸ್ಡ್ ಮುನ್ಸಿಪಲ್ ರೋಡ್ ಅಂತ.
ಪ್ರಪೋಸ್ ಮುನ್ಸಿಪಲ್ ರೋಡ್ ಅದು?
ಎರಡನೇದು.
ಹಾ, ಪ್ರಪೋಸ್ ಮುನ್ಸಿಪಲ್ ರೋಡ್. ರೋಡ್ ಇದೆಯಲ್ಲ ಅಲ್ಲಿ.
Portion ಅನ್ನ ಸ್ಕ್ವೇರ್ ಮಾಡಿಬಿಟ್ಟು they are making attempt to allot this was this CA site and the portion.
Here the case is entering.
Not the case. ಅದನ್ನ ಹೇಳ್ತೀನಿ, why the termination is
That is
issued
not
is
the
the
case
cause.
here, my lord.
This is the cause for issuing a termination of our lease anta. That is my case.
They have constructed the building
We
for
approached
violation of construction.
Let me come. Because of having opposed, my lord, for allotment of this CA site and portion of the road which is being sought to be given in favor of, my lord, the respondent, my lord, we approached, my lord, the trial court in OS number 88 of 2020, seeking injunction.
Now, my lord, that suit is dismissed because of non-compliance of a statutory provision. During pendency of this matter, my lord, we are issued with a show cause notice, saying that, my lord, we have also violated some construction permissions. And we approached this honorable court challenging those notice at, my lord, page number 142, annexure G, my lord. And the petitioners here were given, my lord, liberty to file objections to that notice. And then, my lord, same were requested to be considered by the authority. But within stipulated time, my lord, petitioners failed to give their objections. Therefore, my lord, annexure K series are passed. Cancelling, my lord, the allotments in favor of, my lord, the petitioners. K series starts from, my lord, page number 1.
But then you will impose cost on you for not filing the objections and direct them to reconsider.
We had sought for extension of, my lord, time also in the pending
But now
matter,
we'll
which is
permit you.
in view of this, my lord, let them consider our objection. Now, my lord, one more development is, my lord, as per annexure O, my lord, page number 242. Now there is a circular issued by the APMC itself on 6/9/2022. Last page, my lord, 242. This, as per this circular, my lord, the committee is authorized to impose, my lord, the cost if there is any violation, my lord, of construction permission. We are ready for, my lord, this variations, my lord, if found by the authority.
Whatever is the law.
Yes, my lord. Based on this, my lord, we are ready to pay, my lord,
Based
the
on
cost.
this law, whatever is the law.
Yes.
That they have formulated.
Yes.
If there's any violation, they have to pay cost.
Yes, we are ready for that. Now, my lord, since absolute sale deeds are already.
Orders under challenge are appealable and revisable orders under the act. This annexure H is passed, my lord, on.
Annexure?
H and J are the impugned orders.
Under section 137A, they have to approach the committee, my lord, if being agreed by any orders.
ಇವಾಗ ಇದ್ರ ಮಂದಿ ಯಾರು APMC ಆರ್ಡರ್ ಆಗಿದೆ. Against order passed by APMC, ಎಲ್ಲಿದೆ appeal?
137A, my lord, under the Karnataka APMC Act, Regulation and Development Act 1966.
ಎಲ್ಲಿಗೆ ಹೋಗ್ಬೇಕು?
137A says, save as otherwise provided in this act, any person aggrieved by an original order of the chairman or the secretary under the act may within 30 days appeal to the market committee. The market committee, after giving a reasonable opportunity of being heard to the appellant and after such inquiry as it deemed fits, decide the appeal and its decision shall be final.
Now, anyway, see, they not filed objections. Why should
we
they
have
again
filed
be
ob-
sent here and there? We'll permit them to file objections.
Objections
The
they have filed
objections
after the
ಹಾಕಿದೆ.
orders are passed, objections they have filed. After filing of the order, objection are filed. Based upon that objection.
So let them consider the objections and pass appropriate order. ಎಷ್ಟು cost ಎಷ್ಟು ಕಟ್ತೀರಾ? ನೀವ್ ಹೇಳಿ.
Because of non-communication of this order through council, my lord.
These are all APMC traders alva.
Yes, my
How
lord.
trade.
They are all commission agents.
They are already,
We are
Blood
operating
sucking,
the business, my lord.
blood sucking commission agents.
they have constructed house on the.
ಇಲ್ಲ ಮೇಲ್ಗಡೆ one
ಮೇಲ್ಗಡೆ ಎಲ್ಲ
restroom
ಮನೆ
ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
ಕಟ್ಕೊಂಡಿದ್ದಾರೆ ಅವ್ರು.
Whatever it is.
They have constructed one restroom, my lord, which is.
Right, whatever, ನೀವೇ ತಪ್ಪು ಮಾಡಿ
ಇಲ್ಲ, we
ಇನ್ನೊಬ್ಬರ
are.
ಮೇಲೆ ಬೆರಳು ತೋರಿಸಬಾರ್ದು.
ಇಲ್ಲ, ಈಗ entire access has been, my lord, blocked to our godowns.
ಈಗ ರವಿ ಪಾಟೀಲ್ ಇದರಲ್ಲಿ ಮಹಾಂತೇಶ್ ಪಾಟೀಲ್ ಸೇಮ್ ಕೇಸ್.
Same case, same. Both are same.
They are the beneficiaries of that plot which is, my lord, utilizing 136.
ಅವ್ರದ್ದೇನ್ ಕೇಸ್?
ಇಲ್ಲ,
PSI.
ಮಾತೇಶ್ ಪಾಟೀಲ್ and ಇವ್ರದ್ದು ಸೇಮ್. ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5.
I am the
Five, respondent number two.
for the, by virtue of the, my lord, this honorable court was directed to appear before the court, my lord. They have
ಎಷ್ಟು
appeared
ಜನ?
on that.
ಎಷ್ಟು ಹೇಳಿ ಕಾಸ್ಟ್? 8 ಲಕ್ಷ.
ಅಷ್ಟೇ ಬೇಡ.
ಏ,
10,000 ಮೇರೆ.
ಏನು ಒಳ್ಳೆ ಕಥೆ ಐತಲ್ಲ.
Again, they will assess, my lord, the
ನೀವೇನ್
violation.
ರೈತರಿಂದ ನೀವು ತಿಂತಾನೆ ಕೊಡೋದು?
ಇಲ್ಲ, ಆ ತರ ಅನ್ಸುತ್ತೆ, ಬಟ್ they are not making that much.
ಅನ್ಸುತ್ತೆ ಅಲ್ಲ, ಐ ಆಮ್ ಆಲ್ಸೋ ಎ ವಿಕ್ಟಿಮ್. ಹೌದ್ರಿ,
ಇಲ್ಲ,
ಆಲ್ಸೋ ವಿಕ್ಟಿಮ್.
ಇದು ಫೈನ್ 10 ಲಕ್ಷ ಆಗತ್ತೆ ಸ್ವಾಮಿ.
ನಾವು ಕೊಬ್ಬರಿ ವಿ ಗ್ರೋ ಕೋಪ್ರಾ, ಡ್ರೈ ಕೋಪ್ರಾ 50 kg ತಗೊಂಡೋದ್ರೆ 1 kg ಎಕ್ಸ್ಟ್ರಾ ಕೊಡ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ ತಗೊಳಲ್ಲ.
We are also victims of the
Then-
this, but
So ಕೊಡ್ಲಿ ಇಲ್ಲಿ ಇಂಥ ಕಡೆ ಬಂದಾಗಲೇ ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
ಇಲ್ಲ ಇಲ್ಲಿ ಟೋಟಲ್ ಕಾಸ್ಟ್ ಆಫ್ ವೈಲೇಷನ್ ಏನಿದೆ ಆಸ್ ಪರ್ ಮನೋಡ್ ದೇರ್ ಓನ್ ಗೈಡ್ಲೈನ್ಸ್ 10 ಲಕ್ಷ ಆಗುತ್ತೆ ಸರ್.
8
even
lakh,
if-
ಒಬ್ಬರಿಗೆ 1 ಲಕ್ಷ ಕಾಸ್ಟ್.
ಜಾಸ್ತಿ
If you're willing to pay 1 lakh cost,
ಇಲ್ಲ
I will direct you to-
ಲೆಸರ್ ಮನೋಡ್ ಪನಿಷ್ಮೆಂಟ್
no.
ಬಿಕಾಸ್ ಆಲ್ರೆಡಿ ಅಬ್ಸಲ್ಯೂಟ್ ಸೇಲ್ ಡೀಡ್ಸ್ ಇದೆ ಮನೋಡ್ ಹಾಗಾಗಿ ಇವನ್ ಕ್ಯಾನ್ಸಲೇಷನ್ ಆಫ್
ಇವ್ರಿಗೇನು ಕೊಡ್ಬೇಡಿ, APMC ಏನು ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಡಿ. ಜಯದೇವ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಗೋ
20,000 ಈಚ್
No, no.
ಇಲ್ಲ ಇಲ್ಲ ಅಷ್ಟು
go file an appeal.
ಇಲ್ಲ in view of what happened ಮನೋಡ್ in view of blocking of this road now even business is not ಮನೋಡ್ incurring ಅದು ರೋಡೇ ಬ್ಲಾಕ್
Whatever it is, if you want, you file an appeal. If you want to short circuit that appeal remedy,
ಅಪೀಲ್ ಮತ್ತೆ ಅವರಿಗೆ ಇದೆ ಸ್ವಾಮಿ ಕಮಿಟಿಗೆ ಇದೆ.
so therefore, we are giving you the benefit of not going before the appellate authority. Direct ಇಲ್ಲಿ ಬಂದಿದ್ದೀರಿ, ಸರಿನೋ ತಪ್ಪೋ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿದಿರಿ, ಇದಕ್ಕೊಂದು ದುಡ್ಡು, ಅಪೀಲ್ಗೊಂದು ದುಡ್ಡು, ತಿರ್ಗಾ ಹೈಕೋರ್ಟ್ ಬಂದ್ರೆ ಇನ್ನೊಂದು ದುಡ್ಡು, ಅದ್ರ ಬದಲು 1 ಲಕ್ಷ ಕೊಟ್ಟು go before the
I would
committee.
only request not for some
No.
lesser punishment ಮನೋಡ್.
1 ಲಕ್ಷ
ಅಲ್ಲ,
ಕಟ್ಟಿ ಏನ್
10 ಜನ
ಪರವಾಗಿಲ್ಲ.
ಇದಾರೆ ಸ್ವಾಮಿ that.
You are not paying out of your pocket, you are stealing somebody. You are stealing from somebody, pay to some poor people who can take some benefit.
ಮನೋಡ್, if ಮನೋಡ್ if not out of record, if this notice is ಮನೋಡ್ set aside with the liberty to ಮನೋಡ್ APMC to collect this fine amount, ಅದನ್ನ ಹಾಕಿದ್ರೆ
Fine amount
once
ಅಲ್ಲ.
for all close
Let them-
ಆಗುತ್ತೆ sir.
let them consider in accordance with law.
ಈಗ ನಾವು ಕಮಿಟಿ ವಿರೋಧ ಹೋಗಿದೆ
ನೀವು
ಮತ್ತೆ ಅವ್ರು
APMC yard ಅಲ್ಲಿ ನೀವು ಮನೆ ಕಟ್ಕೊಂಡಿದ್ರೆ,
ಇಲ್ಲ ಇಲ್ಲ we are running a business ಮನೋಡ್, we are running
do not know, he says you have constructed a house.
ಮೇಲ್ ಕಡೆ ರೂಮ್ ಇದೆ, we are admitting ಮನೋಡ್, we have constructed one room for ಮಧ್ಯಾಹ್ನ ಸ್ವಲ್ಪ one hour ರೆಸ್ಟ್ ಸಿಗುತ್ತೆ ಸ್ವಾಮಿ, ಅಷ್ಟಕ್ಕೂ
ಒಂದ್ ರೂಮ್ ಇದ್ರೆ ಕಟ್ಕೊಳ್ರಿ, ಮನೆನೇ ಇದೆ ಅಂತ ಹೇಳ್ತಿದ್ರು.
ಇಲ್ಲ sir, ಮನೆಗಳಿಲ್ಲ ಮನೆಗಳು
Let them consider. ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡ್ರಿ. Want to get instructions from your client, you please get them. But nothing less than 1 lakh.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ.
No, nothing less than 1 lakh. ಒಬ್ಬೊಬ್ರಿಗೆ 1 ಲಕ್ಷ. Mr. Proceedings are held. You have come to this High Court.
Yes.
High Court has directed you. For that also they've engaged a lawyer.
ಇಲ್ಲ
You don't file your objections. You allow the order to be passed, then you file objections.
I would request no, let it be in the form of order of the court,
It will
non-consent.
be in the form of an order of court.
Non-consent ಕೊಟ್ಟೆ ಅಂದ್ರೆ ಕಷ್ಟ.
ತಿರ್ಗಾ ಅದು ಅಪೀಲ್ ಹಾಕತ್ತೀರ ನೀವು.
ಇಲ್ಲ ಬೇಡ.
ನಮಗಿದಿಲ್ಲ.
ಅಪೀಲ್ ಏನ್ ಬೇಡ, ಸ್ವಲ್ಪ ಮುಗಿದ್ರೆ ಸಾಕಾಗಿದೆ.
ಅಲ್ಲೆಲ್ಲ ಕಾಸ್ಟ್ ಮೇಲೆ ಅಪೀಲ್ ಹಾಕತ್ತೀರ.
ಇಲ್ಲ.
ಎಲ್ಲಾದ್ರೂ ಉಂಟಾ? You get instructions.
It could be passed over for 5 minutes, Manod. I will.
Passed over for 5 minutes. Otherwise, I'll relegate you back to the appeal. Go and file an appeal.
Lords, I am for the petition. It's the petitioner is a registered cooperative society, my lords. The respondent number 2, working as a secretary, my lords, indulged.
Petitioner is a cooperative society.
Cooperative society, my lords, credit society. Respondent number 2, my lords, indulged in a misappropriation, my lords, which results in a suspension. Lords, suspension was on 5/1/2012. Lords, he raised section 70 dispute, my lords. Lords, section 70 dispute allowed on 15/3/2014. The order of under section 70, my lords, a direction was to the petitioner to, lords, the suspension period may be converted into a service. Lords, and further directed to pay the monetary benefits, my lords. Against that order, my lords, the petitioner filed an appeal under note 5 of the.
So what was challenged in the section 70 proceedings was only the order of suspension.
Suspension, my lords. Only the order of suspension was allowed. Against that, my lords, the petitioner society files an appeal, my lords. Appeal, there was no interim order. Lord's appeal was sent to Belgaum camp. Lord's petitioner counsel did not appear, my lords, which results in dismiss for non-prosecution. Lords, later, my lords, the respondent number 2 file an execution in 356 of 2019. Notes wherein the petitioner files an application under Order 21, Rule 26, seeking for interim order, my lords. The trial court recorded a finding that, my lords, there was sufficient time to obtain an interim order from appellate authority. The petitioner did not obtain an interim order. Therefore, my lords, my application is rejected. This is one set of facts, my lords. Identically, my lords, on 4/9/2016, there was an inquiry under section 64 was conducted. 68 order was passed. Note 68 order, my lords, at page 62. Page 60, my lords. 60, my lords. 60. It is found that, my lords, total there are 1,620 farmers benefit was, my lords, the misused by the secretary. My lords, out of that, my lords, 73 farmers were not paid. Rest of the farmers were paid, my lords, and a liability was fixed of 1,56,248. Relying on this order, my lords, the surcharge proceedings was initiated. Lords, this 68 order was called in question by the respondent number 2 in writ petition 201806 of 2018. That writ petition was allowed, my lords, and the order under section 68 was set aside. Against it, my lords, the writ appeal was filed by the petitioner.
Order under 69 was set aside.
68 was set aside, my lords. Against it, my lords, the petitioner society files an writ appeal 2000113 of 2014, wherein, my lords, the petitioner got an interim order. Lords, there is a liability in a inquiry, my lords, against the respondent number 2. Lords, my submission is, my lords, appeal is pending, my lords. The appeal was not heard on merits, my lords. We are making efforts to get it listed, my lords. Again, it was sent to the Belgaum camp. Lords, my submission till the disposal of, my lords, the appeal, my lords, the
Deposit ಮಾಡಿ ಸ್ವಲ್ಪ.
Alla, I might submit, my lord.
at the same time, my lords, there is a liability against the respondent number
No,
2.
What
I'll
will be
just
the-
explain.
what will be the financial implication?
Yes.
If the order passed by the under section 70 is complied with, what will be the financial implication?
Lords, 6,67,320.
Mickey deposit ಮಾಡಿ.
Illa, that will also, I'll just explain.
Just trying to know from him.
I've been held guilty for 1,05,000 lakhs. The amount which due from them is now running into 17 lakhs as on today.
It's my
Let them retain 1.5 lakhs,
submission, my lords.
release the rest.
If I succeed, my lords, to sustain the 68 order, then, my lords,
The
he.
68 is only 1,50,000.
Please, my lords, it's not about amount, my lords. If I sustain, my lords, that order, then it amounts to, my lords, he's proved that he is misconduct, indulged in a misappropriation.
That is subsequent.
Subsequent.
That is subsequent. Suspension is in respect of an earlier act. You
Now
can't
he's
mix.
I'm told, now he is dismissed, my lords. After the 68 order is passed, he is
ಇದನ್ನ ಅವ್ರು ಏನೋ
dismissed from
challenge
service.
ಮಾಡ್ಕೋತಾರೆ, ಏನೋ ಆಗ್ತದೆ, ಅದು ಬೇರೆ ವಿಚಾರ.
In fact,
You deposit the remaining.
may I just submit, my lords?
Lords.
They, this is a dispute between the elected body and the secretary. The body which came to be elected at the point of time, it was under the impression that I have helped canvass the other party, the losing party.
There is no records. my lords.
It is my pleading in the other petition. Under that impression, my lords, they first issued a charge against me saying that I have misappropriated certain amount to the tune of 40 lakhs.
ಎಷ್ಟು?
40 lakhs. That was found to be this thing. A report was filed by the ARCS after conducting an audit that there is no misappropriation. Again, after some time, after a few years, again there is the same contention. Same charge, same period, same amount. That time an inquiry officer of their choice was appointed by them. Inquiry officer, he prima facie found that about 40 lakhs was misappropriated. Inquiry was held behind my back without affording me cross-examination opportunity. All of them came and submitted that they have withdrawn the amount, secretary is not to blame. So finally, they could only muster few people, their choice, who totally come to the conclusion that 1.5 lakh was misappropriated. out of the alleged 40. They did not challenge in an appeal that amount. In fact, I preferred an appeal before the appellate authority regarding only 1.5 lakhs. That appeal was dismissed. I preferred a writ petition before this honorable court. This honorable court held that I have not been given any opportunity, therefore it remanded the matter. They file a writ appeal against that and obtain a stay. That is the present position. A writ appeal is pending, there is a stay of the inquiry. They have not challenged the misappropriation, only holding that I am guilty of 1.5 lakh. I have challenged it for 3 courts. In fact, I am sure on the material on record that even that will be dismissed. That allegation will also be dismissed. Now, because 1.5 lakh is due from me allegedly, they are withholding 17 lakh of my pay.
That is what I asked him.
Let him retain, let him release the rest of it.
The amount was 6,67,320.
On what?
And in fact, my lord,
On what basis? Give a calculation. From the
May-
date of suspension. From the
fact,
date of suspension till the date the order was passed under section 70, what will be the financial implication?
in fact, may I just pass on? An attachment warrant was issued, attachment of properties. The secretary gave an undertaking that within 2 days he will pay the amount before the court. Then they obtain a writ petition by suppressing that.
It's a part of record. I filed page 120 minutes. I filed the order sheet. Nothing was suppressed.
May not have suppressed.
This letter.
But how does it help him? You are not suppressed. ಅವನಿಗೇನ್ ಬೆನಿಫಿಟ್ ಹೇಳಿ ನೀವು ಸಪ್ರೆಸ್ ಮಾಡದೇ ಇದ್ರೆ ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ ಡೆಪಾಸಿಟ್ ದಟ್ ರಿಮೈನಿಂಗ್ 19 lakhs or 18 lakhs or 17 lakhs.
Notes ಅಷ್ಟು 19 lakhs ಏನು ಆಗೋದಿಲ್ಲ. Notes
ಆಯ್ತು ಏನ್ ನೀವು ಲೆಕ್ಕ ಕೊಡಿ ಯುವರ್ ಮೆಮೋ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್.
Notes according to their application notes 8,15,360.
Before the executing court.
Before the executing court.
In my EP, I claimed that.
EP ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಅಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿ ಫಸ್ಟ್.
Before the trial court.
Before the executing court, before this court, whatever you want.
ಈ court ಮುಂದೆನೆ ಡೆಪಾಸಿಟ್.
ಆಯ್ತು ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
It's 4 weeks time.
4 weeks. Dragon on my lord is growing up children ಇದ್ದಾರೆ.
ನಾಳೆ ನಾಡಿದ್ದು.
Family.
It's all in the account. You have to only transfer it. For next Saturday. First.
There is a finding against him, my lords.
That's okay,
he's
but you
indulged
show
in
your bona fides.
appropriation.
No. You show your bona fides that you want to get the issue resolved. See, if some money has to be paid to him, it has to be paid to him. How can you keep him waiting for so long?
Let's see, if I succeed in a appeal, my lords, what
You first deposit money. If you succeed, you get
Succeed
it back.
1.5 lakh they are entitled at the most.
without
Any
my lords, I will deposit, my lords, but
ಇವಾಗ ಇನ್ನ KT appeal ಅಲ್ಲೋ ಆಗ್ಬೇಕು.
That is only a suspension order. Now final order has been passed.
KT appeal ಅಲ್ಲೋ ಆಗ್ಬೇಕು. And ಇವಾಗ 68 proceedings ಅಲ್ಲಿ ಬರೀ 1.5 lakhs, assuming that to be true.
lords, it's a fact finding.
ಆಯ್ತು, assuming that to be true, you take out fresh steps. ಈಗ 1.5 lakhs ಇರೋದ್ರಿಂದ you take out fresh steps and to dismiss him, no issue.
Already dismissed, my lords.
ಆಯ್ತು, dismiss ಆದ್ರೆ ಗೊತ್ತಿಲ್ಲ.
Dismiss ಆಗಿದೆ.
Dismiss ಮಾಡಿದ್ರೆ it has to be in accordance with law, whether you issued notice, ಅದು ಇದು enquire ಮಾಡಿದಿರೋ ಇಲ್ವೋ, all those things they will work it out. But retain that 1.5 lakhs, ಮಿಕ್ಕಿದ ಲೆಕ್ಕ ಕೊಡಿ, deposit ಮಾಡಿ. As per the.
In terms of EP, my lords, 8 lakhs something.
ಯಾವಾಗ ಮಾಡ್ತೀರಿ?
ಅಲ್ಲ EP I think it is a norm. ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇದೆ.
May I request, my lords, we will deposit, my lords, but ಅವ್ರಿಗೆ withdrawal permission ಕೊಟ್ರೆ.
Permission ಕೊಡೋದಿಲ್ಲ, first deposit ಮಾಡ್ರಿ. What is the amount? EP ನಲ್ಲಿ
8 lakhs ಅಂತೇನೆ.
ಎಲ್ಲಿದೆ?
Please.
ಎಲ್ಲಿದೆ ಅಂಬೇಕರ್?
Please. EP is on page number.
Page 83, my lords.
What is the amount?
83.
83,
8 lakh
page
15,360.
ಅಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡಿ.
That is in 2019, my lords.
When were you terminated?
Pardon?
When were you terminated? After the 68 order?
My lords, on
Still,
page 62, my lords.
Date is
It is on
7/10/2016.
2016.
16 ಅಂತಾರೆ. Thereafter it was that order was set aside.
my lords, it is 7/10/2016.
How is he making a claim of up to 2019? Purport. After hearing the learned counsel for the petitioner and the learned counsel for the respondent number one, respondent number two, this court felt that the respondent number two has been deprived of the benefit of an order passed under section 70 of the Karnataka Cooperative Societies Act for nearly 12 years. 12 years. Full stop. Therefore, this court directed the petitioner to deposit a sum of rupees 8,15,360, which was claimed by the respondent number two before the executing court. The learned counsel for the petitioner undertook to deposit the money, deposit the aforesaid amount before the executing court within a week.
2 weeks and 8 lines.
Within 2
ಅವೆಲ್ಲ
weeks.
ಸಣ್ಣ ಕ್ರೆಡಿಟ್ ಸೊಸೈಟಿ
ಇದು ಪ್ರೈಮರಿ ಸೊಸೈಟಿ ಅಲ್ಲ ಇದು.
ಪ್ರೈಮರಿ ಕ್ರೆಡಿಟ್
Primary
ಸೊಸೈಟಿ ಅಷ್ಟು ರೊಕ್ಕ ಇರೋದಿಲ್ಲ ಅವ್ರು.
Credit within 2 weeks. Hence, to ensure compliance list on.
Six. Any withdrawal subject to permission of this honorable court.
Just to mention that this, the amount deposited by the petitioner shall not be released until further orders from this.
Obliged.
Yes. K. Ramachandra. Purish Kashampur.
Challenge the endorsement, my lord. At annexure L.
ಏನ್ endorsement?
ಅಲ್ಲಿ ಸೈಟ್ಸ್ ಇಲ್ಲ ಒರಿಜಿನಲ್ ಅಪ್ರೂವ್ಡ್ ಮ್ಯಾಪ್ ಪ್ರಕಾರ ದೇರ್ ಇಸ್ ನೋ ಸೈಟ್ಸ್ ಆಫ್ 71, 72, 73, my lord.
Yeah, please read the endorsement.
ಪ್ಲೀಸ್ my lord. ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1ರಲ್ಲಿ ಆಸ್ತಿ ಸಂಖ್ಯೆ 72ರ ಆಸ್ತಿಯ ನಮೂನೆ ನಂಬರ್ 3 ವಿತರಿಸಲು ನಗರ ಮತ್ತು ಗ್ರಾಮಾಂತರ ಯೋಜನೆ ಇಲಾಖೆಯ ತಿದ್ದುಪಡಿಗೊಳಿಸಿದ ಬಡಾವಣೆ ನಕಾಶೆ ಲಗತ್ತಿಸಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಸಲ್ಲಿಸಿದ ಬಡಾವಣೆ ನಕಾಶೆ ದಾಖಲಾತಿಯಲ್ಲಿ ಒಟ್ಟು 73 ನಿವೇಶನಗಳಿದ್ದು, ಆದರೆ ಸದರಿ ಕಾರ್ಯಾಲಯದಲ್ಲಿ ಇರುವ ಸರ್ವೆ ನಂಬರ್ 396/2000ರ ಬಡಾವಣೆ ನಕಾಶೆ ಹಾಗೂ ಸದರಿ ಕಾರ್ಯಾಲಯದಲ್ಲಿ DCB ವಹಿಯನ್ನು ಪರಿಶೀಲಿಸಿದಾಗ ಆಸ್ತಿ ಸಂಖ್ಯೆ 71, 72, 73ರ ಆಸ್ತಿಗಳು ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಉಲ್ಲೇಖ 2-3ರಲ್ಲಿ ತಿದ್ದುಪಡಿಯಾದ ವಿನ್ಯಾಸದಲ್ಲಿ 73 ನಿವೇಶನಗಳು ಹಾಗೂ ಸದರಿ ವಿನ್ಯಾಸದಲ್ಲಿ ನಾಗರಿಕ ಸೌಲಭ್ಯ ಸ್ಥಳ ಕಂಡು ಬರುವುದಿಲ್ಲ. ಆದ್ದರಿಂದ ಮೂಲ ಅನುಮೋದಿತ ವಿನ್ಯಾಸ ಹಾಗೂ ತಿದ್ದುಪಡಿಯಾದ ನಮೂನೆಯನ್ನು ವಿನ್ಯಾಸಗಳ ಮೂಲ ಪ್ರತಿಗಳು ಹಾಗೂ
ಬಂದಿಲ್ಲ, ರಾಮಚಂದ್ರ ಬಂದಿಲ್ಲ. There is no representation for the petitioner. List on.
ಅಲ್ಲ 30 ಅದು ಒಂದ್ ಡೇಟ್ 30
ಇದಕ್ಕೆ ಹೋಗ್ತಿದ್ದೀರಾ?
ಪ್ರಯಾಗ್
ಪ್ರಯಾಗ್ರಾಜ್.
ಪ್ಲೀಸ್.
ಮನೂರೆ ಅಶೋಕ್ ಕುಮಾರ್. ಸುದರ್ಶನ್. There is no representation for the petitioner. List on. In Agata, does it survive?
My lord, probably maybe like earlier matter, my lord, last semester, we will, please go through, please.
BV Jalde. Krupa Sagar.
Yes, I seek for a week's accommodation, Lord. I have to seek instructions.
Counsel for the respondent seeks time to file statement of objections. List on date for it. Sachin Mahajan. Gaurish Kashampur.
Lord, the petitioner here in Lord is the owner of the property measuring about 5,000 square feet. He purchased the property and registered sale deed. He obtains the construction permission from the municipality. My lord, the respondent issues a notice on Lord 24/1/2024, calling upon me to, my lord, demolish a certain arch which is constructed by me within 24 hours. Demolish, my lord, an arch which is constructed by me within 24 hours. My lord, no inquiry, my lord, as contemplated under section 187 is conducted. I immediately give a reply, my lord. Annexure F, my lord, 24/1/2024 is the notice. It is in fact an order, my lord, not a notice.
demolish ಆಗೋಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ.
Demolish ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. My lord, I have sought for damages, my lord, and consideration of my representation. My lord, the two submissions, my lord. One, my lord, the damage can be quantified, and the things are there, my lord. There is no denial about the fact, my lord, that the municipality has demolished it. The commissioner, the then chief officer, he has issued, my lord, a reply stating that, my lord, he has demolished it, and, my lord, I am required to pay 25,000 rupees towards, my lord, charges for demolition. So, in so far as demolition is concerned, my lord, that is not denied. The next thing, my lord, would be regarding quantification, my lord. Insofar as quantification is concerned, one, my lord, first prayer, my lord, is to, my lord, direction to pay damages. The second prayer, my lord, is to consider my representation. Where, my lord, I have given all the accounts and, my lord, the receipts and everything, my lord, as to how the.
We can't give this direction. Young Kodakar.
My lord, 187, there is absolutely no compliance, my lord.
Correct, no, it's already demolished. It's already gone. You have come to the court asking for determining what should be the compensation payable.
My lord, I have produced all the records, my lord, to.
Can the High Court do it in?
True, my lord, true, my lord, true. My second leg of the prayer is, my lord, to consider that representation, my lord, and.
Why do you demolish this?
My lord, construction permission is taken for the construction of house, my lord. Kindly see the page number 27-28, Annexure D, my lord. Construction permission was taken for construction of house, constructed the commercial arch in the public road, my lord.
Public road.
Public road. If it is in the notice, my lord, he is certainly, my lord, entitled to say so.
For
There should
construction
be
of
such-
house,
such a
whether it is
mention in the
permissible
notice.
to construct the arch in the main road, whether it is permissible in the eye of law, my lord.
No, you should mention so in the notice.
My lord, this kind of submission, they are violated the conditions of the construction permission, my lord.
Is a club ಅಂತಿದೆ.
ಅವ್ರು ಅದನ್ನ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಪರ್ಮಿಷನ್ ಮನೆ ಅಂತ ತಗೊಂಡು ದೇ ಆರ್ ಕನ್ವರ್ಟೆಡ್ ಟು ರಿಕ್ರಿಯೇಷನ್ ಕ್ಲಬ್, ಮೈ ಲಾರ್ಡ್. For that reason, authority has taken a
It is an
step,
arch which is constructed, my lord.
Where have you constructed the arch? If it's in a house, in your site, we can
My
understand.
lord, it's a 5,000, my lord, square feet, huge plot, my lord. I have for aesthetic value and enhancement, my lord, of aesthetic value, put up an arch. Now, this is where, my lord, 187, I am required, my lord, to.
ನೀವು ಫೋಟೋ ಹಾಕಿದ್ರೆ page 47, 46.
Yes, my lord.
ಆರ್ಚ್ ಹಾಕಿದ್ರೆ ಮನೆ ಎಲ್ಲಿದೆ?
My lord.
You can
Yes, my
see
lord.
the- you can see the arch in
Yes.
page number 46.
Yes, yes.
But I don't see the house. Where is
My
the
lord,
house?
I'm still to put up the house. My lord, for identification of the property to enhance the aesthetic value, my lord, I put up an arch. It is well within my boundaries. If it is illegal, my lord, they were, my lord, required to hold an inquiry under 187. Permit me to, my lord, take it out on my own. They can't, my lord, bring it down.
File a civil suit, take whatever. ಬರ್ಕೊಳ್ಳಿ.
My lord, let them consider that representation, my lord.
Oh, no. The petitioner has sought for writ in the nature of mandamus, directing the respondents to pay compensation of rupees 5,07,150 and damages of rupees 1 lakh. Or in the alternative, to issue appropriate direction to the respondents to consider the representation dated 15th February 2024 in a time-bound manner. Next para. The petitioner contends that he is the owner of an open plot bearing number TMC 16229, situated at Zerpet Gully, Umnabad, Bidar district, having purchased it in terms of a sale deed dated 30th of June 2021. His name was entered in the municipal records on 7/9/2021. Full stop. The petitioner sought permission to construct a building with a application dated 7/10/2020. The respondent issued the permission on 19/5/2023. The petitioner claims that he erected an arch gateway to enhance the aesthetic value of the construction that would be that is to be put up in the property. Full stop. Petitioner contends that he spent a sum of rupees 5,07,140 for erecting the arch. Full stop. When things stood thus, the chief officer of the respondent issued an illegal order. Chief officer of the respondent number 3 purportedly issued an illegal order in the garb of a notice dated 24/1/2024, contending that the arch was put up unauthorizedly and called upon the petitioner to remove it within 24 hours. Full stop. The petitioner contends that no mention was made as to how the construction of the arch violated any provision of law. Full stop. The petitioner was thereafter served. The petitioner thereafter submitted a reply on 25/4/2024, claiming that the arch was erected for the purpose of identification of his property, where the construction was yet to begin. Full stop. The petitioner contends that the respondent number 3, being a statutory corporation, is bound to comply the provisions bound to comply the procedure set out in section 187 of the Karnataka Municipalities Act 1964. However, the respondent number 3, without considering the reply submitted by the petitioner, demolished the arch on 24/1/2024. Full stop. The petitioner therefore submitted the petitioner alleged that the respondent number 3, after demolishing the arch, had shifted the entire material and dumped it at the premises of the respondent number 3. Full stop. The petitioner thereafter submitted a representation contending that the demolition was illegal and unauthorized and was not in accordance with law, and therefore called upon the respondents to pay damages of rupees 5,07,140. The petitioner is therefore before this court seeking for a direction to the respondents to pay a sum of rupees 5,07,140 or to direct the respondents to consider the representation filed by the petitioner on 15/16 February 2024. Next para. The learned counsel for the petitioner contended that the petitioner had erected
One
the arch.
submission maybe I am permitted to add.
Huh?
Along with the memo, my lord, I have furnished a document wherein, my lord, the demolition is admitted by the chief officer.
Right.
Memo dated along with the filed a memo
Hmm.
in which there is, my lord, communication dated 23/4/2024, wherein, my lord,
Learned
the
counsel
then
for the
chief officer.
petitioner submitted that the petitioner had erected the arch for the purpose of identification of his property and to make the entrance to the property attractive. He submits that there is no provision in law which prohibits the petitioner from erecting an arch. He also contends that the respondent number 3, without taking action after complying the due process of law, had taken law into its hands and demolished the building, demolished the arch. Full stop. He contended that the respondent number 3 has now issued a
Clarification come intimation
Yeah,
to
issued a
remit the labor and
clarification-
equipment charges incurred for removal of the
clarification
illegal.
cum intimation dated 23/4/2024, demanding a sum of rupees 25,000 as the expenses towards equipment and labor for bringing down the arch put up by the petitioner. He therefore contends that the respondent number 3 has admitted the demolition of the arch, and therefore the respondent number 3 is bound to make good the loss suffered by the petitioner. Full stop. Per contra, the learned counsel for the respondent number 3 submits that the arch was constructed not within the property of the petitioner, but was constructed on the road margin,
Please, ma'am.
road margin, unauthorizedly and illegally and without obtaining any permission from the respondent. Therefore, he contends that the respondent number 3 was well within its power to bring down the unauthorized arch erected by the petitioner. He submits that the petitioner was called upon to remove the arch, but since he did not do it, the respondent number 3 was perforced, PERFORCED, perforced to pull down this structure. He contends that nowhere in the writ petition, the petitioner has contended that the arch was put up in a property which belongs to the petitioner. Thus, he contends that the petitioner is not entitled to any remedy. This apart, he contends that the petitioner has sought for a writ in the nature of mandamus to direct the respondents to pay a sum of rupees so and so, and this so and so, and this court cannot, in exercise of its power under Article 236, compel the respondent number 3 to do so, to comply with the demand made by the petitioner, as there is no corresponding statutory duty cast upon the respondent number 3 to pay compensation to the petitioner. He submits that the respondent number 3 is bound by the provisions of the Karnataka Municipalities Act 1964 and is entitled to bring any unauthorized and illegal construction in line with the provisions of the Act, and also to protect the interest of the general public. Full stop. Next, I have considered submissions of the learned counsel for the petitioner and the learned counsel for the respondent number 3. Next para. The fact that the petitioner had put up an arch is not in dispute. It is also not in dispute that the respondent number 3 has demolished the arch so put up by the petitioner. The question is whether the arch was put up in the property of the petitioner or outside the property of the petitioner in a road margin area.
And one more submission, my lord. And whether it is in accordance with the construction permission.
It is also not known whether the petitioner had obtained any permission for putting up any arch from the respondent number 3. Full stop. In the absence of any of these relevant documents, the petitioner cannot contend that the arch erected by him was legal, was lawful. Besides this, he is not mentioned anywhere in the writ petition that the arch erected by him lay within his property. Therefore, this court cannot, Have you mentioned?
It's the
anywhere?
contention of the other side, my lord. Your
No,
lordship.
is it mentioned? Have you mentioned
I'm sorry.
anywhere?
I'm sorry, my lord. My anxiety, my lord.
ಅಲ್ಲ, ನೀವ್ ಹೇಳಿದಿರಾ?
My lord, I have stated, my lord, it is well within the
ಇಲ್ಲಿ
limits.
where have you mentioned?
My lord,
Where have you mentioned
my
that?
lord, I have stated so, my lord.
ಹೇಳಿ ತೋರ್ಸಿ.
Petitioner has put up RSV for the purpose of beautification which is lawfully owned and, in the property, my lord, paragraph number 4. The
Para?
petitioner has put up the arch gateway for the purpose of identification, beautification, and to enhance the aesthetic value of the construction that is to be put up in the property which is lawfully owned and possessed by the petitioner.
ಆರ್ಚ್ ಎಲ್ಲಿ ಕಟ್ಟಿದ್ರು? ನಿಮ್ ಪ್ರಾಪರ್ಟಿಲಿ ಎಲ್ಲಿ?
My lord, in the property,
That is to enhance the aesthetic value of the construction that is to be put up.
that is to be put up in the property. My lord,
ಸಿಂಪಲ್ ವರ್ಡ್ಸ್ ಅಲ್ಲಿ ಆರ್ಚ್ ನನ್ನ ಜಾಗದಲ್ಲಿ ಇದೆ ಅಂತ ಇಲ್ಲಿ ಹೇಳಿ.
Lord, this is where, my lord, 187 comes into picture, my lord. There has to be a provisional order.
At least for me to take it forward, where have you mentioned in the petition that the arch was constructed in the property which belongs to you?
Yes, my lord. I'll take 2 minutes of your lordship's time, my lord. One, in the notice, my lord, there is no allegation that, my lord, it is outside the property. And, my lord, the objection taken by, my lord, the respondent in the reply, he states it's a commercial activity for which I have not taken permission. Even in the reply, my lord, his contention is not that, my lord, it is situated on the road. This is the submission, my lord, which is now being made for the first time, my lord, before your lordship.
Therefore, this court cannot go into disputed questions of fact to arrive at a conclusion that the demolition of the arch by the respondent number 3 was illegal or unauthorized. This court also cannot take cognizance of the claim of damages. Full stop. If the petitioner is entitled to claim any damages from the respondent number 3, he must do so before the appropriate civil court by establishing the expenses incurred for the arch and the fact that the arch was put up in a property which belonged to him, and that the construction of the arch was in accordance with permission granted by the respondent number 3. Full stop. In that view of the matter, this writ petition stands disposed of, subject to the above observations.
Great.
ಯಾವುದೋ ಒಂದು ಏನೋ ಅರ್ಜೆಂಟ್ ಇತ್ತಲ್ಲ, ಯಾವುದೋ ಒಂದು ಯಾವ್ದು? Yes. 70? 74. 74.
My lord. My lordship has directed us to be furnish how the voter list is going to be preparing, my lord. In that connection, my lord, my humble submission, my lord, as people the Representation of the People Act 19. Representation of the People Representation Act, my lord. Representation of People Act 1951.
There was some order earlier.
Yes, on 10th of January, my lords have passed an order directing the learned AAG to submit as to whether there are additions and deletions subsequent to the list of voters at Annexure B.
ಇದು ನೋಡಿದಿರ ಇದು? I have seen this order.
Directions, my lord, we have been. My lord,
ನೋಡಿ, please go through this. Have you?
Election very connected.
I will submit.
ನೋಡಿದ್ರಲ್ಲ? ಕೊಡ್ರಿ.
I will submit it, man. Tomorrow.
ಹೇಳಿ.
Tomorrow itself, I will submit.
Tomorrow. Why tomorrow?
My lord, regarding the 22 elections, my lord, I can take your lordship, the kind attention. There is a circular issued by the central government, my lord, as on the date 7th August 2024, my lord. On that guidelines only, the preparation of list.
May I pass?
One more ಇದೆ, one more ಇದೆ, one more. ಇದು ಆಗ್ಬೋದು, ಇದು ಕೊಡಿ.
Queried spelling ಏನು? Queried.
7-1.
Queried spelling ಏನಮ್ಮ? ಆಯ್ತ್ರಿ. Queried spelling ಏನು ఉంది? ನೋಡ್ರಿ. ತೆಗೆದು ನೋಡಿ. Queried spelling ಏನು?
Let the first I will take my attention of this honorable court, how the preparation of the voter list is going to be prepared.
Yeah, red petition.
Then this notification is comes under the subsequently, my lord.
ಆಯ್ತು, let him start.
Yes.
Please.
My lords, the petition is by one of the elected corporator of Vijaypur Corporation, Municipal Corporation. The election to the post of mayor and deputy mayor has to be conducted every year. Accordingly, my lords, the last of the elections was on 9th of January 2024, the term of which came to be ended on the 8th of January 2024.
9th of January 2023.
9 January 2024 was the last election for the post of mayor and deputy mayor. And that term ended on the 8th of January this year, 2025. As a norm, 1 month prior to the conclusion of that ending of that period, the voters list and the calendar of events for the purpose of meeting for holding the elections of the mayor and deputy mayor will be generally issued. In this case, my lords, that is not issued within that 1 month period at all. That's not the dispute at all. Now, what happens is the document is now there is a communication by the officer at Annexure D, Annexure E, page number 39. The Commissioner of Corporation Vijaypura makes a communication to the Regional Commissioner Belgavi on the 24th of December 2024, stating that along with a list of voters, which list of voters I have produced at Annexure B.
Let us read.
Yes. ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆಯ 22ನೇ ಅವಧಿಗಾಗಿ ಮಹಾಪೌರ, ಉಪಮಹಾಪೌರ ಮತ್ತು ವಿವಿಧ 4 ಸ್ಥಾಯಿ ಸಮಿತಿ ಸದಸ್ಯರುಗಳ ಚುನಾವಣೆಗೆ ದಿನಾಂಕವನ್ನು ನಿಗದಿಪಡಿಸುವ ಕುರಿತು. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆಯ 21ನೇ ಅವಧಿಯ ಮಹಾಪೌರರು ಮತ್ತು ಉಪಮಹಾಪೌರರ ಚುನಾವಣೆಯು ದಿನಾಂಕ 9/1/2024 ಜರುಗಿದ್ದು, ಇವರ ಅವಧಿಯಾದ ದಿನಾಂಕ 8/1/2025 ಮುಕ್ತಾಯಗೊಳ್ಳಲಿದ್ದು, ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ 22ನೇ ಅವಧಿಗಾಗಿ ಮಹಾಪೌರ, ಉಪಮಹಾಪೌರ ಮತ್ತು ವಿವಿಧ 4 ಸ್ಥಾಯಿ ಸಮಿತಿ ಸದಸ್ಯರುಗಳ ಚುನಾವಣೆ ನಡೆಸಲು ದಿನಾಂಕವನ್ನು ನಿಗದಿಪಡಿಸಬೇಕಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಪಾಲಿಕೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಚುನಾಯಿತ ಸದಸ್ಯರುಗಳ ಹಾಗೂ ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಲೋಕಸಭಾ ಸದಸ್ಯರು, ವಿಧಾನಸಭಾ ಸದಸ್ಯರುಗಳು ಮತ್ತು ವಿಜಯಪುರ ನಗರದಲ್ಲಿ ವಾಸವಿರುವ ವಿಧಾನ ಪರಿಷತ್ ಸದಸ್ಯರುಗಳ ಮತದಾರರ ಪಟ್ಟಿಯ ವಿವರಣೆಯನ್ನು ತಹಶೀಲ್ದಾರ್ ವಿಜಯಪುರ ರವರು ನೀಡಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ 22ನೇ ಅವಧಿಗೆ ಮಹಾಪೌರ, ಉಪಮಹಾಪೌರ ಮತ್ತು ವಿವಿಧ 4 ಸ್ಥಾಯಿ ಸಮಿತಿ ಸದಸ್ಯರುಗಳ ಚುನಾವಣೆ ಜರುಗಿಸುವ ಕುರಿತು ಪಾಲಿಕೆಯಲ್ಲಿನ ಪಕ್ಷಗಳ ಬಲಾಬಲ ಮತ್ತು ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ದೃಢೀಕರಿಸಿ ಈ ಪತ್ರ ಜೊತೆಗೆ ಲಗತ್ತಿಸಿ ಮಾನ್ಯರ ಅವಗಣನೆಗಾಗಿ ಸಾದರಪಡಿಸಿದೆ. ಅಡಕ ಪುಟ ಸಂಖ್ಯೆ 1ರಿಂದ 15ರವರೆಗೆ ಲಗತ್ತಿಸಿದೆ. As I am instructed, Annexure B at page 28 is the list of voters which the Tahsildar has, which the Corporation Commissioner has issued along with this letter. Now, my lords will also see the number of this letter at page 39. This is MNPAV Council 2024-25/5364. Now, as per this letter, there is a voters list, which in fact the controversy is here, which does not include the name of 4 new MLCs who are now tried to be included within the city of corporation without any basis, and a new list of voters is now prepared at the behest of the Tahsildar, showing that these new 4 MLCs also can become a part of this corporation and they can vote in the meeting.
Yes.
Now, my lords, you will see that this is a letter dated 6/1/2024, 12/2024. Now, my lords, the submission I am instructed of the learned AAG is that subsequently there is a calendar of events published for the purpose of holding the meeting for the election of mayor and the deputy mayor, which is to be on the Monday of this month. But the inclusion, there cannot be an inclusion of any new MLC. If your lordships permit me to read the provisions of section 7 of the Municipal Corporations Act,
Annexure B is the voters list.
it's the voters list. My clear submission is, short submission is that the voters list at Annexure B is the one which should be the voters list for the purpose of the election.
Who are the MLCs who are to?
Now, my lords, I may be permitted to furnish along with a memo certain other communications and the lists, if my lords permit. This is the election notification and the voters list which shows who are the new members. Copy.
ಇತ್ತಲ್ಲ ಇಲ್ಲೆಲ್ಲ ರಿಪಿಟಿಷನ್ ಜೊತೆ ಹಾಕಿದ್ರಲ್ಲ.
This list is, my lords, announced only on the 6th of January.
Correct. On the last date, I think you had produced some.
Yes, it was, my lords, by hand it was given. Probably it may not be on record. May I produce this? We have obtained this under RTI, and what was submitted by learned AG, then I am not aware of that copy was not given to us. Kindly see the document number 1, dated 20th of December 2024.
Yes.
And one important document which I want to rely upon, my lords, before your lordships would read that document number 1 is document number 5, the typed copy of which is at page number 8. So this document is dated 6/1/2025. This is from the Karnataka Pradesh Congress Samiti, written to the Corporation Commissioner. Vishaya, ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಮತದಾರರ ಯಾದಿಯಲ್ಲಿ ನಮ್ಮ ಕಾಂಗ್ರೆಸ್ ಪಕ್ಷದ ವಿಧಾನ ಪರಿಷತ್ ಸದಸ್ಯರ ಹೆಸರುಗಳು ಸೇರ್ಪಡೆಯಾಗಿದ್ದು ಮುಂಬರುವ ಪೂಜ್ಯ ಮಹಾಪೌರರು ಹಾಗೂ ಉಪಮಹಾಪೌರರ ಚುನಾವಣೆಯಲ್ಲಿ ಮತ ಚಲಾಯಿಸಲು ಅನುಮತಿಸುವ ಕುರಿತು ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಾನು ಸೋ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿಗಳು APMC ಬರೆದುಕೊಳ್ಳುವ ವಿನಂತಿ ಅರ್ಜಿ ಏನೆಂದರೆ, ನಮ್ಮ ಕಾಂಗ್ರೆಸ್ ಪಕ್ಷದ ಕರ್ನಾಟಕ ವಿಧಾನ ಪರಿಷತ್ ಸದಸ್ಯರುಗಳು ವಿಜಯಪುರ ಜಿಲ್ಲೆ 30 ಬಿಜಾಪುರ ಹಾಗೂ 31 ನಾಗಠಾಣ ವಿಧಾನಸಭಾ ಮತಕ್ಷೇತ್ರದ ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ಸೇರಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಅವರ ಹೆಸರು ಕೆಳಗಿನಂತೆ ಇರುತ್ತದೆ. There are 4 names. ಈಗ ಅವರು ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ ವ್ಯಾಪ್ತಿಯ ಕಾಯಂ ರಹವಾಸಿಯಾಗಿರುತ್ತಾರೆ. ಕಾರಣ ಮುಂಬರುವ ಪೂಜ್ಯ ಮಹಾಪೌರ ಹಾಗೂ ಉಪಮಹಾಪೌರರ ಚುನಾವಣೆಯಲ್ಲಿ ಮತ ಚಲಾಯಿಸಲು ಅವರನ್ನು ಪರಿಗಣಿಸಿ ಪೂಜ್ಯ ಮಹಾಪೌರರು ಉಪಮಹಾಪೌರರ ಚುನಾವಣೆಯಲ್ಲಿ ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಅವರ ಹೆಸರನ್ನು ಸೇರಿಸಿ ಮಾನ್ಯ ಪ್ರಾದೇಶಿಕ ಆಯುಕ್ತರ ಬೆಳಗಾವಿ ವಿಭಾಗ ಬೆಳಗಾವಿ ಚುನಾವಣಾಧಿಕಾರಿಗೆ ಕಳುಹಿಸಿ ಈ ಮೂಲಕ ವಿನಂತಿಸಿರುತ್ತೇನೆ. This is on 6/1/2025. The attempt is made to include these 4 MLCs.
ಸೇರ್ಪಡೆ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ,
ಸೇರಿಸಿಕೊಂಡಿರುತ್ತಾರೆ. ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಹೆಸರು ಸೇರಿಸಿಕೊಂಡಿರುತ್ತಾರೆ.
ತಹಶೀಲ್ದಾರ್, ಹೌದು, ತಹಶೀಲ್ದಾರರು ಸೇರ್ಪಡೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. My lord, now the question before your lordship should be, can there be section 7(1)(d) will permit the MLC of that particular constituency if he is residing in that constituency, if he is also registered as an elector of that constituency to vote. I will read that provision also. Now, my lords, the question before your lordships is that there cannot be an attempt to now say that I am a resident of this town, therefore include my name in the voters list. This cannot happen. There has to be an registration under the electors registration rules 1960. That, my lords, is the requirement which the learned AG has to produce. Section 7 of the Karnataka Municipal Corporations Act. Constitution of the corporation.
Yes.
The corporation shall consist of A, such number of elected councillors not being less than 30 and not more than 200 as the government may by notification determine, and B, not exceeding 10% of the total number of councillors in the case of so and so, and not more than 5 persons in the case of other city corporations nominated by the government from amongst the residents of the city who are persons having special knowledge and experience in municipal administration or matters relating to health, town planning or education, or who are social workers. C, the members of the House of People and the members of the State Legislative Assembly representing a part or whole of the city whose constituencies lie within the city. D, the members of the Council of State and State Legislative Council who are registered as electors within the city, provided that the persons referred to in clause B shall not have right to vote in the meetings of the corporation. Then what's the rest of the provision may not be so relevant.
Yes.
Clause D is that the members of the Council of State and State Legislative Council who are registered as electors within the city is important for the purpose of consideration here. The term of the mayor and the deputy mayor is stated in section 10 of the Act,
Yes.
which shall be 1 year, my lords, from the each year there has to be
Yes,
an
please.
election. Now, my lords will permit me to show this one other document, my lords. We have already stated that these 4 persons which are named in this document number 5 by the Pradesh Congress Committee's request are already having their names in the voters list of their respective different constituencies, not within the city of Vijaypura. That, if I am permitted, I will file a memo to that effect, along with the voters list of 3 of such members out of 4. We were able to only fetch, my lords, the 3 of such. May I be permitted to pass on along with the memo? Copy put to the operator. The 4 names are, my lords, one is in the, along with this memo which is now produced, my lords, on the top, serial number 406, the first page, the top right side, Hesaru Balkis Banu ante. That your lordships will find at serial number 3 in document number 2, serial number 2 in document number 5 at page 8.
Where is she registered?
Please.
Where is she registered as a voter?
This is at the top of that your lordships will find it is Bhadravati. Indra Nagar, Haler Nagara, Bhadravati. And this is also, my lords, obtained under the RTI. Your lordships will find at the bottom of this page the signature of the Tahsildar of Bhadravati on 8th of January 2025. Then the second of the document, my lords, will see at serial numbers 292. That is the 3rd page of this memo. This is, my lords, the words attested by Tahsildar Raichur. Your lordships will find that very number is 292. This is Mr. A. Vasant Kumar. And on the top of this page, it is 54 Raichur is the constituency. This is also issued on the 8th of January 2025. And the name of Mr. A. Vasant Kumar is also found at serial number 4 in document number 5, where it is shown he is from constituency 31 Nagthana. And the last of the document, my lords, the last page, at serial number 934, Jagdev Guttedar. This is constituency Chincholi. And that is also issued by the Abhilekhalaya Shirastedar on 8th of January 2025. The request, my lords, to now include somebody's name cannot happen, lords, unless there is a cancellation of that person's voters list in a different constituency, for which I am also placing a reliance on the judgment of the Honorable Supreme Court in the case of Kuldeep Nair. I will read that also, lords. If I may take your lordships to the relevant provisions of the Registration of Electors Rules 1960.
That is under the RP Act.
RP Act 1950. Read with section 20 of the Representation of Peoples Act 1950.
Yes.
Right from the provisions of section Rule 16 up to the provision under Rule 22 especially.
Yes.
Rule 22, if I am permitted to read. Rule 22 says Matadarara Pattiya Antima Prakatane.
Yes.
ಆ ನಂತರ ನೋಂದಣಾಧಿಕಾರಿಯು ನಿಯಮಗಳು 18, 20, 21 ಮತ್ತು 21A ರೀತಿಯ ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ತಿದ್ದುಪಡಿ ಪಟ್ಟಿಯೊಂದನ್ನು ತಯಾರಿಸತಕ್ಕದ್ದು ಮತ್ತು ಬರಹ ದೋಷ ಅಥವಾ ಮುದ್ರಣ ದೋಷ ಅಥವಾ ಪಟ್ಟಿಯಲ್ಲಿ ಕಂಡುಬಂದ ಇನ್ನಿತರ ದೋಷಗಳನ್ನು ಸರಿಪಡಿಸತಕ್ಕದ್ದು. ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ತಿದ್ದುಪಡಿ ಪಟ್ಟಿಯೊಂದಿಗೆ ಪ್ರಕಟಿಸಿ ಪೂರ್ಣ ಪ್ರತಿಯನ್ನು ನಮೂನೆ 16ರಲ್ಲಿ ನೋಟಿಸ್ ಅನ್ನು ಪ್ರದರ್ಶಿಸಿ ಪರಿಶೀಲನೆಗಾಗಿ ಇಡತಕ್ಕದ್ದು. ಪರಂತು ಮತದಾರರ ಪಟ್ಟಿಯು ಸಾಗರೋತ್ತರ ಮತದಾರನ ಹೆಸರನ್ನು ಹೊಂದಿದ್ದಲ್ಲಿ ಅದು ವಿದ್ಯುನ್ಮಾನ ರಾಜ್ಯ ಪತ್ರದಲ್ಲಿಯೂ ಸಹ ಪ್ರಕಟಿಸಲ್ಪಡತಕ್ಕದ್ದು ಅಥವಾ ಮುಖ್ಯ ಚುನಾವಣಾಧಿಕಾರಿಯ ಅಧಿಕೃತ ವೆಬ್ಸೈಟ್ ನಲ್ಲಿ ಹಾಕಲ್ಪಡತಕ್ಕದ್ದು ಮತ್ತು ಚುನಾವಣಾ ಆಯೋಗದ ಅಂತಹ ಯಾವುದೇ ಸಾಮಾನ್ಯ ಅಥವಾ ವಿಶೇಷ ಸೂಚನೆಗಳ ಪಟ್ಟು ಅಂತಿಮ ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ತಿದ್ದುಪಡಿ ಮಾಡಲ್ಪಟ್ಟ ಪಟ್ಟಿಯೊಂದಿಗೆ ದ್ವಿಪ್ರತಿಯಲ್ಲಿ ಚುನಾವಣಾ ಆಯೋಗದಿಂದ ನಿರ್ದಿಷ್ಟ ಚಿಹ್ನೆಯನ್ನು ಪಡೆದಿರುವಂತಹ ರಾಜಕೀಯ ಪಕ್ಷಗಳಿಗೆ ಉಚಿತವಾಗಿ ಒದಗಿಸತಕ್ಕದ್ದು. ಅಂತಹ ಪ್ರಕಟಣೆಯ ನಂತರ ತಿದ್ದುಪಡಿ ಮಾಡಲ್ಪಟ್ಟ ಪಟ್ಟಿಯೊಂದಿಗಿನ ಪಟ್ಟಿಯು ಮತಕ್ಷೇತ್ರದ ಮತದಾರರ ಪಟ್ಟಿಯಾಗಿರುತ್ತದೆ. ಮತದಾರರ ಪಟ್ಟಿಯು ಇನ್ನು ಮುಂದೆ ಈ ಉಪ ನಿಯಮದನ್ವಯ ಮೂಲ ಪಟ್ಟಿ ಎಂದು ಕರೆಯಲ್ಪಡತಕ್ಕದ್ದು. ತಿದ್ದುಪಡಿ ಪಟ್ಟಿಯೊಂದಿಗೆ ಉಪನಿಯಮ 2ರನ್ವಯ ಮತಕ್ಷೇತ್ರದ ಮತದಾರರ ಪಟ್ಟಿಯಾದ ನಂತರ ನೋಂದಣಾಧಿಕಾರಿಯು ಸಂಬಂಧಪಟ್ಟ ಎಲ್ಲರ ಅನುಕೂಲಕ್ಕಾಗಿ ಈ ಸಂಬಂಧ ಚುನಾವಣಾ ಆಯೋಗದ ಯಾವುದೇ ಸಾಮಾನ್ಯ ಅಥವಾ ವಿಶೇಷ ನಿರ್ದೇಶನ ಮೇರೆಗೆ ಪಟ್ಟಿಯನ್ನು ಮೂಲ ಪಟ್ಟಿಯಾಗಿ ಏಕೀಕರಣಗೊಳಿಸಬಹುದು. ಹೆಸರುಗಳು ಸೇರ್ಪಡೆ, ತಿದ್ದುಪಡಿ, ಸ್ಥಾನಪಲ್ಲಟ ಅಥವಾ ಮೂಲ ಪಟ್ಟಿಯಲ್ಲಿಯೇ ಸೂಕ್ತ ಭಾಗಗಳಲ್ಲಿ ನಮೂದುಗಳು ವಿಲೋಪನ. ಆದಾಗ್ಯೂ ಅಂತಹ ಏಕೀಕರಣ ಪ್ರಕ್ರಿಯೆಯಲ್ಲಿ ಯಾವುದೇ ಮತದಾರನ ಹೆಸರು ಮತ್ತು ತಿದ್ದುಪಡಿ ಪಟ್ಟಿಯಲ್ಲಿ ಯಾವುದೇ ಮತದಾರನ ಸಂಬಂಧ ನೀಡಿದ ಇತರ ವಿವರಗಳ ಬದಲಾವಣೆ ಮಾಡತಕ್ಕದ್ದಲ್ಲ.
Yes.
There is absolutely nothing produced before your lordships pursuant to your lordships order dated 10th of January 2025 stating that there is a registration in the constituency of Vijaypur under the relevant rules, electoral registration of electoral rules. Therefore, my lords, the first contention is that as per Annexure E, when there was a request made by the corporation commissioner to the regional commissioner for the purpose of holding the election of mayor and deputy mayor, the voters list at Annexure B is the valid voters list, which is the only list which can be now utilized, and there cannot be an addition of any other member in that voters list. Secondly, my lords, there is no cancellation of this voters list. Therefore, I am placing reliance on in the case of Kuldeep Nair versus Union of India, 2006, volume 7, SEC, page 1. This is a case where the Honorable Supreme Court holds that one need not be a voter of the constituency for the purpose of contesting the election, but one needs to be an ordinary resident of that particular constituency to be a voter. Relevant paragraph, my lords, will permit me to read at para number 213, page 90.
But after the amendment to the RP Act, this judgment has no value.
The amendment to RP Act, my lords, does not, I will also read that. My lord is referring to a specific provision of the RP Act, my lord?
No, which mandates that he should be an electorate.
Yes.
Of that particular constituency, that is amended now.
RP Act 1950.
Yes.
Because as I understand, my lords, the electoral roll, section 15 of the RP Act 1950.
Registered in some, what you call constituency, that is it.
No, that is for the purpose of contesting.
Yes.
This judgment also, Kuldeep Nair's judgment explains the very same proposition of law, saying that one need not be registered in the very same constituency for the purpose of contesting. But for the purpose of being a voter, he has to be registered in the constituency. That's the proposition, para number 213 and 214. No, there is one more.
Nothing but common sense, huh?
Not
obviously.
There's one more, only one sentence I wanted to place. It's just last sentence of para number 213. I will read it, my lord. That's also another. 4 lines from the bottom at page 90, para 213. Electoral rolls are prepared basically for assembly constituencies and revised every year. My lords have got page 90.
Just on.
The last sentence, a conjoint reading, just three lines from bottom.
Yes.
A conjoint reading of sections 17, 18, 19 and 20 shows that a person can get himself registered as voter once in only one assembly constituency, which must be the one within which he is an ordinary resident.
Yes,
And next is, my lords, the definition of what is the meaning of ordinary resident.
yes.
In this case, my lords, there is nothing to show that these four persons could be now deemed to be an ordinary resident of another town when their names are already in the electoral list of a different constituency.
Yes.
That paragraph number 214, 215.
Yeah, that may not be, yes, yes.
Malad, my humble submission, Malad. With regard to this, the prayer, I will take, Malad, kindly see the page number, Malad. 11 of the petition copy.
11, no?
Page number 11 of the petition.
11 is the
Para number 18 onwards, prayer of the petitioner.
Yes.
Malad, the prayer of the petitioner above named.
Page 9.
Humbly, sir,
Page 9.
Page 9.
The
prayer of the petitioner, the issue writ of mandamus to the respondent number 2, the regional commissioner Belagavi, to immediately consider the letter bearing number so and so forwarded by the respondent. Number 4, Commissioner Vijaypura City Corporation, wide annexure E. And annexure E is a request letter by the petitioner to consideration. The annexure E, I will take page number 36, Malad. Dated 24/12/2020, Malad.
annexure?
Annexure E. Annexure E is a letter between the correspondencing by the petitioner by the Commissioner of City Corporation Vijaypura addressing letter to the regional commissioner. Subject ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ 22ನೇ ಅವಧಿಗಾಗಿ ಮಹಾಪೌರ ಉಪ ಮಹಾಪೌರ ಮತ್ತು ವಿಧವಿಧ 4 ಸ್ಥಾಯಿ ಸಮಿತಿಯ ಸದಸ್ಯಗಳ ಚುನಾವಣೆಗೆ ದಿನಾಂಕವನ್ನು ನಿಗದಿಪಡಿಸುವ ಕುರಿತು. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ 21ನೇ ಅವಧಿಯ ಮಹಾಪೌರ ಮತ್ತು ಉಪ ಮಹಾಪೌರ ಚುನಾವಣೆಯ ದಿನಾಂಕ 9/1/24 ಜರುಗಿದ್ದು, ಇವರ ಅಧಿಕಾರ ಅವಧಿಯು ದಿನಾಂಕ 8/1/2025 ಮುಕ್ತಾಯಗೊಳ್ಳಲಿದ್ದು, ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ 22ನೇ ಅವಧಿಗಾಗಿ ಮಹಾಪೌರ ಉಪ ಮಹಾಪೌರ ಮತ್ತು ವಿಧವಿಧ 4 ಸ್ಥಾಯಿ ಸಮಿತಿ ಸದಸ್ಯರುಗಳ ಚುನಾವಣೆ ನಡೆಸಲು ದಿನಾಂಕವನ್ನು ನಿಗದಿಪಡಿಸಲಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಪಾಲಿಕೆ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಚುನಾಯಿತ ಸದಸ್ಯರುಗಳ ಮತ್ತು ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆಯ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಬರುವ ಲೋಕಸಭಾ ಸದಸ್ಯರು, ವಿಧಾನಸಭಾ ಸದಸ್ಯರು ಮತ್ತು ವಿಜಯಪುರ ನಗರದಲ್ಲಿ ವಾಸವಾಗಿರುವ ವಿಧಾನ ಪರಿಷತ್ ಸದಸ್ಯರುಗಳ ಮತದಾರ ಪಟ್ಟಿ ವಿತರಣೆಯನ್ನು ತಹಸೀಲ್ದಾರ್ ವಿಜಯಪುರ ಅವರು ನೀಡಿರುತ್ತಾರೆ. ಪ್ರಯುಕ್ತ ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ 22ನೆಯ ಅವಧಿಗಾಗಿ ಮಹಾಪೌರ ಉಪ ಮಹಾಪೌರ ಮತ್ತು ವಿಧವಿಧ 4 ಸ್ಥಾಯಿ ಸಮಿತಿ ಸದಸ್ಯರ ಚುನಾವಣೆ ಜರುಗಿಸುವ ಕುರಿತು ಪಾಲಿಕೆಯಲ್ಲಿ ಪಕ್ಷಗಳ ಬಲಾಬಲ ಮತ್ತು ಮತದಾರರ ಪಟ್ಟಿಯನ್ನು ದೃಢೀಕರಿಸಿ ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿ ಮಾನ್ಯರ ಆಹ್ವಾನಿಗಾಗಿ ಸದರಪಡಿಸಲಾಗಿದೆ. Malad, in this case, only the requesting for the considerations to issue the election date of events. So that was considered by the regional commissioner, which is we have brought it to your lordship by already submitted the doc. And so the 27th is a declared elections as of now. So now coming to, with regard to the voter list is disputed by the petitioner in this.
Where is the calendar of events?
Malad?
Calendar of
Submitted
events?
before you. That is on the last occasions only.
Calendar of events is published?
Yes, Malad. That is on 7/8. 8/1 is calendar of event is published. Submitted to this honorable court.
If I'm not wrong, my lord, the copy is not given to me, but I have produced a document at document number 8. If that is dated 8/1/2025 with my
7/1/25.
Submitted ballot, this, that 27/1/2025 by 1 o'clock, this Sabangana.
The calendar of events ilide.
This it's paper, ನಮ್ಮ ಕೊಟ್ಟಿದ್ದೀನಿ. Same, submit ಮಾಡಿ. ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆ ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ 22ನೇ ಅವಧಿಗೆ ಮಹಾಪೌರ ಮತ್ತು ಮಹಾಸ್ಥಾನಗಳ ಅಭ್ಯರ್ಥಿಗಳ ಚುನಾಯಿತ ಕುರಿತು ಚುನಾವಣೆ ದಿನಾಂಕವನ್ನು ನಿಗದಿಪಡಿಸಿದ ದಿನಾಂಕ ಮತ್ತು ಸಮಯ, ಚುನಾವಣೆ ನಡೆಯಲಿರುವ ಸ್ಥಳ ಮತ್ತು 22ನೇ ಅವಧಿಗೆ ಮೀಸಲಾತಿ ವಿವರ, ಮಹಾಪೌರ ಉಪಮಹಾಪೌರ ಹಿಂದುಳಿದ ವರ್ಗ ಎ ಸಾಮಾನ್ಯ ಮಹಿಳೆ ದಿನಾಂಕ 27/1/2025 ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆಗೆ, ಚುನಾವಣೆಯ ವೇಳಾಪಟ್ಟಿ ಸಮಯ 27/1/2025 ಮುಂಜಾನೆ 9 ಗಂಟೆಯಿಂದ 11 ಗಂಟೆವರೆಗೆ ಮಹಾಪೌರ ಮತ್ತು ಉಪಮಹಾಪೌರ ಸ್ಥಾನಗಳಿಗೆ ನಾಮಪತ್ರ ಸ್ವೀಕರಿಸುವುದು. ದಿಸ್ ಮಧ್ಯಾಹ್ನ 1 ಗಂಟೆಗೆ ಮಹಾಪೌರ ಉಪಮಹಾಪೌರ ಹಾಜರಾತಿ, ಕೋರಂ ಪರಿಶೀಲನೆ, ಮಹಾಪೌರ ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣೆ, ನಾಮಪತ್ರ ಪರಿಶೀಲನೆ, ಕ್ರಮಬದ್ಧ ನಾಮಪತ್ರ ಘೋಷಣೆ, ಉಮೇದಾರಿಕೆಯನ್ನು ಹಿಂತೆಗೆದುಕೊಳ್ಳುವಿಕೆ, ಉಮೇದಾರರನ್ನು ಪಟ್ಟಿ, ಅವಿರೋಧ ಆಯ್ಕೆಯಾದ ಫಲಿತಾಂಶ ಘೋಷಣೆ, ಅಭ್ಯರ್ಥಿಯ ಒಬ್ಬರಿಗಿಂತ ಹೆಚ್ಚು ಇದ್ದಲ್ಲಿ ಕೈ ಎತ್ತುವ ಮೂಲಕ ಮತದಾನ, ಪರವಾಗಿ ಕೈ ಎತ್ತಿದ ಸದಸ್ಯರ ಸಹಿ ಪಡೆಯುವುದು, ವಿರೋಧವಾಗಿ ಕೈ ಎತ್ತಿದ ಸದಸ್ಯರನ್ನು ಪಡೆಯುವುದು, ತಟಸ್ಥ. So the calendar of events for the elections 27 is declared, my lord. Now coming to the voter list issue is concerned, my lord, how I am going to be issued this calendar of, the voter list concerned. First, the preparations is provides under the Representation of the People Act 1950. It gives powers for the concerned as per the hierarchy to the concerned Deputy Commissioner and Tahsildar of the concerned district. Section 30, 13A, 15. And the voter list also it's a declared manner, the same, that is on. This calendar of event before, after that, the.
Oh, please tell us, once the calendar of events is finalized.
Please, my lord.
Once the calendar of events is finalized.
Please, my lord.
And a letter correspondence is made as per Annexure E.
Please, my lord.
What is the procedure for updating the calendar, the voters list? Is there any provision for making additions or deletions in the voters list?
My lord, it is not there, my lord. So there is no deletion. My lord, there is a provision, Rule 6 of the Representative Act, deletions for modification.
Let me understand your case. Annexure E nalli, there is a voters list.
My lord, voter list is how I am going to be. My lord, see, this is the date given on 24/1/2024 list. The date of the requisition letter given by Annexure E, that is 24/12/2024.
Yes.
My lord, for me to be preparation of the voter list is a deadline as on 1/1/2025. I need to be consideration who are all staying in particular area.
Where is that?
That is notification, my lord. One copy. So dated 28. No, you just quoted. Just.
Kudu again, kudu.
ಅದಲ್ಲ ಈ ತರ ಒಂದು ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಇದು ಕಾಪಿ ಕೊಡಿ ಇರಲಿ. Well, this is 28 August 2024. The Election Commission of India. Direct, with regard to the subject, special summary for the revision of the last part of election rolls relating to the service voters with the reference 1/1/2025. The qualified date as on the state UT except Haryana, Jharkhand, Maharashtra of so and so regarding. So based on this circular, my lord, we have been prepared on 2000. You must copy that. Based on this, my lord, the elections voter list has been declared by the Regional Commissioner, my lord, that is on that is on 7/1/2025, my lord.
Hmm.
So after the voter list declared, my lord, the elections is declared.
Yes.
My lord, if anything voter list is there going to be dispute, there is a provisions before the deputy commissioner. They have to be making, I will take the
But where is the voters list which includes the names of these four members? Where
That
is
is
the
on
vote?
7/1/2024, my lord.
It is there.
It is submitted already, my lord. ಇದು one more copy ಇದೆ. ಈ date ಅಲ್ಲಿ. 7. Members name ಏನಿದೆಲ್ಲ? Members name ಏನಿದೆ? ಅಲ್ಲ 11 ಅಲ್ಲಿ. The serial number 1 to 11 is there, my lord. The four members, his names is included.
ಎಲ್ಲಿದೆ?
Okay. 7 members, 1 to 7, my lord. ಚುನಾಯಿತ ಸದಸ್ಯರುಗಳ ಹೆಸರು ಸೆಕೆಂಡ್ ಪಾರದಲ್ಲಿ, my lord. Number 1, ಆಸಿಫ್ ಇಕ್ಬಾಲ್, ರೈಸಮ್ ಶಾನೆವಾಲೆ.
ಅದಲ್ಲ ಅದಕ್ಕೆ ಮೇಲ್ಕ್ ಬನ್ನಿ. ಜಗದೇವ್ ಗುತ್ತೇದಾರು, ವಸಂತ್ ಕುಮಾರ್, ಬಿಲ್ಕಿಸ್ ಬಾನು, who's the other one? ತಿಪ್ಪಣ್ಣಪ್ಪ ಕಮಕ್ನೂರ.
Please, my lord.
ಹಾ.
So their name also included and final list has been issued.
Yes.
To issue this, my lord, what is the powers for the regional commissioner? He has based on the voter list given by the commissioner of the city corporation, Bijapur. So how he is also issued in the representations of the people act, kindly see the section 13, my lord.
AG, ನನಗೆ I'm getting confused. 24/12/2024 is some letter addressed by the city corporation to the regional commissioner. Correct?
Agreed, my lord.
ಇದ್ರೊಳಗೆ ಯಾವ್ದು ವೋಟರ್ಸ್ ಲಿಸ್ಟ್ ಇತ್ತು? ಇದ್ರಲ್ಲಿ ಹೆಸರು ಇರ್ಲಿಲ್ಲ. ಇದ್ರಲ್ಲಿ ಹೆಸರು ಇರ್ಲಿಲ್ಲ.
Yes, correct.
ಅಲ್ವಾ? ಯಾವಾಗ ಬಂತು? When the requisition was received to include the names of these four persons, when was it received?
My lord, before how it is going to be an issue also, I will submit, my lord.
Alright, first, let me understand.
Yes. The particular date I am not aware. When it is included, their name, date is not aware.
But when was, see, 24/12/2024, ಈ 4 ಜನದ ಹೆಸರಿರ್ಲಿಲ್ಲ. 24/12.
ಅಲ್ಲಿ ನನ್ಗದು ಆ ಡೇಟ್ ಅಲ್ಲಿ ಅವ್ರು ಇದ್ರ ಇಲ್ಲ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. I don't want to be false submission before.
ಇಲ್ಲೇ ಇದೆಯಲ್ರಿ 24/12 ಲಿಸ್ಟ್.
That is their version, but I had to get the instruction from the concerned officer. It is a petitioner contention, that is.
Petitioner contention ಅಲ್ಲ.
It is not there, but I would get to the correct information whether when date has been the electrical road has been inserted in this the particular date also.
24/12/2024 is some communication by the Vijaypura City Corporation to the regional commissioner.
Yes.
Enclosing therewith a copy of the voters list. Correct?
Correct.
That list did not contain the names of these four persons.
That is a contention, particularly that name there or not, I am not sure about that. I don't want to be. That is their contention, but I should know that through the commissioner, my lord. That is only the prayer.
Yes.
I don't want to be say false also.
List not enclosed, my lords. Voter list was not enclosed, my lords.
ಆಯ್ತು, ಇವಾಗ ಇದ್ರಲ್ಲಿ ಇದೆಯಲ್ಲ, ಇದೆಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ.
Annexure B.
Annexure B is the voters list.
My
Annexure B ನೋಡ್ರಿ.
Page 28.
Page 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. 28. Annexure B ನೋಡಿ,
Please. Malad, Annexure B is concerned, ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆ ಚುನಾಯಿತ ಗೌರವಾನ್ವಿತ ಸದಸ್ಯರ ವಿವರ ಬಂದ.
ಅದ್ರ ಮೇಲೆ ನೋಡಿ.
35
ಮೇಲೆ
35.
These are the elected members of the council. These are the councillors' name. ಅದ್ರ ಮೇಲ್ಗಡೆ ಇದೆ ನೋಡಿ.
Malad, see how these are preparations, lordship permit me, I will take 1 minute time. Malad, even the last date for the commissioner to prepare the voter list, not on the date of 24/12/2024. It can be by the commissioners is a powers, the as on 1/1/2025 till that, as per the notification of the central government, the overall before declaring an election, overall declaring a election, before declaring the elections, all the persons, who, people representative persons can be at least, if they made an application, they can also consider as a voter in particular area. Malad, for every year, for example, I will take that 17 years by, so is going to be, he is going to be a citizen of India by January 10th of 2025. So if the elections comes, in the date, what the commencement of the date is going to be every year is going to be considered 1st January or 1st January. In the month of January, they have to be declared voter list. So then only the voter list going to be a preparation. The date of, in the People Representative Act also, it is provides for the provision. I will take the section 13, Malad, so that I will, the relevant paragraphs.
Section 13 of what?
Section 13, Representation of the People Act 1950.
Yes, please.
Section 13, Malad, the procedures order in delimiting constitution. Section 13A is important. The chief electoral officers, there shall be an force for each state in the chief elections officer, so who shall be and such officer of the government of elections commission
Section
may.
13A of what?
13A, Malad, is with regard to the state, the chief elections commissioner. 13A is a district officer of the concerned district.
13A of what? Which province, which law? 13A.
Malad, say this is the Representation of the People Act 1950.
13A ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
Malad? ಯಾವ ಕೊಟ್ರಿ ನಾವು? Representations. Malad, 13A. So district election officer for each district in the state, the election commission shall, in the conclusions with the government of the state, designated or nominated and district elections officer who shall be an officer of the government, provided that the elections commissions may designated and nominated more than one such officer of the district elections commission is satisfied that the function of the office cannot be performed satisfactorily by one officer, where more than one district officers designated or nominated by the district under the provisions of subsection 1. Elections commission shall be in order to be designated or nominated district election officer shall be a specified area in respect of this, such shall be an exercise jurisdiction subject to so and so. Well, 13B is related in the election, this city corporation concerned, Malad. 13B, Electoral registration officer, electoral roll for each preliminary parliamentary constitutions in the state of Jammu and Kashmir in the Union of Territory as not having been legislation assembly shall be prepared under the revised by electoral registration officer who shall such officer of the government or local authority as elections commission may in conclusions with the government of the state in which the constituency is situated, designated and nominated in this behalf of a electoral officer or electoral office, the registration officer may, subject to any prescribed restriction, employ or such persons as he think fit for the preparations of the revised electoral roll as for the constituency. So, my lord, election, the 13C, my lord. Every assistant electoral register officer shall, subject to control of the electoral registration officer, competent to be perform all any other such functions, electrical registration officer. My lord, then coming to the section 15, my lord.
50.
15. Electoral roll for every constituency. For every constituency, there shall be a electoral for roll which shall prepared in accordance with the provisions of this act. Superintendency, directions and control of the election commission. So that election commission is issued the notification as has to be taken as on 1/2025. So, my lord, next coming to my lord, 21, madam, section 21. The preparations and revision of the electoral rolls. Electoral rolls for the each constituency shall be prepared in prescribed manner by reference to the qualified date. Qualified date shall be come into the force immediately upon the final publications in accordance with the rules as made by this act. So qualified date is called 1st January of 2025 concerned about this the particular year. So to preparation of the voter list. My lord, concerned about 23 is the inclusions of the name in the electoral roll. Deletion and inclusion. Section 22 speaks about the correction of the entries in the electoral rolls. 22, I'm reading, my lordship permission.
Yes, please.
If the electoral registration officer for the constituents on an application made by him on own motion, it is satisfied after the each inquiry as think fit that any entries in the electoral rolls of the constituency and is erroneous defective in any particular should be transposed to another place to the roll on the ground that the person is concerned as changed in his place and ordinary residence within the constituency should be deleted on the ground that the person is concerned is dead and has been seized so ordinarily residence in the constituency or he is otherwise not entitled for the registration in the rolls. Electoral registration officer shall subject to the such general and the special directions, if any, may be given by the election commissions on behalf of the amend and transpose of the delete in the entries after the proper verifications on the fact of such manner as may be prescribed, provided that the before taking in any actions on the ground that under class or class B or any actions under class C on the ground that the person is concerned has is ordinary to the residents to the constituency that they otherwise not entitled for the registrations electoral rolls that the constituency electoral registration officer shall give person the concerned a reasonable opportunities of being heard in respect of the actions prepared and taken into the relating to him after prepare verification fact the such manner as may be prescribed. 23 is concerned, Malan, the inclusive of the name in the electoral rolls. So which is important is in this case. The persons who has been named in the not included in the electoral rolls for the constituency may be an apply for the electoral registration office of the inclusive of these names in the
ಏನೇನೋ ಓದ್ತಾ ಇದ್ರಿ ನೀವು.
23, Mother, inclusive of the name of the electoral rolls.
Inclusive ಅಲ್ಲ, inclusion.
Sorry. Inclusion on the
I
name
hope
of
you are
the.
not suffering from dyslexia no ಏನಂತಾರಲ್ಲ. You're simply reading what is not there. Inclusion ಗೆ inclusive ಅಂತೀರಾ. ಓದಿ. ನಿಧಾನಕ್ಕೆ ಓದಿ.
Yes, sir. Any persons whose name is not included in the electoral rolls, the constituency may be an apply to the.
May be ಇಲ್ಲ ಅಲ್ಲಿ. Be ಇಲ್ಲ. May apply.
May apply to. May apply to the electoral registration officers for inclusion of his name in that role.
Yes.
The electoral registration officer shall satisfy that the applicant is entitled to be registered in the electoral rolls, direct his names to be included in there.
Include
Therein
thereof.
after the proper verification of the fact in such manner as may be prescribed.
Yes.
So in this case, Malat, so it has been verified on the basis of applications, it has been included in the electoral roll.
So therefore I'm asking you, first to 24/12/2024 ಒಂದು voters list ಮಾಡಿದ್ರು. Annex B ಪ್ರಕಾರ. When was the request received by the electoral officer to include the names of these 4 people? When was the request made? When was the request received?
So date I am not aware, I will submit it tomorrow morning itself.
Yes, now you please come to the proviso.
Please. Provided that that if the applicant is registered in the electoral rolls of any other constituency, the electoral registration officer shall inform the electoral registration officer of the other constituency, and that the officer shall on the receipt of this information strike out the applicant name from that role after the proper verification of the fact in such manner as
So now,
may be prescribed.
ನಿಮ್ಮ ಪ್ರಕಾರ 7ನೇ ತಾರೀಕು 7th of January 2025 ನೀವು ಇದನ್ನ ಅವ್ರ ಹೆಸರು ಸೇರಿಸಿದ್ರಿ, ಕರೆಕ್ಟಾ? ಸೇರಿಸಿದ್ರಿ ತಾನೆ?
Yes, ma'am.
7th ಸೇರಿಸಿದಿರಿ. Where is the communication to strike off his name from Chincholi, Raichur? Where is the communication?
The communications, I'm getting instructions, and I submit to the court.
Then we'll permit you to vote, but no contest. You can't contest, will permit you to vote.
These persons cannot contest at all. If they are councillors, they can only vote. That's the
they can only vote.
They cannot vote, my lords, because of the reason.
We'll direct them to permit them to vote, but it will be kept separately.
The results cannot be declared then.
Results cannot be declared.
There shall be
But
an
in this
election and
case-
results cannot be declared.
In this case.
May I, my lords, explain a little bit, my lords, what my,
No, that's right.
there's only one fact, my lords, which I wanted to show.
Malad, in this
Section-
case, my prayer is concerned, Malad. So Lordship has may notice that only the directions to be issued the regional commissioner to declare the date of events, it is over now. And now the interim prayer, they are going to say that 2024, the election list has to be considered and this should not be considered.
Can't tamper.
That, Malad.
Once the election process is begun by preparing the electoral roll,
Please, Malad.
can you tamper it? You can tamper it, or you can add, delete, provided there is a procedure.
Malad, in this case, there is no question of tamper, Malad. My lordship is aware the election date, even before that, it's every year, so the date is consideration. Malad, every year is going to be considered the election list, I mean, voter list. Voter list based on that, who has come to the majority of the particular area. For example, this not only members I am saying, that the even ordinary person who have been citizen of the India, who is staying, and if he is completing 17 years, completing is entering into the 18 years where he has got a right to vote on that particular day. Before declaring elections, his right should not be taken away. Therefore, it is going to be declaring in the voter list before declaration of the election. So
Yes,
that,
Mr. Rose,
that is called as the date.
what is it you want to say?
Kindly see, my lords, section 23 of Karnataka Municipal Corporation Act.
Yes.
May I read, minutes? Electoral rolls. The electoral roll of the corporation shall be prepared subject to the superintendent's direction and control of the State Election Commission. For the purpose, my lords, the Tahsildar needs to prepare all the voter list, my lords. Kindly see, my lords, proviso, provided that the electoral roll of the Karnataka Legislative Assembly for the time being in force for such part of a city as included in any ward may be adopted for the purpose of preparation of electoral roll of the corporation of such ward. Further, minutes. Provided further that the electoral roll for such ward of the corporation shall not include any amendment, transposition, inclusion, or deletion of entry made after the last date for making nomination for the election of such ward and before completion of such elections. Before nomination minutes.
Yes. No, that is right. But it appears that, to tamper this or to include names into the electoral roll, these 4 people have been planted, it appears.
The electoral roll registration 1960, kindly see my lord, section 7.
Section 7 of?
7, my lords, Corporation
Karnataka
Act,
Municipal Act.
Karnataka Municipal Corporation Act. Notes the proviso clause D, my lords. The members of a council of a state and state legislative council who are registered as electors within the city.
Yes.
It provides for registration. my
Correct.
lords. All these 4 were, I'm told that, my lords, registered in the month of December 2024, my lords. But as regards and what they are now the Annexure E, my lords. There is no
Annexure B?
enclosure. What they are saying, my lords, now Annexure B is the enclosure of Annexure E, my lords. They have it tomorrow, my lords. I will get the entire file. It appears there is some confusion, my lords, as regards this Annexure E is concerned, my lords.
Yes.
Let's kindly have it tomorrow, my lords. I will get the file.
This tomorrow.
Please note.
On the end of this education matter, serial number 2.
But can I request for, my lords, taking this matter at the earlier hours of the day?
5:42, I've already spent 1 hour more.
ಅಲ್ಲ ನಾಳೆ ಕೇಳ್ತಿದ್ದಾರೆ ಅವರು ಟಾಪ್ ಆಫ್ ದ ಲಿಸ್ಟ್.
ನಾಳೆ ಬರ್ಲಿ ನೋಡೋಣ. ಯಾವ್ದಿದು? ಪಾಸ್ವರ್ಡ್. ಯಾವ್ದು?
It is a matter, your
For you,
lordship.
mister?
Pardon?
Log it, yes.
My colleague
Your lordships, it is a matter wherein your lordships, the petitioner is an engineering student.
Petitioner is an engineering student.
Yes, your lordships. He has appeared till 7th semester, your lordships, and now the respondent university has issued notification as per Annexure C.
Yes.
Granting 2 more opportunities, your lordships. That opportunity has not been extended to the present petitioner, your lordships.
Maybe you belong to another format.
No, your lordships. In fact, the notification clarifies.
Yes. Sudarshan. Why don't you give a copy to him?
We have sorted.
I just notes, minute time, I will.
ತಗೊಳ್ಳಿ, ಓಡಿ.
ನನ್ನ ಬ್ಯಾಗು ಹೋಯ್ತು, ಐ ಆಮ್ ಸಾರಿ. Please. My lord, I inquired with my lord, concerned officer, examination officer. What has been told, my lord, so far as my lord petitioner examination coming in the month of my lord March. Tomorrow, my lord, no hurry in this matter, my lord. Maybe, my lord, Tuesday or Wednesday, I will come back with the details of my lord, student.
As per the timetable at
No, my
next,
lord. Throughout the year, my lord, exam goes on there, my lord, and, based on different notifications.
I will record your statement.
yes.
Yes, my statement may be recorded.
Lord, Mr. M. Sudarshan is directed to accept notice for the respondent number 1. We'll stop. Mr. M. Sudarshan, after securing instructions from the respondent number 1, submits that the examinations
My lord.
supplementary.
My lord, whatever the examination they have
annexure-
sought for direction to the university, it is, my lord,
Your lordships, Annexure C is the notification issued by the university granting permission to the students to clear all the backlog subjects, your lordships.
backlogs, 5th, 6th, 7th semester.
Submits that the
Student of 2010-11, my lord. He is a student of 10-11 academic year. Yes. For those.
when you're still doing engineering.
Yes, your lordships, he is doing engineering. And your lordships, as per that Annexure C, students from the year 98, 99 till your lordships 2014.
Is right, ಇವರೆಲ್ಲ ಏನೇನೋ ಮನ್ಸಿಗೆ ಬಂದಂಗೆ ಮಾಡ್ತಿರ್ತಾರೆ. I don't know. ಏನ್ ಮಾಡಮಾಯ್ತು? Submits that the examination here the backlog subjects of the petitioner is scheduled somewhere during March 2025.
Lordships, I have enclosed C1, that is the timetable, which states that your lordships, it is commencing from 24/1/2025.
No, not for, my lord, this student,
Yeah,
or not
format
for
is-
this batch, my lord, academic
Stop.
year batch.
He therefore submits that there's no urgency, there's no immediate urgency to consider this petition. He seeks time to secure instructions. List
Lord,
out
any education matter day, my lord, next week, any
Thursday.
Thursday, right?
Thursday, no? Thursday.
Please, much.
Your lordship,
Nine
one
of
submission.
Yes,
Serial number 6.
Password was there.
Password matter, my lord.
ಯಾವುದು?
APMC
ನಾಳೆ
matter,
ಯಾಕೆ? ಆಯ್ತಲ್ಲ ಟೈಮ್ ಇನ್ನೆಷ್ಟು ಓಟಿ ಮಾಡೋದು ನಾವು. ಹಾ.
petitioners are seeking for 2 days accommodation, my lord, to discuss among themselves.
ಆಯ್ತು.
Only 2% could bid
ಮಾತಾಡ್ಕೊಳ್ಳಿ.
mother day.
ಯಾವತ್ತು ಬೇಕು ತಗೊಳ್ಳಿ. whichever date.
30th May request.
Yes.
Your lordship, one submission. Serial number 66, your lordship. On last few occasions, the matter could not be reached because it was posted last. Your lordship may kindly have it on 28th at 2:30 or top of the list.
Why?
Your lordship, it is a short matter, your lordship, where,
So,
please, lordship.
ಏನೋ ತುಂಬಾ
I apologize, lordship.
no, if it is of some great value, then we can take it.
I apologize.
What is so
Some,
great? Huh?
Interior order is there.
All interim orders. will be accepted.
obliged. lordship.
And 57 be interim order. Sir,
Madam, 28 ಬರ್ತಾ?
Sir, 57 be interim order.
Madam, 28 and 66, 28. ಇಲ್ಲ. 66. ಇಲ್ಲ ಪ್ರಯಾಗರಾಜ್ ಎಲ್ಲ ಹೊಂಟ್ರಂತವ್ರು.
20 years of ಪಟ್ಟಣ ಮಾಡಿರುತ್ತೆ. 30 ಏನಿದೆ ಅವಸರ ಇದೆ. 9 ಆದ್ಮೇಲೆ. Dam, 1 second bro. 1 second. Dam bro.
13 ಕೊಟ್ಬಿಟ್ರೆ ಮತ್ತೇನ್ ಮಾಡ್ತಾರೆ? 13 ನಿಲ್ ಬಿಡ್ರಿ.
30th ಇರ್ಲಕ್ಕ ಮೇಡಮ್.
13.
30 ಓಕೆ.
ಓಕೆನಾ ಇರ್ತಾರ?
At least ಅವಾಗಾದ್ರೂ ಸ್ಟಾರ್ಟ್. ಹೆಂಗಡೆ ಇರ್ಲ.
ಏನ್ ಇರ್ತಾರೆ?
ಮೇಲ್ಗಡೆ ಕೆಳಗೆ
Hello.